There was no reason why. I think that it really is, you know, like time. And I was hoping it would.
I mean, it's
Figures are.
when the thing that scholarships, this is. They won't. But nobody seemed to apply. You know. They're using pretty good. It's the tough. Have somebody. I know who they are. No, I know. Yeah. No. No. And they have to be really. The fund's not one. See? Yes. I just started. One person. It's not we can have now everybody can spread out. Yeah. So originally, these like like that's just flickering the whole time, so we have to switch. We're gonna get better at it. It's for all, it's fine, but. Flickering was like really. Yeah. I had another. That's right. They're false chasers. I got oh, because I told you. You got this. That's who I could have just texted and said, you know. Cameras. They're mainly just. Okay. I wanted to say about this. Here, there, and plus the front. You'll just, everybody will have it.
They were as- Yeah.
I don't want to have to.
Yeah. No, there's been a long power. But you can move around. Because it does go to camera. It's an awkward side. No.
We're also fulfilling it. You're gonna check, we're checking everything we're supposed to. No, because that, I should use that, they cost about $38. Really? Last. Okay. If he's not representing someone, social security related matter, like you're trying to. Yeah. But if you get that for there, just first, a ball back, I didn't think about that. That's very cool. Ooh, get it on the fall frequency. I keep, because I'm thinking, when you go on and get the other person, without having to go here to the. Oh, yeah. It's all. I want this information because the other side isn't giving it to me and I don't. That should work. That's right. So. Yeah.
I'll check if I get locked out.
Good job.
Probably secure and for.
But let me know what she said, but I would inquire. It doesn't matter. It doesn't matter. So, if that was bad,
So I could keep up.
Yeah, keep me on time, please.
Let's hope the train stops down.
It should be.
And then she was on in players that injured, and then we lost her. That's when I got back. No, it's probably Well, good. I want to say about practice like that's something that when
Okay, everybody, it's 9 o'clock, so we're gonna go ahead and get started. So we can stay on time. Thank you all for attending this year's Family Law Webinar. For you all who don't know me, my name is Andy Cole, and I'm the Pro Bono Coordinator at West Tennessee Legal Services. You all should all have a schedule and a form to complete your CLE. If you can make sure you get that form to us before we leave, you can place it there. You can give it to myself or Katrina over here who pass those out to y'all. That way you can get your CLE credit because we want y'all to have that when we're here. Then lunch will be served. Coffee is supposed to be on its way. I haven't gotten an update on that a little bit. But lunch will be served at 12. And then does anybody have any questions for me before we get started? All right, we'll go ahead and get.
Andy,
Yes.
does everybody need to know where the restrooms are?
Maybe, but I don't know.
The building.
Okay.
The one down here is the closest, just go to it ends and it's on the left. For the women's is on the left, the men's is on the right side.
And also, we do have some snacks up here. We've got granola bars this morning. We do have some chips for people during the breaks, or if you get hungry, come grab them. We've got plenty. But if there's no other questions, I will go ahead and let Chancellor Maroney get started. Like I said, if it doesn't work, just let me know.
All right, well, hope you can hear me okay. I understand there's a camera, so I'm sitting here and you're all over there, so let me know if I need to speak up. And this is my first ever PowerPoint presentation, so I'm gonna just check this, and
They're not working.
that's not working. So the first glitch of the morning. We tested this earlier.
Do you have to point it at the machine?
Oh, it works. Okay.
Well, thanks.
Oh, you gotta put it up there.
Well done. All right, extra credit. So let me just say how much, first of all, this is the first time that I've had a chance to address this body in person. We did this virtually last year. And so it's my first time as Chancellor to speak to you all this way. And I just want to say how much I've appreciated everybody's help going as I go through this transition. It's still new to me. There are still new challenges. It's intimidating, frankly, to think I'm going to come in here and talk to some of you all. It's not exactly a big secret. Family law is not a big part of my practice. Much of any part of my practice before I became Chancellor. So I really need to be taking notes. And if I'm able to finish some things at court today, I'll be back here learning just like you all will. But I do want to say how much I appreciate everybody's cooperation. And professionalism. It's a fascinating area of law, as you know well. It seems like every week I have a case where I say, I thought it couldn't get any worse. This is the worst set of facts I've ever seen. But next week comes, and then there's always something new. And so even though I handled other types of litigation before, even cases were involving whether it's big financial transactions or people with injuries where you would think, oh yeah, that sounds awful. These cases are so emotional and much more so than any other type of litigation. So I appreciate all of you all for what you do to work in this difficult area and serve your clients. So I was told, this is my first PowerPoint, as I said, and when I put this together, it was pretty bland. And I was told by others that you're supposed to dress it up. So I found this blue border. I was also told you're supposed to put funny pictures and cartoons and anecdotes in here. which goes against everything they tell you when you go to the new judges school. They say, no humor, you're not, no one, first of all, you're dealing with serious matters, it's not dignified, and second of all, you're not, everyone's going to laugh at you, but you're really not funny. And so I know in advance, I try to balance that tension by putting some things in here, but I know when you laugh, don't worry, I know I'm not funny. I'm going to talk about some of the changes in the statutes first of all, and then maybe switch over, reverse the order there and talk about some of the things that maybe could help us in Chancery Court as much as anything with the administration thing. So, taking a look at the changes in statutes in the family law area recently. This is 136-6-106 dealing with custody. And as you all know, this is the statute that has a lengthy list of statutory factors that the court is supposed to consider in making determinations of custody. And of course, the threshold factors that are there in the, what I guess I'm calling the preamble, are still there, in as much as we're trying to come up with an arrangement that allows for maximum participation in the life of the child. But this is a new factor that's been added by the legislature, and as you know, it's number 16. So I feel like at some point they're going to keep adding factors here, and it's a good thing they're using numbers and not letters of the alphabet, apparently. But the latest factor they've added for the court to consider is whether or not a parent has failed to pay court-ordered child support for a period of 3 years or more. And so this is just one more thing for you to have in your wheelhouse in bringing these matters to the attention of the court. And I'll just say, by the way, any slide we go through, I've arranged for some questions at the end, but please interrupt me for any slide that I have up here if you want to talk about something that we're addressing. But I don't know if anybody has any thoughts or questions about that, but I just did want to make you aware of this latest addition to the factors. The next change that we made that I've got up here is with the mediation process, and this is a new addition, perhaps COVID inspired, I don't know. It says the court may order mediation between the parties to take place by video conference when appropriate. And of course, during COVID, we all have gotten used to doing things electronically. The seminar is virtual in part. The question I have for you all is, how effective do you think this would be? If you're going to come to the court, because it's an option that the court may order. I've been in mediations, family and otherwise, and I've been in those. I'll put it in from an insurance standpoint, put it that way, because I used to do a lot of injury law. I always found that when the insurance adjuster wasn't there, we never made much progress because they were distracted doing other things. It was when they were forced to interrupt their schedule, come to Jackson, Tennessee, or wherever the case was being mediated, and have to give their full attention to the matter, our percentages of success went way up. So I'm curious what you all think. I know that's a little different situation because I was dealing in those circumstances. You were often dealing with people who were out of state. I'm curious what you think about the effectiveness of video participation in mediation. And I know it's probably going to be a case-by-case basis, but I don't know if anyone has any thoughts on that.
In my experience, I don't think it is as effective for a couple reasons. One, it's you have participants in my mediations, only the parties can be present. And that way they have communication with their attorney. When you have like Zoom mediations, many times they're hiding in the background, and so they're communicating otherwise. They're not as attentive. They also, it's kind of like when people talk through computers, they don't feel the pressure as much as if they were saying it to your face. And so you don't have the ability to have them focused and the pressure of what to experience as if, because what we always say is what you feel here, because they're stressed, what you feel here is gonna be even worse than what you feel in court. Because that person's making your decision, and this one, you're making the decision. And so, for a couple reasons, I personally, when I have cases, I want them to be in person. I know I do Zoom, I have the ability to do it, and I continue to do it, but my rate of success in mediating that case is a lower percentage than if it's in person.
Well, those are good points. I appreciate that, Lisa. And obviously, this is not a mandatory thing. It's just opening the door for an option. So you may have circumstances that are bizarre. For whatever reason, this is something that we need to consider. I will say, I share Lisa's concerns and the concerns that I see on some of your faces, that I share concerns that this is really not the best way to conduct mediation. But there could always be that magic exception, and so it's good to know that it's there, but I'm not encouraging you to come before the court with a rush of requests for video mediation or otherwise. All right, now, the next area that there's been some significant statutory change. I felt this was the time to insert a funny name. So this is Michael Scott, who was never married. I think he did get married by the end of the show, but he struggled with debt, and he thought that all you could do was come out and just talk about it, and that would handle your problem. But he was wrong, and I guess the legislature has decided we need to get more serious about that too. So probably the most significant change that I've seen in the family law area over the last year, insofar as legislative enactments is concerned, are changes with respect to debt. Now, I think when you start looking through this statute closely, you'll see that a lot of the things are not so much changes of what the practice has been, as much as it is codifying and expressly stating some principles that have already been followed to some extent by courts in Tennessee, but this is taking it from a good, solid principle to something that we're required to consider. So this is 36-4-121, which is the statute that, among other things, talks about distribution and division of property. And you see the part that I've bolded so you can look at it. One of the things that the court is responsible for doing is allocating the responsibility for paying marital debt in proportions as the court deems just, based on the factors set forth later in the statute in subpart I. So what is subpart I? Says in allocating responsibility for the payment of marital debt, the court is to consider the following factors: the purpose of the debt, which party incurred the debt, which party benefited from incurring the debt, and which party is best able to repay the debt. So I think the logic of these factors is fairly straightforward, but it is interesting that the legislature has seen fit to go ahead and expressly state these factors. I know that when I first became judge and went to my first judicial conference, they were talking about this. This was last fall. And at that particular conference, I was, drinking water from a fire hose, trying to absorb everything that was coming into play. But this was one of the big items that they were excited about presenting the Domestic Relations Committee, which is one of the committees of the Judicial Conference. This is one of the items they were particularly excited about presenting. And they've been working with legislative staff to get this adopted. And of course, then this spring or after the first of the year in 2022, this change was made. So I don't know if anyone has any particular thoughts about it. And as I say, to some extent, it's codifying some principles that have already been around through case law, but now it's all in one neat place for us to look at. An additional part of that same factor, of that same subpart I, what we were just looking at was I-1 with the factors listed. I-2 references responsibility for payment of unpaid attorney fees and expenses, something I know everyone here is excited to learn about. And of course, as you can see, the court is required to consider those same factors that we had in subpart I in making that determination. But we're also provided expressly these 4 factors to consider: the total amount of the attorney fees and expenses incurred by each party in connection with the proceedings, the total amount of the fees and expenses that were paid by each party relative to the proceedings. And then, of course, whether the fees and expenses are reasonable under the factors set forth in Rule 1.5, which I'm sure you're all familiar with, which I didn't republish here in the presentation, and whether or not the fees and expenses were necessary. And of course, I think you all agree that your fees and expenses are always necessary. But anyway, I don't know if anyone has any thoughts about the changing the factors, at least to the extent they're changed and expressed statutorily. But if you do, I'm happy to hear what you think about it. You may not have questions about it. You may have comments about it and how this particular change may impact your practice or your presentation. But to the extent you weren't aware of that change, I do want to make you aware that that's now with us and part of our presentation. Any thoughts on debt before I go on? All right. Well, another statutory change that's been made, and there's some connection to what I just was talking about here, is with alimony. Now, there are not a lot of great cartoon slides or memes having to do with alimony. It's not a subject that I guess brings a lot of humor to everybody, but I was told I had to have a picture. So the best I could come up with was Billy Idol, alimony. And I know Billy Idol has nothing to do with alimony, except you can't pay alimony until after you've had a white wedding. So, and as I stated, I'm proving the principle that you're really not that funny. All right, but there has been a change also in the alimony statute 36-5-121, and I bolded the part that is new. And this is the statute, of course, referencing alimony in solito. And the new section is, as you can see, and I hate to just read to you, but I want to make sure I point it out and give you an opportunity to absorb it, is that alimony in solito may be awarded for attorney's fees and expenses incurred in connection with these proceedings through the date of the final hearing, as well as any proceedings brought pursuant to Rule 59, motion to alter or amend. And when determining whether fees and expenses are awarded as alimony in solito, the court shall consider the following. And of course, the first factor are the traditional statutory alimony factors that are already set forth in subsection I, which I didn't list here. But then in addition, and this is very similar to the section we just looked at having to do with death, the total amount of attorney's fees and expenses and the total amount of attorney's fees, the total amount of attorney's fees and expenses incurred and the total amount of attorney's fees and expenses which are paid by each party in connection with the proceedings, and also consideration of the factors set forth in Rule 1.5 of the rules of professional conduct. And then once again, obviously, whether or not the fees and expenses are necessary. So,
I have a question about that.
sure.
On the triple I, we pretty much here just don't say anything about our affidavits because we trust each other, I suppose, more than anything else. But one of the large cities to the west of us, apparently they bring in lawyers to testify that, these fees are reasonable and whatever. Are you thinking that maybe we'll have to do that under this? Or is it just a matter of you making that determination? And if somebody brings it up, we'll have to have another hearing.
Well, absent express instruction that a hearing like that is necessary, I don't think that's mandatory. I don't consider it mandatory to go into it in that depth. Now, having said that, I think with any request for attorney's fees and expenses, what's necessary is the other side has to have an opportunity, if it elects, to cross-examine and challenge. And most of my experience here, at least in the domestic cases that I've been involved in, the affidavit has been supplied to the other side. The other side has not. They may not have liked the fact that I awarded attorney fees and expenses against their client, but I haven't really had anyone challenge. Maybe one exception I can think of, where someone said, no, those fees and expenses are unreasonable. Now, for the sake of argument, if that scenario developed, then I think it would be incumbent upon the party that's asking for the fees to put their proof on. I wouldn't require them to bring in experts. I wouldn't bar them from doing that either. But I think they could also probably testify to the sufficiency themselves of why they think their fees and expenses were reasonable and necessary. I think there's maybe a little bit of like the Cold War mutually assured destruction. I don't know that any attorney wants to open the box of starting to challenge the other attorney's fees and expenses. At least I haven't seen that around here. A fairly significant non-domestic case that I've handled recently has had a lot of challenges about fees and expenses. And there have been affidavits upon affidavits in that case, which is, and so it all depends, I think, on the degree to which the other side wants to challenge. But I don't think this, to your point, I don't think III there mandates that we have to have a lengthy evidentiary hearing on the subject of fees and expenses merely by the presence of that. I think the court, in considering it, let's assume it plays out like it typically does, which is one attorney supplies, offers an affidavit for fees and expenses, has shown it to the other side has not raised objections. I think at that point, the court can consider the 1.5 factors without a full-blown presentation on that. I suppose every case has got the potential to develop into something bizarre, so there's always an asterisk to just about everything you encounter in the law. And so I suppose a scenario, I mentioned at the beginning of this, every week I say, I never thought I'd see that, but I've seen it. So I suppose the scenario you described is possible. but I don't think it's mandatory. At least that's not the way I consider it. It's a good question. Anyone else have any thoughts on that? All right. See how we're doing. The next section has to do with orders of protection. And this is, of course, perhaps some might be surprised this wasn't in the statute before, but the times we live in and proper awareness brought to these issues has led to some additional language being put in the petition, in the language for orders of protection, in that, in addition to domestic abuse and stalking and sexual assault, which were already elements for the court to consider when a petition for an order of protection is being sought. We've now had added to that sexual exploitation of a minor, sexual assault, as I mentioned. I think the language before may have said only sexual. I didn't bold. It may have only said assault, and I think it's added sexual assault to that, or human trafficking offenses, and of course, these are heinous acts, and it is appropriate that individuals who've been vulnerable parties who've been the victim of these sort of things now are added to the class of persons who can come forward and seek some relief from the court. Anything else on the statutory changes that we've made? I say that we've made, that you made for your elected representative.
Could I ask a question about petitions for order of protection?
Yes, sir.
Many times those petitions are filled out by the alleged victim. They don't have any legal training, or they don't know exactly what they're putting in there. And then sometimes we're tasked with following up and helping them in court. And this doesn't really relate to this specific
That's okay.
change, but I have had some judges that will not allow any extraneous evidence in there other than what's in the four corners of the document. And then I've had other judges that will allow it in there. The statute says if it's filled out by an individual that they're supposed to be reported, the discretion of the courts because they're not an attorney. So what is your take on that as far as, are you going to limit them to specifically what they alleged in the application for order of protection, or will you allow other evidence to come in?
Well, that's a good question. I think I would take into account, especially when you're talking about pro se petitions, I think I would give some grace there and give some latitude. I understand persons who are filling those forms out, they may not necessarily reference in two ways. One, they may not necessarily reference the fear or apprehension they're put in by virtue of what they've experienced. They may not state that eloquently or sufficiently, and I would give some grace there. And then in terms of what's been alleged, that's a little trickier because you've got due process rights of the party for whom the order of protection is being sought. I'm trying to think of a somewhat recent example I had where there was an incident that occurred, a domestic incident that occurred, and it's somewhat like what you say. The victim didn't adequately describe everything that happened in the incident that happened at her home. But she did sufficiently describe that an incident at her home had occurred, and she had satisfied, in my mind, the need, demonstrated fear and apprehension, so forth, such that a temporary order of protection went down. And in the hearing itself, when it was fleshed out, a better job was done because she had, engaged counsel. A better job was done of demonstrating some of what I may have stated something wrong about the facts of that case. I think I didn't order. Well, anyway, it doesn't matter. It's not relative to your question. I may have been crossing two cases in my mind, but the case, to your point, in the hearing itself, there were some additional facts brought out about the nature of what happened in the domestic incident. And I think that's fine. I think that was appropriate. And my memory's not failing me again. I think we did issue, I did put down an order of protection against the offender. Because it all arose out of the same transaction, out of the same event. Now, if there's I can see a scenario where someone could allege a particular domestic incident, and the party against whom the order is being sought comes prepared to address that. And just playing out your hypothetical here, if the facts didn't really bear out with respect to what happened in that incident, and the victim then tried to raise a wholly separate incident that had occurred at another time, particularly if it was in the more remote past, I think that creates a different situation. So I'm not sure if I'm answering your question.
Yes, I have seen them with as simple as a line about he constantly harasses and you know, beats on it, but without any specific dates, times, or whatever. And then generally in these situations, the questions come up about historical data. Well, that's not relevant to this specific, but it does show this pattern that's been going on for years and years. So I haven't had the opportunity to have a word text hearing, so I'm kind of trying to flesh out what, you know, what might be allowed and what might not be.
Well, it's a problem. What you say goes beyond order protections. Pro se pleadings and complaints generally is something that's challenging in domestic practice. None of those pro se litigants are here attending a seminar, hopefully getting better tips on how to handle things.
If we see them and they're insufficient, filed and amended, you know, there's more facts in there, but because of the short time constraints and from the time it's filed until the hearing must be heard, sometimes we don't hear about them until the day and the hearing's tomorrow. You know, that's time to,
Right. Well, that is a challenge. You're right. Anytime you're dealing with folks, when you're having to take over a case, and this is true in just straight divorce practice too, I've seen that where people are taking over a case that was initiated by a pro se litigant or something. It's a challenge, but I would try to, if I'm answering your question, I would try to give a little grace to the fact that they're lay people and they're trying to do the best they can. But as long as it's sufficiently related that it's not just creating a real due process problem for the person against whom the order is being sought. All right. Well, good question. Any other questions about that? Or any other thing we talked about so far? Well, I'm going to move on to practice tips. And I feel a little silly giving you all practice tips. You're all fine attorneys. So I've retitled this "Things That Help Us in Chancery Court." Maybe that's a better way to put it. And most of you have met my assistant, Sam. Over the last year, she and I have tried to keep a running list of things that help us, that we say, you know, this would be something good to let the attorneys know, or this would be something good that we need to ask the attorneys about. So to the extent any of these are good thoughts, you can give credit to Sam. If they're not, you can blame me. I didn't have a good picture because I did this after hours, and everybody's going, I didn't have a picture of Sam to put up here, so that's the best I could do. Sam is a great assistant for me, and I'm sure most of you have met her and talked with her on the phone. She's done a great job. She is like me. She's a legal assistant who had not worked in domestic practice before she began working in the Chancery Court. And so she's learning a lot also. She was used to fielding a lot of calls from people who were looking for mercy because they hadn't paid their property taxes, or county commissioners, or people like that. And so, she's had to really transition along with me, and she's doing a great job, and I appreciate her help tremendously. So in no particular order, these are some things that may help us, may help you when we're dealing with things in Chancery. And some of these may spur ideas that you have or questions you have, and I'll hopefully save you some time for questions at the end. First, talking about scheduling, that first paragraph, please make sure to advise Sam if an additional motion is added to an already scheduled hearing. Let me give you an example of what I'm talking about. Attorney A schedules a hearing on, say, a motion to modify alimony. I'm just using that as an example. Well, when scheduling is done, as you know, scheduling in Madison County is done through Sam, my assistant. She keeps it on a master book, which then goes to the online calendar. And that's what we're looking at when we're scheduling other matters for that day. By the way, if you're doing this in Henderson County or Chester County, you schedule those with the clerks and masters in those counties, Lee Milam or Keith Fry. We sometimes have a scenario where after the hearing is set, the opposing attorney, or maybe even the initial attorney, now that a hearing date's been set, collectively, they determined this would be a good day to hear all of the other things that we have disagreements on. And so they properly notify each other, and they may, depending on the circumstances, they may even submit a notice of hearing filed with the clerk. The problem is Sam is not the clerk. She doesn't see that. So we may have on our calendar the initial motion that was set, perhaps that was advised to us, it's going to take about 30 minutes. That's what's written on the book. Then as other parties come in to schedule matters, she's writing other things on that day saying, well, we only have this first matter is about 30 minutes, so we've got time for these other matters, not knowing that the attorneys have added 3 or 4 motions to that. And then I'd love to say many days before, but unfortunately more often the night before, when I'm at home reading the file, I'll look at it and say, oh my gosh, this has turned into a real thing. And we've also set 4 or 5 other motions that day. And of course, we don't want to inconvenience everybody involved, make everybody wait. So it will just help us with scheduling it when you add motions to a hearing date, and hearing dates are at a premium. So I'm definitely okay if we found a mutually agreeable date for you and your other attorney, please, by all means, that's fine, but just let us know so we can keep the calendar going. Another thing we've started doing, and some of you have already experienced this, so you know what I'm talking about. Second paragraph. Sam has started contacting attorneys 30 days out from a hearing date. Now she's not doing this if you got a motion for default or something like that. But if it looks like it's going to be a contested matter that's going to take some time, I've asked her to start contacting attorneys 30 days out from that hearing to check the status and confirm that the hearing is ready to proceed. If it is, that's great, and we just keep that there. If it's not, then she's going to schedule a status conference call for us to talk about what's going on. Are we ready? Do we need to move this? What sometimes happens, and you've all, everybody's been in this boat where the day before, the week before, something's happened, a continuance is necessary. And I understand that. I've practiced law for 30 years. I've been there. It happens, and nobody is to be penalized for that. But what I've also seen happen is that sometimes the continuance is asked for at the very last minute, but the circumstances which lead to the continuance have been known to everybody for a while. And the reason that becomes a problem is, this is not a rule or a practice that we're trying to implement to make life harder for you, I promise. It's a practice we're trying to implement to make life better for you. Because as some of you contact us saying, hey, I need an available court date, December 2nd. It's a shame when we have to say, well, you know, we're booked out till March. And then 30 days from now, I get to an all-day hearing and I find out the day before, we need to move that because we've been having some trouble with the expert. Most of the time that didn't happen the day before. And so what we're doing is, what I'm hoping to achieve is that we can free up some more slots, and it actually has worked so far. Where we've been able to free up some slots and find days we didn't think we had to help you all when you've got something. This seemed like a happy medium. I didn't want to do what I know some judges do in other jurisdictions, not necessarily, some perhaps in domestic law, maybe in other things, is to do something at the very beginning, like say you've got to have a scheduling order, something like they do in federal court where there's an automatic scheduling order that goes down very soon after an answer is filed. I want to keep it flexible enough for you, but I also want to put something in place to help you get your hearing dates. Your clients want to be heard, their cases matter to them, you're eager to move them along. Hopefully this will help. It's already helped. I know of a couple of cases where when Sam's made the call, the attorneys have said, yeah, we've been meaning to get together with you on that because the expert is from out of town and it's a counselor and we're having trouble getting the party seen by the counselor. So that case was never going to go. And that's fine, but I'm afraid if we hadn't called, we might not have known in time. And we're calling 30 days out because if we make that call a week before, we might get the same information, but it's too late for most of you who are calling me looking for a hearing date to drop into that slot. I'd love it when we open up a day, if I could call somebody and say, hey, that big trial you've been wanting to have, we can do it tomorrow. But that doesn't work. That's just the way it goes. So hopefully that, some of you may have experienced that. Hopefully you'll find that's helping. Yeah, orders. This is just something, again, some of these are things everybody already does, but just a reminder. If you will, please send your orders to the clerk, not directly to the chancellor. What this really does is help the clerks. Occasionally I'll get a letter in the mail with the order. Being me, and being running around, as Chancellor Butler knows, trying to put out 1,000 fires, sometimes I'll say, okay, I'll review it. I remember the case. It looks appropriate. I'll sign it. But it helps the clerks. The clerks come around and say, what order you signed. So it helps the clerks in handling the administration of their duties because they have things they have to do, responsibilities with the AOC. It helps if you'll send your orders to the clerks. Trust me, they'll get it to me, but then they'll have it on their radar to follow up with me. And to the extent there's a delay in getting any order signed, that's on me, not the clerk. But they're very good about reminding me, you need to get this signed. Chancellor Butler, all those years, and I said, when's he gonna sign that? I apologize.
Well, what they used to do would be to bring a court order from Chester County to me in Madison County.
Yep.
And ask me to sign it, and I would sign it, and then it would never get to Chester County.
Right. Right.
And they would say, well, you know, I'm fixing to drive it down there right now. And I would say, no, I don't believe that. I'm gonna send it myself. So I started sending it myself.
I agree. Yeah, Randy.
This relates, I assume everybody in there's had this same problem. The US mail is forbidden. It's terrible. For example, I kept calling about an order that was submitted in Chester County. I still haven't gotten it in the mail yet. They tell me they mailed it. They did email me a copy of it. You signed it on November 5th. So, I don't know what we do about it. The clerk in Chester County said, I had a courier drop it off there. Then they said they mailed it to your office. And then I guess you sign them and then mail them back to Chester County and then back to us. And it's just taken an extraordinarily long time for us to get the orders. And this because of maintenance.
It is. Well,
And
it's
the clerk in Chester County got quite perturbed with me when I asked her, could she email me a copy? You know, well, I've already put it in the mail. I may see it in January.
Well, that's good to know. I'll say this. I go to Chester County 2 days a month, and I go to on Wednesdays. I go to Henderson County 3 Thursdays a month. With Henderson County, because I'm generally there, not there weekly, but almost weekly, they generally hold orders for me to sign when I get there. In Chester County, because it's sometimes a little more spread out between the times I go, it's not always at even 2-week intervals. Sometimes we try to make it that way, but sometimes it might be the first week and the last week of the month, or, you know, just depending on how the holidays and calendars flow. So, what I try to do when I receive an order from another county via mail, like you said, one of the clerks sends them to me in Madison. I try to sign it. I do. As soon as I'm ready and prepared to sign it, I do, if there's no question about it. What I ask Sam to do is send an electronic copy to the clerk immediately, so they know it's signed, they see it. We then, if I know I'm going there in a week or less, I carry it, because I trust that as being faster than US mail. If I know it's more than a week before I'm going to be in that county again, we do mail it in at that point.
Could you maybe ask the clerk, would they, instead of getting all sideways with us, about asking them to email us a copy? You know, we're trying to
Yeah,
close our cases out and we
we're
want
gonna make a
to,
note of that right now.
and we want to be able to send the client a copy. They, you know, they're constantly calling us and about the board.
Well, and that part of what you're saying, you see that little part in italics, e-filing is coming. This may make a difference. I can't tell you all the mechanics of it. I told you it was enough for me to make this my first PowerPoint. But I spoke with the clerks, I don't know, in the summer, maybe. We've been getting all this feedback that e-filing is coming statewide. It's coming. And so in speaking with the clerks, I said, let's start investigating what we need to do to be ready. Some counties already, some districts already have it, as you know. And part of that is getting the text set up ready. We have the text set up ready. We didn't have it ready in all of our 3 counties. I think we do now. In the interim, while we said, let's get the tech ready, and then we'll work on trying to develop. We were looking at a slow rollout. That's why I haven't said anything about it before now, and I'm not prepared to give you a date or give you rules, but we have been working on trying to develop some of that for a slow rollout. In the meantime, the Supreme Court has very recently, I think within the last month, has sent out a memo to everybody, judges, clerks, saying more or less what we thought is coming, that we need to start a slow roll to get ready for. They more or less told us, this isn't just something that's going to happen one day, it's going to happen. They still haven't given us a date, but they've now put us all on notice. That may be a better thing. It's caused us to say, wait a minute, maybe we need to see what they're looking at. There are many vendors. And maybe we need to see what the Supreme Court has in mind, so we're not doing something inconsistent with their plans that we just have to change again. But I'm sitting especially in a case that's in Davidson County right now. And, as a result, I'm dealing with their e-filing system. I think, other than the obvious hassle that no one likes to learn a new system, I think everyone will like e-filing. It's been very nice for me to be able to sit in my office and pull up anything, any pleading that's in that Davidson County case. I get it instantly. I think we'll like it. It may help alleviate some of what you're talking about. But it's not here, but it's coming. It's about the best I can say, but we'll work on what you've described in the meantime. I think that's good to know. Zip through here, so you're getting close to the end. I can't believe it. Thought I was gonna be up here trying to tell jokes or something. Termination of parental rights. This is important. Excuse me. Mostly ice, it's not gonna go. Please remember, if you have a parental termination case, a court reporter is required. That's, and this is the thing, obviously, for termination of parental rights cases, it goes without, in a contested case, I don't think this is a newsflash to anybody, but even in a default judgment, with a default judgment, I still have to make findings of fact, and I have to make conclusions of law concerning the grounds and the best interest. And you'd be amazed how many times the quote, this isn't really a problem case. Now, there are problem cases that are littered throughout the appellate courts. Even some, if you read the history where you had, for example, a mother whose rights were being terminated and a quote, unknown father. And you can even find cases where the unknown father who was defaulted, the appellate courts review these with a microscope. And there are cases where the party that participated in the litigation was found to have been properly terminated, but the party who didn't even participate, that particular finding is reversed by the appellate courts. They scrutinize these in great detail. Anytime I go to judicial conference, they hammer us with this point that we need a record. So even if it's a default, please provide a court reporter. We'll be glad we did when we have that one case that goes up. Also, as you know, this comes under the heading of termination rights cases, but it applies in other sorts of cases as well. If you're interested in serving as a guardian ad litem in one of those cases, if you're interested in serving as appointed counsel in a termination case, please let me know. I know generally the lawyers that have been doing that type of work for some time. I inherited all these files and I can see who's been receiving appointments, who evidently is willing to take on that type of work. I don't want to overlook anyone. If that's something you want to do, please let Sam or myself know so we can make sure to include you in the rotation of attorneys that we reach out to for those sorts of cases. This one, saving the best for last, I guess. This is one I want to really make sure we discuss and remind about. And this has to do with ex parte injunctive relief. This is a portion of Rule 65.03 that deals with ex parte relief. All of you know what's necessary to get injunctive relief. That's not really a shock. And what you see up there in paragraph 1A about the necessity of showing immediate and irreparable injury, loss, or damage, I don't think that surprises anyone. But the rule does say that I can only issue ex parte relief only if the applicant's attorney or the pro se applicant certifies in writing efforts made to give notice and the reasons why it should not be required. That's something that I've been trying to remind people about. And it doesn't require a great lengthy dissertation, but I need something in there that says, or whatever the reason, whatever the circumstances are, the respondent, is a danger to the child if we're concerned that he may or she may try to flee the jurisdiction with the child. Give me something to hang my hat on, because the rule says I can only give ex parte relief if that certification exists. I'm aware of 6507, which provides some exceptions with respect to domestic cases. And it says, as you see, that in domestic cases, y'all, I'm sorry. I started to drink that hand sanitizer over there, so a little closer at it. I know that I've got the authority in domestic cases to issue those, that injunctive relief on terms and conditions that exceed certain elements of 65. But I do not, and I haven't seen any authority to tell me otherwise. I do not interpret the broader discretion I have under 6507 in terms of fashioning relief. I don't view that as eliminating the requirement in an ex parte circumstance that I have to have that certification. So it's an extra clause, it's an extra paragraph, but I need something. Because otherwise, to me, I'm reading the rule and it's pretty specific. And I don't think it's a relatively new addition to the rules, but it's not that new. That section was added in 2009. So I really want to stress that I'm asking people to make sure you do that if you want ex parte relief. That's probably one of the biggest things in domestic cases. We get a lot of requests for ex parte relief. And usually I've found that satisfying that requirement is probably something that is a pretty low threshold to meet, but you have to include it. You have to put it in there. Okay. I'm out of funny material or pictures. But I've got a few minutes if there are any questions about anything we've talked about or anything we haven't talked about, but that you've been wanting to ask me about or correct me on. I'm still new.
Well, Chancellor, I don't have a question, but I remember that one of the worst things that you have to deal with is ex parte custody.
Yes.
Upon the filing of the divorce, somebody wants to get the advantage and they want that custody quick. And so I always required that they have to pretty well state some pretty tough facts in the complaint. And then I would possibly grant the temporary custody and then set a hearing within 5 days. I think there's some requirement for an immediate hearing when you're granting ex parte relief like that. And so that seemed to solve a lot of problems. And a lot of times I did not uphold the injunctive relief or the ex parte relief. I canceled when they didn't, you got to bring your proof. If you don't have your proof, then the order's out.
Well, someone who I have a lot of respect for told me that sometimes the pleading is an atomic bomb, but the proof is firecracker.
Right, they fleet an atomic bomb, but prove a firecracker.
That was you.
I could ask a question about that on these restraining orders. And the rule says that without written or oral notice to the adverse party or its attorney. I've had cases where there's attorney on both sides and the other attorney would just all of a sudden, file for a restraining order, ex parte injunctive relief to take the child and wouldn't tell me anything about it, which I guess is allowed by the rule. But what are they going to have to allege to you that would be sufficient to not give the attorney notice? I understand if you're not giving the party notice if they're about to flee the state or whatever, but what about not giving the opposing attorney notice?
I think that's a higher standard Because I do understand if somebody pleads extremely dangerous conditions with an unrepresented party, I get that, but I would guess, I didn't keep statistics, but I think in the first 60 days that I was in this position, I probably heard 3/4 of the ex parte cases I've heard overall. And I guess everybody wanted to see what the new guy was going to do. They have declined greatly, I think, maybe in part because I have tried to hold to a high standard. I do believe, while I believe the rules are there for a reason and there are circumstances that warrant ex parte relief, I'm not immune to that, or I'm not blind to that. I do take seriously consideration of the due process rights of others. And I do take seriously, as Chancellor Butler did before me, I do take seriously the idea that you're only hearing one side of the story. So it does need to be pretty extreme. And I would say in your example with, if there's another attorney involved, I really have serious questions as to why you weren't able to contact the other attorney and at least give them an opportunity to show up here and be heard.
If they ask for that, and they know there's an attorney on the other side, and they don't disclose that to you, would you entertain sanctions against them if,
I think I'd like to reserve that question for when it materializes, but I would hope that wouldn't happen. In my experience in dealing with the domestic bar around West Tennessee has been, it's a pretty, for the most part, it's a collegial group that works well together. I'd like to think that wouldn't happen.
May I add a thought to that though? Here's the problem, and I have no answer for this at all. Here's the problem about notifying the other attorney. If Randy calls me up and says, I'm gonna go and get this restraining order, I have a duty to tell my client. So what's the difference between telling the client and who's pro se or telling me? Because the guy who's gonna head off to Rhode Island with the child is gonna head off whether Randy tells him or me, pro se or with an attorney. And, you know, I wouldn't not call my client, but at the same time, I would be upset if Randy didn't call me. That's a real conundrum.
Yeah, well, you raise a good point. It's a dilemma, and I'm not saying I wouldn't grant one if the other attorney wasn't notified, but I think the point you raise, I think it's a higher standard. I'm saying it's an unbeatable standard. And
In terms of showing the threat,
right,
yeah,
right.
but I think you'd have to put in the certification that you specifically did not notify opposing counsel because of that fact.
Right, because I think I'm closing my screen down here, but because I think that's the lane. I don't have a pointer here, but that's the idea. The idea is give reasons why it. I think I cut off. I think that
It should not.
should not be required. And that's the key. The key is to give some justification. What I
guess
think
under that circumstance, you would say, this person is liable to plead with the child. And if I'm required to tell the attorney has an obligation to tell the person. And then the judge makes the decision, okay, that's reasonable. You don't have to give notice, but.
right.
And then you better have proof when you show up for the hearing.
Sure, make sure it is a bomb, like you said. And I know I gotta stop, I'm running over. Let me just say, overwhelmingly, one reason I wanted to stress that rule, though, the bigger issue I've had has not been the sufficiency of the certification, it's been more the absence of it. So let's just make sure we include it, and I think if we include it, we're going a long way. Thanks, y'all. I'm sorry I went a little over. Appreciate your patience and appreciate all of your service to your clients and how you handle yourself in court. And unfortunately, I've got to go back to court, but I will be back later.
All
Hopefully.
right,
Thank you.
thank you. We have coffee if anybody wants to grab some really quickly. But Doc Reedy, if you want to come on up and get ready to get started. And then y'all can grab some quick coffee while he's on his way down.
Yeah. I like them. Small kids are ready to help her walk. Then,
Didn't see, what they yesterday. Step in, if you like.
Don't say it. You know, it's like, well, I'm saying, and that's nothing, and we had a call the garden girl, I've been buying them.
Bye.
That was my mistake. I didn't realize. I was gonna make these up, sorry, for the first income tax year. Dang. Yeah. Honestly, you know, but I like that was what it was. Hey, Doc, he's gonna want you to be at the coast because of the virtual people. Because of the people that are virtual. Okay. You want to go. I know, I know. Okay.
Because the microphone is right there too, so the people online will take a shot. If it's not my camera, I don't know how much it picks up.
Yeah.
Oh.
Especially because you're in Europe.
That makes sense.
Yeah, that's actually probably a smart idea.
Thank you.
So I don't want it up when they're presenting in front of it, but I'm scared to turn the PowerPoint or turn the thing off.
Probably how you get that. Like, I don't want the Zoom, like, y'all look like it's itself on the screen. So I'm scared to turn it on. Well, yeah, I'm not. Okay, because I came in. All right, everybody, we're gonna go ahead and get started. Next up, we have Dr. Reedy, and he will present here in a minute. Like we have a break after this, so.
Yeah, I'm sorry about that, right? No, you're sorry. Well, really, I was, because I hadn't sent you anything, we hadn't talked in years, and I said you weren't like that. She had me cool. Hey, man, honest. She got me for a long time.
Yeah.
I thought, and I thought because of that, I believe.
You ready?
I'm ready.
Okay, right, we'll go ahead and get started.
Okay, I guess we're starting the next presentation, which is mine. First of all, I want to thank Mayor Joe for inviting me to do this, and she invited me one day, and so I said, well, yeah, okay, I'll do that, and then that night I reflected on what I had done, and my life flashed before my eyes. Like, I'm going to go into a room with attorneys and chancellors and who knows what, and why would I want to do something like that? You know, question myself. But then I started, I said, okay, let me reflect back a little bit on my history with attorneys in Jackson. I was married down in Jackson. And my first close encounter of the first kind with an attorney was, I hope you remember this gentleman, Jim Diamond.
Yeah.
Remember Jim?
Yes.
Some of you do. I was being rushed by a fraternity at Union. By the way, at Union where I was an honor student, I was always saying, yes, your honor, no, your honor, never again, your honor, you know. But anyway, Jim Diamond was an alumnus of our fraternity. He came to speak to those being rushed. I remember he wore a either black or dark blue pinstripe suit, he had a vest, shiny, really shiny shoes. And he gave me some advice. It was awesome advice that night when he spoke to us. And he said, while you're here at Union, work, study like hell. 5 o'clock. And after 5 o'clock, play like hell. Now, obviously that advice has stuck with me. I still remember that. And now I might have confused that advice a little bit, because the way I interpreted that was, never let classes interfere with your education. And I'm sure that's what he meant. I miss it. Occasionally he would come to our house and just hang out and talk with us too. But that was my first encounter. And I've had many encounters over the years. I'll tell you this, I think, as many of the therapists and counselors across West Tennessee, we still have trouble sometimes when they introduce us as an expert witness. We still have trouble with that, because we know in our particular profession, experts are dime a dozen. So much of the research is still not solid and valid, and all these social issues and studies that come out. And for me, my dad right now, would, not just spin in his grave, he'd probably climb out if he knew his son was being called an expert. Because this is a guy like, well, I remember in the 5th grade, I used to give my report cards to my friends so they could scare their parents. I mean, in the 1st grade, I was not like all the rest of them in the 1st grade, you know, I was 11. So I've never been the brightest person, and now I'm called an expert. And so I've always flinched a little bit. I mean, that's serious. I flinched, okay, expert. I'm going to offer my opinions and my knowledge, and even what I'm going to tell you today about helping attorneys be well is based on research. So I can offer that. And then again, when Mary Jo asked me that, I thought, well, why is she saying that maybe attorneys and the legal system of professionals in general, why do they need some coaching a little bit on how to be well? Okay. So I did a little research. Okay. And there was a study done, commissioned by the American Bar Association from 2019 to 2021. And this will be the only facts I'm going to offer you today. But right now, 28% of attorneys report mild to severe depression. 28%. Mild to severe depression. 19% mild or high levels of anxiety. 61% anxiety at some point in their career. 11.5% report having suicide thoughts. This is in that study 2019 to 2021. 11.5% have suicide thoughts. How do they deal with some of these things? Well, 15.7% use sedatives. 10.2% use marijuana. 5.6% use opioids of some sort. 4.8% use stimulants of some sort. And 20.6% report signs of problematic consumption of alcohol. So we have obviously a very high stress population, choosing some ways to deal with that sometimes will make things even worse. Treating depression with alcohol is literally pouring gasoline on fire. Alcohol is a depressant. It will make you depressed. And when you use it chronically to treat chronic depression, you're guaranteeing that your depression is going to worsen. And then if you try to come and treat that with an antidepressant, Prozac, Zoloft, and any of the SSRIs, you are canceling out the effects of the antidepressant if you continue to drink. Doctors will tell someone now, you can take your Prozac and you still have 2 drinks a day. Now, where they get that, I don't know. But you can have 2 drinks a day of alcohol. Over that, it will begin to cancel out the positive effects of an antidepressant. So they're not going to help the person using the alcohol. So dealing with, by the way, the problematic drinkers tend, according to the study, tend to be new, young attorneys. And they classify that as age 25 to 34. Tend to have more of the problematic drinking. Okay? Maybe they get wise over time. I don't know, and they slow it down. But after I read the results of these studies, I said, okay, maybe this is a good idea to talk about how to have well-being, but also how to be well. The things I'm going to suggest today are things that are not just recommended for attorneys. These are recommended for professionals. My profession has no reason to hold anything over anybody. The last study I read for psychiatric, well, We used to call us, psychiatric social workers, now we're clinical social workers. The last study I read, we were number 8 on the list for suicides. My profession. Child psychiatrist, number 4, the last I read. Number 1, we're still trying to figure this out. For years, was dentist. I don't know why. But the ADA is trying to study that still. The American Dental Association, they're trying to study why. Pediatric oncologist, number 2. I think I understand that. Okay. I think I understand. So, professional people in general, I need a lot of coaching on how to be well. My profession is well. So today, what I'm offering you, some ideas. Some of them you already know. I'm sure you do. I'm sure you probably have been to some workshops on stress, for example. Well, I'll offer some of those too, but some of these other ones are more generic. They're not just about practice mindfulness. Now, by the way, I believe in mindfulness. If you don't know anything about mindfulness, I would explore it on computers, get to know more about it. It is being done across the world now as a genuine treatment that is very effective in some studies, more effective than antidepressants and anti-anxiety medication. So yes, I'll be telling you some of those things. But there'll be some other suggestions that are a little bit broader that I hope that you will take to heart. And one of those, right off the bat, is some of this I will put in my language, but it's based on the research. Okay. One thing that professionals need to know in general is don't confuse your career with your life. 2 different things. Should be 2 different things. Your career is what you're choosing to do. Hopefully 8 to maybe 24 hours a day for some people. Okay. That's your career. Your life is not the same thing. This holds true of other professions. Mine, like I said, mine too. Medical profession, okay, same thing. These are choices you're making to spend your lifetime as a professional. It's not your life unless you make it that way. Unless you make it. The research is very firm on that. Is if you don't have some way to separate that, not just physically leaving the office, but in here. You can leave the office physically, but if you take it home with you, you have a limit. So it is your life, unless you personally make it. I say, people have asked me over the years, well, you hear all these problems all day long. You know, you hear the sad stories, and you see children who are abused, and you see teenagers who are abusing drugs constantly. But how do I separate? How do I do? I was not being facetious, but my first answer was, I have no choice. I have children. Our children did not give a flying fortune cookie about what I did all day long. When we got home, they demanded our attention. Thank goodness they demanded our attention. Okay. Well, I say thank goodness until they were teenagers. I've got to tell this story about teenagers. So, well, and I plagiarized because it's actually Mark Twain's story. Mark Twain had a hypothesis about how to deal with teenagers. He said, when a child is born, get a big oaken barrel. Take the top off of that barrel, drill a hole in the side of that barrel. Put the baby in the barrel, put the top on the barrel. Throw some water in there, food in there, and just keep them alive. And then when they become teenagers, plug up that hole. I think he was on to something there. But what I'm saying, our kids didn't care, and I'm thankful that they didn't. And of course, my wife and I, who was in the same line of work, okay, until she retired a couple of years ago. We had to come up with some rules. And one of those was that when we got home, at least 30-minute timeout before we talked to each other. Not, the kids didn't obey that rule, okay? We just didn't, we didn't have, hello, how was your day? Okay. Go to a place, sit down, just kind of diffuse, calm down, but also not talk about our work at home. Now that, let me tell you, I know you know, is hard not to do. It's just to shut off a point of your life, okay? That you spent all day, but also that you were trained to do, that you spent years in school, okay, and more schooling, and continue to go to school. But I'm telling you, it's one of the best little rules that we ever had. Didn't take me long to realize, back in the good old days, we had these devices that were on the wall a lot of the times. And you picked up this thing and I forgot what they were called. Wall phones. And we had other phones. Very quickly, since one of my first jobs in West Tennessee was at a mental health center. Unlisted phone. Unlisted phone. Can't tell you, how much grief that probably saved. Now, okay, what do we do now? With those electronic things carry around with us. By the way, those things we carry around, they are sources of addiction. I'm sure you realize that now, right? Not just with kids, by the way, definitely with kids, okay, with the games they can play on there, the places they can go, they don't need to go on there. Right now in the United States, I know of 5, and these are new ones, 5 psychiatric treatment facilities only for electronic addictions. That's the only thing treated. And that's because about 2-3 years ago, the DSM, our diagnostic manual, finally included electronic addiction as a diagnosis. And once that's done, insurance companies will reimburse once you have a diagnosis, bona fide diagnosis. Now there are freestanding psychiatric facilities treating mostly young people and young adults, but also teenagers for addiction. Because the source is so available, it's right here. Or it's just the iPad, okay, whatever. Those, and one of the things that already being recommended by psychiatrists and doctors, sure, is like, you've got to have holidays from those things. You have got to have holidays. Adults, kids, but especially adults, there's so many examples of the kids. You can live without that phone being on in your hand next to you in the car. Now, a little bit of research. They've determined that people in their cars, when the cell phone goes off with a ringtone, they have no problems ignoring that. Ringtone, they go, well, I get that way. If it is a text, they cannot resist looking. They don't know why yet, but a text has a more powerful message to look at me. Yes, while I'm driving, they delude themselves all the way to the next stop sign. Okay. But they've got to answer. That's why one of those things now there are saying, when you get in the car, put your phone in the back seat. That's one of the reasons. That's one of the reasons. But those possible addictions are so available now. Where at one time I could say unlisted phone number, now I have to say I'm gonna leave my phone in the car when I get home, put it in another room, something. Okay? But all this goes back to what I was saying. You have to carve out a life rather than just your professional. Oh, what else? Another thing that I encourage all professionals to do is do not get cocky. Just don't get cocky. No, that's my term. That didn't come out of the psychiatric journal. Okay. What came out of the psychiatric journal is professions that have the most addictions, depression, anxiety, the professions that do that are the ones who the members of that profession feel like it cannot happen to me. Oh, I know what stress is. I know I need to exercise. I know I need to watch what I eat better. I know I need to practice yoga maybe, or mindfulness, or I know all that. I just don't have time for that stuff. I just don't have time. I'm too busy, and that's not going to affect me in any way. I'm kind of immune to stress. That is called cockiness. Okay? It's called denial. Okay. And it leads to all these things. I mean, not just these, the drug facts and the depression facts, but unhealth. We know stress causes increased hypertension, rapid heart rate, chronic pain. If someone has asthma, stress makes it worse. If they have IBS or irritable bowel syndrome, makes it worse, or it can actually cause IBS. It can make an ulcerated stomach worse. So we know all this, and it's been around for years. I used to spend sometimes a day or two in some factories, corporations right here, doing nothing but a stress workshop for a day and sometimes two. So this is all around us now. But professionals who say, like years ago, not my kid, when it came to drugs, not my kid. Professionals who say, no, I don't have time. Oh, by the way, I'm smart. I know what I'm doing. What they are doing is confusing sometimes IQ or intelligence. They confuse that with wisdom, which are two totally different things. Do you not know someone who has probably got 130 IQ, who is the most stupid person on the face of the earth? I mean, their decisions, like, really? You really did that? You're smarter than that. Wisdom is the intelligent use of your intelligence. So if you have an average IQ, say 100, have an average IQ of 100, but you really know how to use that, that's wisdom. And I know many people with an average IQ who are not only some of the most successful people I know, but some of the happiest, the most contented people I know. And they just have that average IQ. And along with the cockiness and denial, sometimes it is, these things could happen when you're in one of the most highly stressful professions in the nation. One of them. Okay? Some other things that are recommended, little bit. I hate to say to do this, but I know it's factual. One thing they have found recently to help reduce stress. And I know this is true because I heard it on NPR. Well, and they were quoting a study done in the Wall Street Journal. Hey, two sources you can't deny that. They said that someone who's feeling a lot of stress should go in their backyard and dig holes. Now, if you leave here and tell people I said that, I will not. They say that the digging of a hole is a stress reducer. I'm afraid with some attorneys, they might take that a little bit too far. I won't say anything else. I'll say anything else. You know what else is a stress reducer? Chewing gum. Chewing gum. Okay. Don't know what, but it is. It is a stress reducer. Eating a banana. Now that's something about the diet and sugar, blood sugar and stuff like that. But all these little things, eating an apple with peanut butter on it, stress reducer. Don't know. You know what really causes me a lot of concern is who paid for that research? You know, the Apple producers of America, you know, and digging in holes, you know, where did that come from? But I haven't tried that yet, but come spring, maybe I'll try just see what it is. Something else that helps in professions to ward off not just stress, but to be more proactive and being happier, more content. Have a mentor and become a mentor. Any of you mentors right now? Anybody here a mentor right now? Okay. How many of you had mentors when you came into the profession? I had one. He remained in Oklahoma because that's where he taught, and I moved back here. So he was my mentor for years by phone and by letters, and eventually by emails until he passed away. But really, it just really helped. I could get on there on the phone and use all the profanity I wanted to use in describing things. He would match me with it, you know, and then just but reinforce that you got to keep trying. You got to do this, do that. Again, this is not me recommending this. These are the studies that say if you're in a profession, especially when you enter a profession, that you need a mentor, plural mentors. But also work toward being a mentor, give back. One thing, when I study the people who are depressed, one thing that I found when a person is suffering depression, that they become not narcissistic, but egocentric. They just start thinking about only of themselves. And sometimes to get them out of that, one of the therapeutic interventions is to get them involved with helping somebody else. Doing something, move out of your shell. Okay. Move out, and it is proven to help with depression. Okay. So again, if you're a professional, have a mentor, be a mentor, become a mentor. Another thing, again, this is not just a stress reducer, but other than your work, develop a passion for something. Something. I don't know what that something is for you, but there needs to be something that you feel passionate about other than your work. That could be your family, it could be your spouse for sure. It could be a charity. It could be anything you come up with. It could be collective. Anything that is going to take you again away from this maniacal approach to my career and my life with the same thing. Anything that will take you out of that. And one of those things is having a passion. Cooking, for example. I've just started doing that recently. Been cooking with wine for about a year now. Might start adding it to the food. I don't know, I haven't got that far yet, but
Would you bring us?
it can be done. No, but I will go get some wine. We'll just cut to the check. Okay. So what I'm saying is that we are not meant to be only focused in life on one thing. And yet, as a society, we tend to be that way. There's more to us than that. There's more to us than our job, our career. There's more in here that we should be letting out. And people who do that, over time, tend to put their perspective a lot better about their career. So if they still have a career, they're going to still do the best job they can do. But there's something else out here, even to the point of where you can guarantee every day, that during that day, there's something that you really, really look forward to doing. And I hope it's not, having 2 or 3 drinks, okay? But there's something that every day you need to basically kind of reward yourself and say, I look forward. Again, it could be spending time with your kids, okay? Grandkids, I've got grandkids now. Okay, so it's like spending time with them. I look forward to that. I try to play the guitar more now than I used to because I've got more time. Something out there. Sports. Find something to be passionate about. And I say find something, sometimes you don't have to look that far. Just kind of look inside yourself. See that there's something in there that you've always wanted to pursue, wanted to try to do something different. Yeah, this is not just a stress reducer, this is a life enhancer type of thing. And of course, eat well, okay, exercise. Next one, again, research-based. Laugh. Find some way to laugh. Out of the mouths of babes too. I had a 9-year-old boy, this is a couple of years ago, who was being brought to me for anger management. 2 words that I've grown to detest and hate, but anyway, anger management. And I'd only had one session, kind of meet and greet, get to know type thing. And he would have these tremendous tantrums, okay, when he didn't get his way. And little things like that would set him off already. So we have our initial session, he goes away. I think it was like 2 weeks later, he comes back with his parents. He comes into my office and announces to me that he had found a solution. I said, okay. Inside I'm going, oh heck, no, I won't make as much money off this. No. I said, okay, what's your solution? He said, pull out his phone. He said, when I start getting mad, I just start looking at memes. I said, really? What memes do you look at? And he showed me. He just started showing me, and he started laughing. This one and that one. And I said, so instead of getting mad, you just pull out your phone and start looking at memes. He said, sometimes cartoons. Sometimes cartoons. I said, well, okay. You found a fix. You did it. And he had. I only saw him maybe 3 or 4 more times, honestly. He came up with that solution. But it's exactly what I'm talking about. Laugh. You can't be angry and laugh, generally laugh at the same time. Laughter, we know, reduces tension in the body. But I think this is something where I think I do add a little bit to the research. Please learn to laugh at yourself. Please learn. If that's a hard task, hire someone to laugh at you. Unless you have teenagers and they do it pro bono. But it's just, I'm serious though, laugh, don't take life or yourself so serious. It goes back to that being cognizant thing. But find some way to laugh. I guess I'll be honest, I think I'm somewhat addicted to YouTube for rock videos, learning a new riff on the guitar, looking at bloopers and outtakes of all these shows that I grew up watching. And I will sit there and just laugh and laugh. And before I know it, 2 hours are gone. 2 hours are gone. And I have to go out and apologize to my clients who've been waiting for 2 hours. No, I wouldn't do that. But I'm serious about the laughter part. I really am. Find ways to laugh, but never take yourself off that list of laughing at. Because you know you do. Do you ever just do stupid things that you hope nobody saw? Yeah, okay. Laugh at that. Okay? Laugh at that. How are we doing for time? Oh, okay, that has to be long. This next one. You know, Americans are some of the biggest whiners in the world. Would you agree with that? They just like to whine. And one of the things they whine about is, I don't have enough hours in the day. There's not enough time to get all this done. I'm just always too tired because there's not enough time in the day to get all this done. Well, that's bullcorn. That is absolute bullcorn. You are in charge of the clock. You are in charge of your time. There may be many things you're not in charge of, but time is not one of them. You can set your clock. If there's not enough hours in the day, don't blame anybody else but yourself. Now, you look at someone who is still developed ADHD, okay? And so I had the time management thing all my life, okay? You know, I would start things on the weekend and not finish one thing. 5 projects, not finished a thing. Those are the weekends that my wife would create ways for me to go into town. Don't you need to go into the town? Did you check your mail at the office? Because I'll be driving her crazy. Now, I had a little thing called a heart condition, which I still do have, but prevents me from using stimulant medications. I mean, I did try. I did try, and they did help. But my cardiologist said, no, you're not going to do this. You're not going to do this. Okay, so I had to stop those. And with time, most ADHD will subside somewhat in time, most of the time. But the time management was one of my biggest problems. And I used to blame everybody. Till I started studying it and realizing I'm in charge. I'm in charge. I have to make decisions, but I am in charge of my clock. You guys live by the clock and calendars, do you not? You have to. You have to. You not show up into the Chancellor's court on time and something's going to be said or done, okay? But you have paperwork to finish, briefs to file. But when you are off the clock, get off the clock. Not again as a pep talk type thing. This is critical, okay? One of my jobs in a former life was for about a year and a half. I was a Boy Scout executive, and this is sort of weird. I lived in Texas, but I was in a district that was the largest county in Oklahoma. Across the river, one of the smallest counties in Texas. That was my district. Serving Oklahoma and Texas. In those days, there was a certain date each fall that I just hit out. Because that was the Texas OU football game. And I knew I couldn't win. So I went to the woods. Okay, I couldn't find it. Part of that training that I got though, New Jersey for a month. And part of the training was they said, all right, guys, BS at Boy Scouts of America, the volunteer organization. We don't make it without volunteers. Got to have Scoutmasters, Den mothers, Eagle Review Board members, Scout Council members, all have to be volunteers. And they said this in our training. If you get back home, look into your town, and you want to find a volunteer, look for the business person in town. And I just said, really? Because that probably wouldn't have time to add Boy Scouts. No, they will. You don't want to go after the lazy person. The person's got all kinds of time on their hands. They'll tell you no in a heartbeat. I ain't got time for that. Nah, I don't want to do that. You go to the busiest person in town and you do your spiel. They'll go, well, okay, let's see. I guess I can start working that in on Monday nights. And they'll do it. They'll do it. We were taught, find the business person because they'll add one more thing. Okay? What I'm saying is, a professional, someone who wants to really enjoy life, has got to learn to say no. Just no to other people, okay, who want demands on yourself, on your time. It's hard with some people, family, etc. And yet, that is in your realm of possibility to say no. But also say no to yourself. That's the hard part. Maybe no to the new toys that you want to buy. Maybe no to that, just 2 more new cases this month. And I'll have them along the way. We'll be able to get that new house. At what sacrifice that say no? If you just keep saying yes and yes and yes, then you are again blending the same thoughts, career and life. Saying no is an art. You will not know how many times in my office over the years I've recommended a book. Usually it's an adult client. That old book, When I Say No, I Feel Good. I'll say read that book. And come back and we'll talk about it. Sometimes I've even got the book for them and given it to them because they wouldn't get it themselves. And we come back and talk and they'll say, I can't do this. Just say no. Just say no sometimes. Now, that wasn't the way I was raised. That wasn't the way I was raised. If someone asks you something, you say yes. Now, which gender do you think is more prone to do that? Women, more prone still to do that. I can't say no about it. Men tend to be a little bit better about saying no. Sometimes hell no. No, I'm not gonna do that. No, hell no. But honey, hell no. I'm not gonna do that. Women are still being raised to look at the world as a collective. We're all in this together. We need to help each other out. Men are still being raised. Life is a hierarchy. It's a ladder. I've got to keep climbing that ladder, and this person up in the part of the ladder knows more than I do. That means he's better than I am. I've got to keep going. Boys, men still being raised that way. Why do you think men won't stop and ask for directions? Have you ever gone through that experience? Honey, pull over and ask at the service station how to get that on Millie's new house. No, I can find it. Now, what? GPS. I got GPS. But before that, it would be not, I can find that house. Just pull over and I'll go inside, honey, and I'll ask for directions. I got it. I got this. Because if I have to ask for help, someone is above me on that ladder. And not can do that. Cannot do that. Gee, okay. I'm gonna slow down, but I'm gonna say one last thing about being healthy, being well, periodically. I'm not saying every day, every week, and month, but periodically, we all need to sit down and reevaluate what are the most important things in our lives. Hold on. Now, this is another little exercise I will give, even I used it last week on a teenager. Please do this for me. I said, there are many things that are important in life. And I want you to brainstorm between now and the next session. And come back with the top 3 things in your life. And I said that this might, at the beginning of the week, you may list top 3, and then you think about it, move one down. No. Just come back with the top 3. And she kind of looked at me like, okay, crazy long hair therapist, I gotta do this. But she came back, really into the discussion. The reason though that is important is, again, the studies show that people who are consistently battling with depression, sometimes anxiety, because depression also can cause anxiety, but depression is that the most important things in their lives are not there. They're not there. Let's say that they rank family values or just family as being really important, and they're going through a divorce, or their parents are going through a divorce. And all of a sudden, one of the top 3 gone. There is no sense of family now. Our family is totally different now. That's just once. All right. Honestly, suppose somebody says, well, you know what? I'll be honest with you, money. On the top 3. Well, okay, how much money are we talking about? Well, more than I got now. Okay. Are you still working it? So you don't have that right now? No, I don't. Does that bother you? Yes, it does. Are you going to keep striving for it? Yes, I am. But you don't have it now. That is one of the things important in that person's life. Ask people, reevaluate and see, because by the way, these change over time. Sometimes they evolve over time. Sometimes they just change totally over time. Those top 3. But the studies have shown, not just in the United States, these studies were worldwide, and they were longitudinal over decades. They come back and do the same test, they follow up with these people. When a person is denied what they think, not what somebody else thinks, what they think are the most important things in their lives, they're going to be depressed, they're going to be anxious. Sometimes it becomes that downward spiral, so I will use alcohol, treat my depression, or I'll use weed to get my mood up. They make the wrong decisions about, instead of saying, okay, why don't I have these things? Why don't I? What's keeping me from these? Then making decisions based upon why. Are there obstacles? Have I given up on these other things? Although these are the three things that I want the most, you have to look at that. Doing that will, if you reevaluate, as I said, every so often, where are you now in your life with those things that are the most important? And with that, I'm going to shut up and I will ask, let you say, ask, are there any questions? Didn't get it all covered, like I said, I used to do a day or two once we stop things, but questions? Yes, sir.
I heard Ellen, you're talking about NPR.
Yes.
About a year, maybe two ago, I heard really interesting segment on NPR about the use of LSD
Yeah.
with especially older retiring people, talking about helping one to reassess your values. What do you know about those studies?
They're still pretty solid. Now, they are still limited because you just can't get everyone to participate in that.
As Richard Nixon said, but that would be wrong, right?
Well, LSD has worked. Okay, it has worked. Not only that, mushrooms have worked in clinical studies, okay, to help people with severe depression now. And sometimes they're not tried until after all other known treatments are tried, where they offer someone to participate in the study. Most of them are done in California, Colorado, but they are showing promise. They really are. I'm gonna lie to you. Yes.
I have a question about marijuana and the legalization. What effect do you think that has on our urban areas?
What?
Urban areas like DC and New York City and your larger cities. And I say that because I've talked to a couple of people who've been tourists and gone and visited these places, and they've been there before, and they notice how everybody's smoking marijuana.
Yeah, it's going to happen. Tennessee still, I think they rejected medicinal again this last week. And definitely not recreational, but marijuana, especially the marijuana of today. Now remember, in the United States, we can still only do studies on marijuana grown at Ole Miss. Okay, they're outside of Ole Miss. The only place. Yeah. The only place that you could, so what I'm saying is we're limited on studies because that's the only place that we can study marijuana or THC. I'm saying though, it is not a gateway drug. This was proven years ago. Nicotine is more of a gateway drug than marijuana. Nicotine is one of the most powerfully addicting drugs in the world. You ever know someone who's smoking and they quit, they're cold turkey, and they're doing fine for like 2 weeks, 3 weeks, and then boom, I gotta have a cigarette. Nicotine will stay in your fatty cells for 90 days. 90 days in your fatty cells. So it's slowly absorbed as you stop smoking until it finally leaves, and then you crash. It leads more people to doing illegal drugs than many people who do the marijuana. That's all they ever do. They don't graduate. The majority of them don't graduate to cocaine. Okay, they don't. More of a problem, prescription drugs, more than marijuana. Fentanyl, One of my clients, teenage clients, lost her best friend this last year who took one fentanyl and died on the way back from Nashville in the backseat of the car. But I'm saying the weed is going to be eventually, it's going to be here. I wish we knew more studies on what dose of THC is okay, what's not okay, how far do we go with the THC? We're leaving all this experimentation to farmers and growers out there. And I'm still a big believer on it. Let's study this stuff. Let's really study it. So open up government and let us get some more this around the country right now, get some more studies done.
Yeah.
Any other questions? I'm getting ready to go over, but I'll answer them or I will fake it and act like I know the answer. Okay, thank you so much. Appreciate it.
All right, we have a 15-minute break. And then Randy told me that the people and they're trying to clean and set up to the right, correct, Randy? So we need to go to the left if we want to use bathrooms. When we, if we go out the door, but we do have a 15-minute break, so we'll start back at 11:15.
How are you today? Not in pain. No.
Walk around.
That's why you did the same thing I did. If you did it just the way that the thing pops up. Yeah, I'm not sure this chair and my back are gonna be free. It's my, I feel like my back is already kind of got crooked. And I kept trying to find a comfortable spot. It's nice that they move and stuff, but
Yes.
no, there's something,
It's made to be done.
there's something bad. And I agree.
I love the way you want
It's just the necklace. Thank you. One of the many things that my daughter left behind when she moved away, and I thought, well, it's here.
And she's been on.
Hanging out there, you're,
But it's better. Because the quality is. The way it is.
yeah, I go, she is about an inch and a half shorter than I am. And I cannot wear her shoes. That's unfortunate because she has much better shoes than I do. I can't wear the shoes, but a lot of other stuff I
I know you may.
I just now.
You're a little bit closer to it.
That's right. Exactly right. That's another good way to look at it.
Oh, dear.
But you.
I was like,
Years ago.
I can get it.
Oh, wow.
Kids are doing.
We actually do have.
So I don't think that's. They don't.
Now, you put a lamp on, you know, it's outside of your.
I don't already identified it, ready to pull up.
Right now, I'm stringing my practice.
Can I email it to you? That way we can have it on the same. I just sent her the PowerPoint.
That's all. Oh my God. I was trying to see if we could hook.
I'm not there yet.
I was trying to be Christmas.
But, yeah, but my list of cases was shrunk, which is surprising. And I think.
Yeah. Can you hear me now? You can eat it.
All right, everybody, we're gonna go ahead and get started with our next presentation. Stephanie, you can go ahead and get started.
All right, hello, everybody. Can you hear me in the back? Hello, everybody. Can you hear me in the back? Thank you. Thank you. Mr. Sir, in the very back.
I hear you.
Oh, thank you. They always have to have it. Okay, so we're gonna get started this, it's not quite afternoon, is it? It's still morning. I'm Daphne Davidson. I'm Senior Associate Counsel at DHS in Nashville, Office of General Counsel. I oversee the child support program for the state of Tennessee from the legal standpoint. I train our new attorneys, child support attorneys, a couple of times a year in the different JDs, whether it's a district attorney's office or a private contractor, or we have one state office that the Department of Human Services directly supervises, and that's up in East Tennessee, the fourth JD. And I work with policy, legislation, research. People want to say, hey, Daphne, do you have a case on this? Can you send it to me? And I do my best to find that, because I've got a little arsenal of cases and forms and such that I send out to our attorneys across the state. I do a lot of presentations. I've spoken to you all before. It's been a while since I did it in person. Mary Jo, I think it was 2019 when I had that surgery, and I think that's when I was on my little scooter, or I was in on my boot with my boot or something. I don't think it was this location though, was it? No. Somewhere else, I think. Yeah, also. But anyway, so thank you all for having me, first of all. If you ever need something like for case law updates for child support, let me know, because that's what I do quite a bit of in the fall, especially. Also have some ethics PLEs that I present on periodically too. We all try to be ethical, right? Best we can. But today we're going to talk about the guidelines, child support guidelines. And I do believe, I want to say in 2019, I spoke on the guidelines too, if I'm not mistaken. Because that was right before we did a really big change in our child support guidelines. It was the biggest change that we've had since we went from flat rate to income shares. We went to income shares back in January 2005. So this was the biggest change when we made the changes in 2020. So I think when I spoke with you all in December, in person anyway, in December 2019, we were getting through that process. It was a couple of years of working through the new guideline changes, because we had to make some major changes because of federal law changes for all of the states in the United States had to make some changes that were required. And so as a result of that, we decided to go ahead and do a very, very, very thorough review of our guidelines and make other changes that we felt were necessary. So as you all are aware, I'm sure, probably, under state law, we have to do a review every 3 years. Under federal laws, every 4 years. We do those reviews. However, this is the biggest review that we have had. Now, we made some changes in 2020 that went into effect May 2020. And as you recall, what was going on in 2020? Major change, everything shut down. So our GovOps did not get to meet immediately during that time to review our guidelines that were became effective actually Mother's Day weekend in 2020, as a matter of fact. And so when they did get to review the changes that we made within a couple of months of that, they had a few things they wanted to tweak, in particular with regards to the self-support reserve, and I'll talk about that in a little more detail, but also the minimum order that we implemented. We did have either 60 or 65, bless you, 60, 65, and then we changed it to $100 a month minimum order. So I'll talk about that too in some more detail. But here's my contact information. Please feel free to reach out to me at any time. There's my phone number, but also my email. Email is probably the best way to get me, because I probably mentioned this before, but I am a Disney-holic and I'm not getting help for it. That's supposed to be fun. I'm gonna say it again. I'm a Disney-holic and I'm not getting help for it. I've got a bra bunch.
I'm laughing.
Thank you. Thank you. Oh, I love it. So I have been known to be walking around Disney World and still checking emails. So I say that to say emails are the best way to get me, quite frankly. So that's where I was going with all that. So, all right, let's move on in here. Let me ask this then. Who all do we have here in particular? What all, are you all in private practice? Can you private practice? Everyone in private practice that's in here? I'm sorry, legal aid, all right, I did a presentation for legal aid not long ago too, in Smyrna. Were you at that one? Maybe? Smyrna, okay. Everybody else in private practice? Yes, no, maybe? You know, Gilbert lawyers talk a lot. You know, we get paid by the hour, or paid by the word, I'm sorry, paid by the word. We do get paid by the hour too, or some private practice do, but we get paid by the word, so you gotta talk to me. Okay? Don't fall asleep on me. Because I like this to be as interactive as possible. I don't want to just get up here and speak. And am I getting too far away to be able to be heard? Okay. I've been warned not to get too far away, so because my voice isn't carried. Okay, let's just move on in here. There we go. Oops. Just pointed up here, right, Andy?
Where, yeah. Let's see. I'll go on to the next. No.
Nope. Can we stop? Okay. Can you all see that? I can't see it that well. Can you, it is hard to see?
Yeah, for me.
Is it possible to turn the lights down a little bit? No?
So we had to do it this way because some of those are flickering. So if we turned them all off, it would be
Too
pitch
dark.
black. But I'll see if we can turn those down some over there to see. what
I mean, I can see it. It's just kind of hard. Can you all see it? Okay. You got it pulled up? Okay. Okay. Oh, real okay, Andy. I think it's all good. Oh, that's better. I like that. Yay. Yay, Andy. Go Andy. Okay. So these are some of the topics I want to cover today with the guidelines, key points. Self-support reserve. How many of you are familiar with that now? That we've done that for a couple of years. SSR. Thank you, Mary Jo. Incarcerated individuals. That was something that came about as a change regarding from the federal law. Self-insurance, a couple of changes there. Minimum order, that's a new one. And anytime we just explain that a little bit more in more detail about the definition of what that means. Retroactive support, there's a law that came out, it's been a few years now, but there were some changes in the retroactive support. And debt compromise. How many of you use debt compromise? Have you used that at all? All right, we're gonna talk about, do you know what it's about? Let me ask you that, and I'm not trying to put anybody on the spot. I mean, it's just not something we've done a lot of. And it's a fairly, I say it's fairly new, but it's something that hasn't been used a lot. So we'll talk about that too, and some pitfalls of that. All right, so let's jump in here. This is the federal law that set out some changes under CFR that made some changes back in actually January 2017. And I know it took us a long time to get through this child support review, this last really big one, because we have to engage or hire an economist. We have one out of Chancellor out of Colorado. She does this for many different states and does a lot of research into the economic background and studies associated with child support and how it affects everyone, how it affects the parents, how it affects the children, more importantly. But also we had a lot of, it took a while. We had a big, we had a lot of people on the panel. We had private attorneys, we had magistrates, of course, child support personnel, myself, legal aid, or who was legal aid? Your legal aid. We had various people within the state that were experts in this area to be on that panel to do this research. So it did take quite some time. So these are some of the changes that the federal law required us to do. And that is they required all the states to take into consideration the basic subsistence needs of the parents, in particular, the non-custodial parent, but at the state's discretion, the custodial parent. The bottom line on that is the person is dealing with low income people, low income parties, okay? The person needs to be able to take care of their basic subsistence needs before they can be able to take care of their children. I know that maybe sounds backward, you know, your children need to come first, right? However, if they're out on the street, living in a dumpster somewhere or under, you know, the bridge, they're not gonna be able to take care of the kids. Now, this basic substance need, when I say basic, it's basic. It's below minimum wage. It's the federal poverty level. Okay, it's down, that's where we had to research the federal poverty level. So it's very, very basic. There are the federal, can you hear me? Okay, I thought my back was to you. I'm not trying to be. The federal law requires us to take this into account, but what they didn't set out is exactly the means that we had to use. What we ended up falling on, and this is what all the states that I'm aware of are using, that's a self-support reserve, the SSR, and I'll go into more detail with that in a moment. It addresses, the federal law requires us to address how the parents will provide for the child's healthcare needs. Now, in the past, our guidelines said that teen care would not satisfy the requirement for providing healthcare. That has changed. Now it can be public or private insurance. So that was one of the federal changes. Another big change is that the federal law is requiring us not to consider incarceration of a parent to cause them to be voluntarily underemployed, considered to be voluntarily underemployed or unemployed. Remember, our guidelines in the past said, you know, incarceration, you're voluntarily unemployed or underemployed. Okay, when I say underemployed, that's basically after they've been incarcerated, now they come out, they can't get that same job, right, as they had probably before. Especially if they embezzle money from the bank that they were working at, well, they're not getting another job at the bank they were working for, right? So under the old law, it said that we had to say, okay, you're voluntarily underemployed because you did the action that put you where you are, put you in prison. The federal laws required us not to include that, which no longer consider them voluntarily underemployed or unemployed. We need to look at their actual income. So we'll talk about that too. All right, here's the self-support reserve, SSR. So basically, this is a low-income adjustment in the amount of money a parent owing support needs to support him or herself at the minimum level. We'll talk about, we're going to do some worksheets at the very end here, like probably for the last maybe 15 minutes. I think I have an hour total, right? 12, okay. So like the last 15 minutes, we're going to do some worksheets. I am a very visual person. I learn visually much better than someone just talking to me. So to me, it helps to actually look at the worksheets and do some examples, some live examples. So we'll do that and I'll show you how this all fits together. Okay, the SSR, SSR is a part of the BCSO. What is the BCSO? Basic Child Support Obligation. That is considered before any of the other expenses. Like on the second page of the worksheet, it has like health insurance, child care, those expenses. The SSR is prior to that. Also, the SSR, you have to also look at parenting time. So if a parent is getting more, let me see how, make sure I word this correctly. If they're exercising 68 or less days, so if they're not exercising much parenting time, you'll see an SSR that's gonna bump up. And you'll have a little bit more in support to pay because they're not exercising very much parenting time. If they're exercising more than what I consider kind of standard, if they're exercising more than 92 days, they can't get both the SSR benefit and a credit for exercising more parenting time. Again, this will make more sense when you see it in the worksheet. Yes, ma'am.
Will the computer automatically? Oh, thank you.
Yes.
Okay.
Yes. Yeah. I knew where you were going with that. Yes. Yes, and I will show you that on the worksheet as well, where you will be plugging in the basic information and the computer, all these little genies right behind the scene, you know, they're going to do their magic and calculating all this for you, so you don't have to worry about it. Thank goodness. Although I do remember, and all of you who've been practicing for a long time, at least back to 2005, probably remember when we first learned income shares, we had to learn how to do it manually. Thank goodness. I think there are still some judges that do that, actually, but I'm not sure now that since we've had the changes, but they used to. Okay, so here is the statute regarding the incarcerated individuals. So if a party is incarcerated more than, not up to, but more than 180 days, 180 days is approximately 6 months, right? So if they're incarcerated for more than 180 days, Then, what will happen is when the child support office is involved in particular, they send notices out to the parties that, hey, you know, there may be, you may need to have a review for your child support obligation. Okay. If the person's in and out, like 10 days here, 10 days there, no, we're not going to review that typically for modification unless, just depends on the facts, really depends on the facts. But if they're incarcerated, like I said, for more than 180 days, then we want to look at that and review that for a possible modification. Actual income is always used when you deal with an incarcerated person. Don't do minimum wage just because that may be what you've done all these years. Don't do that. Use their actual income. Their actual income is zero, put zero, and I'm going to show you how you want to flip line 15. You already know this, but line 15 from an automated default from an N to a Y for yes for minimum order. That's the kind of situation where you at least want a minimum order, because if you leave it at zero and don't flip that line 15 to a Y, then you're going to have a zero obligation. We don't want a zero obligation. Okay. Some states do that. Some states, when they're incarcerated, they do a zero, or sometimes they'll do a $50 minimum or $60 minimum, various numbers. We have a $100 minimum. Now I can see arguments on both sides, right? We're lawyers. We can argue both sides of everything, right? You know, on the one hand, you've got a parent who did something that caused them to be incarcerated, right? And why are you giving them this benefit? Why are you not keeping their support obligation at $400, $500, $700, whatever it would be, as opposed to a minimum order? Well, the research has shown that when a parent, especially once they come out of prison or jail, if their support, if their arrears are so astronomical, when they come out, they're going to disappear. And working under the table, they're not going to like that wages on it. And working under the table, we won't be able to find them, won't be able to get any support from them, more than likely. If they have a more reasonably set obligation and an arrears balance, they're more likely to continue to pay, and more likely to that relationship between the child. I mean, there may not be an intact family in this situation, obviously they're not, but at least you have a situation where there isn't so much bad blood, hopefully, you know, because somebody is constantly, you know, hey, you haven't paid your child support, hey, you haven't paid your child support, and then they disappear. But we have found with the research that a person is more likely to stay involved in that child's life if they're paying support, at least at a nominal amount, at least at that $100 minimum while they're incarcerated when they come out. Now, it may be that they'll be at a $100 minimum for just a little bit longer until they're back in the workforce. Just depends on the circumstance, depends on where they're working then. And I tell you, we have a lot of resources now in the state to help people find jobs. I mean, we are really looking at the whole family unit, not just, you know, years past. Remember the term we used to hear 20 years ago, especially, long time, Debbie dad, right? We don't hear that anymore. You try not to say that. You try, or Debbie mom. I mean, there are Debbie moms too. But we try not to go there anymore. We want to help the whole family and both parents to be able to have a job, get an education, help them with their resume, help them with a bus pass if that's what they need to get to and from, you know, to that job interview. That's what we want. We want both parents, because both parents have a duty to support their children, right? And both parents need to. So if we can help them do that, we do have a lot of resources that are helping them get that job, maintain that job, and be a better parent overall. Okay, I'm gonna stop preaching on that. Yeah.
Let me get ahead of myself here.
Okay.
Many of our cases that we handle, you know, parties have nothing. And many times, a lot of our cases are granted by default.
Right.
We don't even know where the dad is or whatever, so.
Right.
I know that there's a dollar amount in the guidelines that you plug in for that person. So it says if you don't have any reasonable information as
You talk about imputed income?
yes.
Yes.
About what they're making, to plug that in, well, that's a pretty high dollar amount,
It is.
you know. So is that what we're supposed to do?
Not necessarily.
Okay.
You
We
need to
don't have
look,
any idea what they're making or any, often where they are or any ability to find that out.
and we are gonna talk about imputed income, but let me just go ahead and touch on that right now. You know, hopefully, and I know in your situation, your caseload, you may not, that other parent may not have any information about that parent or any kind of history. If the child support office is involved at all, they can also look at the payment history through clearinghouse to see, you know, if they've had any kind of jobs. You know, it may be very sketchy, but they can get an idea, okay, is it like fast food places or, you know, here and there, what kind of income? And it may be that there's nothing there showing up, it may be a tenant, they're, you know, working under the table. Or they may be a pharmaceutical rep, you know, of some sort. But, you want to look at what kind of, if you notice anything at all about their educational history, did they get a GED? Did they graduate from high school? Did they have anything that kind of post-high school education? Any kind of community college, any kind of training whatsoever? Do you have any of that information? What about the area in which they're living, the kind of jobs available for that type of person, that person's educational or work history? You know, you can impute income to other amounts other than the 43,000 and the 30-something thousand that it changes. So it's like, I used to know these and be able to rattle those numbers off, and now since the change, it's like, what is it now? I tell you, we rarely use those numbers, quite frankly. You have to if you have absolutely nothing else. You know, you're going to end up doing that. What's going to happen is the support obligation is going to be so high. Again, they're not going to be able to pay that based upon their work history or their ability to work. So you want to try to do it as more realistically as possible. Does that answer your question at all?
Yeah,
Sort of,
as long as
maybe?
you know that.
Okay. Well, we'll do some worksheets as well, but yeah, that's one of the things with the guidelines, there's a laundry list of things in the guidelines that say for different things that you look for. Some of the things I just mentioned, their work history, their educational level, and that sort of thing. What kind of, and I know you're talking about defaults where you really don't see the person, but you can see the person, what, you know, do they have a really expensive pair of shoes on? Do they have a lot of tattoos? Do they really spend a lot of money on? Or the fingernails, how much did they pay on those fingernails? I mean, there are different things that you can look at if you see the person. Now, it's a lot different if you don't have any contact. I get that.
Unfortunately, we have a lot, but you
Yeah.
never see them, you don't really know where they are. If you rely on the client's information, they're probably a minimum wage worker, you know, they work at fast food, they don't really work, that kind of thing, you know, so.
And you can impute at minimum wage if that's what you find based upon the facts, if that's what should be done. Okay. All right, let's. Okay, health insurance. Again, I talked about the private, public, you can do either one, whatever is available. What you do want to use though is if the children are on teen care, you want to also have a provision in there. You want to specify that if they're on teen care, that's being covered by teen care, but also have a provision in there that the parents, either one or the other, usually it's a non-custodial or alternative residential parent, will provide insurance when it becomes available at a reasonable cost through their employer. What is a reasonable cost? 5% of their gross income, the children's portion. Okay, that is actually federal law. However, that's another thing we did in the in the Tennessee law. We added that part from federal law, we put it in the TCA code as well. So that it's the definition of what is reasonable cost, and that is the 5%. That's not, like I said, it's not a new law, it's just a new law and putting it in our Tennessee code as opposed to just the federal law. So, and that's the only comes into play when you're talking about when the order says when available at a reasonable cost. If the order actually says that they must provide it, they must provide it unless they get a modification that says, you know, this is just too extreme. I mean, the cost is just enormous. I mean, they just can't afford it. So then you might get a change or modification on that. But you would look at the cost for the child's portion. You have 3 kids, divide it by 3, even if there are other kids. In another case, you want to divide that out by the number of kids that they're covering. Health insurance includes medical, dental, and vision. Most importantly is the medical coverage. If all 3 can be covered, and it's 5%, if it's less than 5%, then put that in there. They need to cover that. If by adding dental and vision bumps it up over the 5%, then they just need to provide the medical. If doing the medical bumps it up over, then they don't have it available at a reasonable cost. Okay? Step parent insurance, that is another change that we made to the guidelines. Yes, ma'am?
Well, here's my question about the eliminating the vision and dental. The state's not gonna do just that, right? You can't get TennCare just for vision and dental.
Probably not.
So,
So you could, they can still have that TennCare for that, but you still want to have them, if they have insurance available for the medical, they need to provide that.
but if they provide that, then they won't have TennCare.
Well, TennCare probably is still gonna cover them for something there. Have you seen that actually happen?
No, I'm just visualizing, you know, the stories after this occurs. Just asking, because you would be more likely to know whether it's come up than you.
I haven't seen it come up with that difference
Okay,
like that. Usually if they are eligible for TennCare covers them.
right.
But the thing is, you need in their order that they need to provide this insurance to their employer if they have it available and it's reasonable. TennCare may still be in there, may still be available until somebody's made aware of it. And that's the problem. A lot of times they don't make them
Well,
aware.
if they're
of it.
supposed to report it.
They're supposed to.
Okay.
I don't think they do, but they're supposed to.
So
So that
can
is a
they
good
be forced to pay the insurance premiums back if they don't report it? There's no
You can
downside.
certainly file something with the court and ask for that, but that's not something I have seen in the law.
Okay,
But you do bring up a good point, and that is something that I'll take a note of that to check with TennCare on. Because to see if they can cover just the dental and the vision, if they're not having to provide the medical, and because the other parent is providing it. That is a good question, but bottom line is I don't really know the answer to that, if they could do the vision and the dental and not the medical. That is a great question, Mary Jo.
thanks.
Yes, ma'am.
If the non-custodian parent, they have and are willing to provide private insurance to their employer, if they live in a different jurisdiction than the child, so their insurance doesn't cover the providers of the child.
Are you talking about maybe like a different state? That used to be a much bigger issue than it is now. I understand that most states, they will allow that. They will still have, they have more coverage even in other states. But that is something you would want them to check into that availability. Because if, you don't want them paying that premium if it's not doing any good, right?
If the child is currently on TennCare and the mother doesn't want the private insurance,
Yeah, 'cause then there's gonna be some out-of-pocket costs.
but he's being told that the providers he sees now won't pay that insurance.
That's something that you do, if that is a fact, and not just them thinking that. Because I have seen a difference in that over the years. That used to be very rapid, that you didn't have good coverage in other states for this state here, or vice versa. But I think that has changed a lot over the years. So what I would want is something in writing that said that, not just a parent saying, well, it's gonna be covered. Because, yeah, the custodial parent probably is wanting them to want to keep the TennCare because they don't have anything out of pocket. But if it's available and it is covered and that other state can cover that child, then that needs to happen. So, good questions. Step parent insurance, that used to be in the guidelines that step parent insurance could not be credited. Now it can. We did that change because that was one of the things I never understood their guidelines, and I asked some that had been on the committees way back when, and I said, no, why is this? Why was step parent insurance specifically excluded? So, well, we had to look at, are we going to use step parent income? No. To me, that's comparing apples to oranges. It's not the same thing. With insurance, you may have a parent of the child in the household that may be self-employed or just may not have very good insurance, but they're married to someone who does. They have great insurance. Okay, it's a great premium. It covers a lot of the expenses. So it helps everyone. It helps the child. It helps both parents, not just one or the other, but it helps both. and having good coverage for that child. So why not include that? So that is a change that we implemented back in 2020. It's, again, it's just a child portion, and it's under that parent, whoever they're married to, that column on page 2 of the worksheet. All right, ooh, that's hard to see, isn't it? Colors. Can you all see that? The minimum order, okay. Okay, well, I guess it's a good thing that I know what it says. I guess. The minimum order. So in Tennessee, we do have a minimum order of $100 now. And there are some exclusions to that. One exclusion is when the person's only source of income is means tested income, such as SSI, supplemental security income. Now, they may have Social Security Disability or SSDI, Social Security Disability, and the difference, I'm sure you all know this, but I'm just gonna throw it out there. Do we have any Social Security attorneys in here? Yay, may pick on you. So SSDI is when they have credits. And you correct me if I'm wrong on any of this, because you're the expert here. If they've worked over the years and they have credits and they've built up Social Security in their work history, then they can get SSD if they become or SSDI. Some can get Social Security disability benefits. When they can get disability benefits, usually the child can get a derivative payment from that benefit that will go directly to the custodial parent. That income, that Social Security disability is income, because it is based upon their work history. So you're going to include that as income. SSI, supplemental security income, is when they really don't have that work history. Okay, they haven't really worked, or maybe they have they do have a disability, but they could be a 20-year-old have SSI. It's be all over the place there. That's when they haven't had that work history, and it's basically to supplement. It's supplemental security income. It's a nominal amount. It's not very much. I don't know what is the minimum amount or what do you typically see now with SSI?
The maximum amount this year for an individual is $840.
841. I remember it was just like what $200-300. I mean, it's pretty low. So 841 is the maximum.
That's the maximum though. That's not the average.
What's the average?
I can't say that on the top of my head. I don't think it's in my materials either.
Oh, are you
Probably
presenting
around
today?
600.
Are you presenting today? What is your name?
Beth Bates.
Beth Bates. I may pick your brain later, if you don't mind.
He's board certified.
He's board, okay. BB, okay, I want to remember that. So you don't want to use a minimum order, do a minimum order when that is your only source of income. Now, a person can receive both. They may have some disability income, but it's that they really don't have a whole lot of credit, so it's just fairly nominal. So they've got this SSI that kind of helps build, close that gap a little bit. Am I saying that right?
Yes, it's very, the low SSDI may be based on the amount of earnings rather than the number of credits. They got the requisite number of credits, but their earnings were
Really low. And so they may get that SSI to kind of give them a little bit of income. So there is a line on the worksheet that is a means tested income line. It's on the first page. And if you're only using the means tested income, you will flip that coming into a Y. And I'm going to show you that on the worksheet as well. That will be a zero order as far as that person will not have an obligation. Now, depending upon the parent income and the other parent's income, it could be the other parent, the PRP could be under an obligation to pay support. Depends on their income. That can be in any circumstance, not just with SSI or that sort of thing. So the minimum order, a lot of times when I will see it is when, what we talked about earlier, with the person being incarcerated and their income is zero, or it may be very nominal and it may have some earnings there when they're incarcerated. So you want that minimum order, or you may have a situation where a parent is maybe in an inpatient facility for like drug treatment or alcohol treatment or whatever it may be, and they can't work while they're in that treatment center. And then you want to at least have that minimum order. So that's when you're going to use that in some of the circumstances there. Another time when you wouldn't use the minimum order, when you would not flip it, is when with the SSD, when they're getting SSDI, and I'm more, again, I'll show you this on the worksheet. Say, for example, I'm gonna say that the dad is disabled and is receiving 1,500 a month or something. Mom is receiving a derivative payment directly from the SSA, Social Security Administration, based upon dad's disability. Okay, it's gonna go under his column because it's his disability, but it goes straight to mom. And I'm gonna say, for example, she's receiving, I'm just picking numbers, $400 a month from as a derivative payment, so it's straight to her. If you plug in all these numbers, his obligation, say, is $300 a month. Okay, she's receiving 400. So that takes care of his obligation. And we won't flip that order to that line 15 to minimum order because you don't want that 100 because that's taking care of his obligation. Because she's getting 400, his obligation is only 300. So I'm going to show you the very last line on the second page where it will show 0 to show what his obligation is, but then she's getting some support through SSA, so he doesn't have an additional obligation. Now, that difference, that $100 that he may have in arrears, that difference does not go to his arrears, it stays with that custodial parent. That's retained by the custodial parent for the benefit of the child. So he would still have payment on the arrears if he has an arrears, okay? Now, you may have a different situation, maybe let's flip those numbers. Let's say, mom was receiving 300 a month, but dad's obligation for whatever the numbers add up, and his obligation is 400. She's getting 300, so he's gonna pay an additional 100, the difference. Does that make sense? It'll make more sense when you see the worksheet. You all probably have worked all this yourselves, but I did have this come up the other day, actually at the legal aid session. And afterwards, someone emailed me and they said, now here's an order that we did a couple years ago. It's already final, but I want to ask you if this is right. They put the Social Security benefit in the wrong column. When they did that, dad had an obligation that he shouldn't have had. Because it was already being satisfied with his Social Security, the rate of the payment. So you have to be really careful about that. Okay. All right. Y'all stop me at any time, question. I know you all have been really good about that, and I want you to ask some questions anytime you have something. Let's see. I think I've already talked about this. Yep, already talked about that. Parenting time. So in the guidelines, what's been in the guidelines and still in the guidelines is talking about what is a day. What is a day of parenting time? Basically, it is when the child spends more than 12 consecutive hours in a 24-hour period under the care, control, and direct supervision of a parent. Okay, that's still the law. And this part in green here was still in the guidelines before, but it wasn't in the same section of the guidelines. So we moved it, put it over in the same area because they went together. So the blue is the general rule. The green is an exception. Okay, so if you have a parent, and there's some case law on this, if you have a parent that in extraordinary circumstances routinely incurred parenting time of shorter duration may be accumulated as a single day for parenting time purposes. An example of that is in some case law when a dad was the ARP, alternate residential parent. He was picking the child up from school 3 afternoons a week at 3 o'clock or whatever time school let out, 3 o'clock, took the child home at 8 o'clock at night to mom's house, 3 afternoons a week. So picked the child up at 3, took care of the extracurricular activities, took care of homework, took care of dinner, everything, for those 5 hours. If you looked under just the blue definition, the definition in blue, he wouldn't have gotten any credit. Well, that's not fair based upon the circumstances here. He was doing that routinely 3 days a week. Now, he shouldn't get 3 days credit because it's not 3 full days. But in that particular case, the judge gave him credit for 1 full day for those accumulated time periods. Does that make sense? Okay, so you may have that in some situations. Okay. Monthly gross income. Man, I can't see. Okay, gifts, inheritance, I think that's what that's talking about. Okay, so these are some things what you see underlined, if you can see that, that was what was changed in the last changes in the guidelines. So gifts were already included, but we kind of expanded upon that, kind of went a little further with it. So one of the things that I used recently in a case I was helping one of the JDs out, he was a brand new attorney. And she got hit with a doozy of a case, worse than any case I've dealt with in 30 years. Now, I've been practicing 30 years. I started when I was 5. Thank you. I gotta laugh, Andy. So yeah, it was the first case I dealt with ever. So, and we had a lot of great issues. I was really actually hoping this would get appealed, and it didn't get appealed. We just got over the 30-day time period, but it wasn't appealed. One of the things that we used was gifts, and like gifts, but also this last part, reducing a parent's living expenses, such as housing. In that particular case, Dad moved after their divorce in 2016. Dad moved to another state, moved to Colorado, living with his parents in a very nice home that he brought up in the discovery and dealing with custody. There's all these other issues going on over the years, and he put a picture of the house from Zillow, the website from Zillow, on there, saying, oh, this is a really nice house. The kids will have their own rooms. It's a 3-bedroom. It has a nice large basement. Anyway, he talked about all that. And so he was paying maybe $300 a month to his parents, allegedly. Well, the Zestimate, the Zillow Zestimate, I pulled up, and it was like $3,500 a month for rent Zestimate. Well, I used that. Court accepted it. Because the guy didn't deny it. I mean, he was kind of bragging a little bit in there. So he opened the door with a Zillow. And so there were 3 adults living in the household. So the judge divided it by 3 and assessed that amount to his income every month. Now, he did give him credit for the $300 a month, so it came out to be about $700, something like that, added to his income. Okay. Do it. Well, how many cases do you have where the partners are living with their parents or living with a girlfriend or boyfriend, not paying anything, or you probably have a lot of those. I know I've seen a lot over the years. That's income or a gift. Now, there was another case. What am I doing all the time? I tend to talk. No, okay, it's 12 o'clock. Well, I've only got 15 minutes. Oh, I got 15 income shares. Okay, so I had there was another case that came up to the Court of Appeals. It was out of Davidson County. Judge Bill Robinson. I've practiced in front of him for many years. And one of the things he used, it was a high income case. It was on the issue was the modification of child support, among other things. And mom had remarried. She remarried very well. Okay. And she was working, and the judge included her income from that work, but she also received I think it was like $1,200 a month from her new husband just for her play money. Yeah, he just, here you go, honey. I mean, it was routine, regular money that he gave her just to do with whatever she wanted. Judge included that as a gift, added to her income each month. Judge did that, Court of Appeals upheld it. Use it. Yes, sir.
If you inherit $50,000 in a year, do you put the whole 50,000 in the income for? I mean, you divide that by 12, and
you can. There is not.
How's it generally done?
There is not a steadfast rule on how it's done. So you need to look at the facts of the case and circumstances. One of the things I have seen judges do is how long before the children emancipate? Maybe it's 3 or 4 years or something. Maybe spread it out over that time period. That's one option. Had a judge, again, Davidson County, different judge, who the father inherited $100,000. The judge spread it out over 10 years. He just picked that number. I mean, it wasn't really, and that wasn't how long before the kids emancipated. I think they're not fighting against that yet. But, and he added that amount to the guy's monthly income. If you do it all in 1 year, you can do that, but you need to set a review because obviously there's going to be a check after that 1 year's up. Then you bumped it up a lot for that 1 year. Then it doesn't need to stay the same after. I'm sorry, what? What'd you say?
I said, if I get it, I'm not gonna set it for review in a year. Somebody else gonna do that.
The other person. See, and that's the beauty about opposition is perfect for the state. I'm a neutral. I'm in the middle. I like to make sure the law is followed. I don't care if it's which side it's on, and I love that position. I know you all as private attorneys, you have to look at it differently. So I've been in your shoes, and I'm glad I'm not here. I'm also a realtor. I'm also a mediator. So I like like the fairness. I've also been on the bench as a magistrate too, so I really like being neutral and following whatever the law is. But I understand your point. I totally get it. Hopefully the other side will bring that up.
Or not.
Or not. Because it does need to be fair. It needs to be equitable. Okay, that's a good question though. I like that. Any other questions on this? Let me see where I am on how many screens I have left. Imputation here, who asked the question? Oh, gentlemen, here. Yes, here are the new numbers. These changed. This is based on the 2016 US Census Bureau. If you can remember, we were doing this back in 2020. And so 43,761 for men, 35,936 for women. I think it used to be like 29,300 for women and 36 something for men. So that's what you would use if you have absolutely nothing else to go on. No other, and that's only in setting support. That is not when you're doing a modification. When you're doing a modification, it is still the same as previous law and that before 2020, and that is up to 10% per year. So that's still the law for modification. Retro support, this really in the past, even before 2017, you could still do a limitation going back depending upon the circumstances. However, we kind of did it in reverse now. So in the past, it used to be, okay, we would go back to the date of separation or date of birth, that sort of thing. Now, but it could be a lesser period of time. Now we're starting at this point, it's 5 years, or it can be more, it can be less depending on circumstance. If the parent tries to secret the child, took the child, moved to out of the country, out of state, whatever, and or just stood in the way, then that may be less than 5 years. It could be more than 5 years if that parent was really trying to find that person and they couldn't find them. If there are state benefits prior to 5 years, we're going to go back all the way to wherever those state benefits, because I will tell you that when there are state benefits, when TANF benefits are being paid, there is an automatic referral. Automatically that is in the system. Automatically that system is trying to find that person. So if they can't find them, it's because they're hiding or they're under the cut, And so we're going to go back further than that if that is the case. But general rule now is 5 years retro support. And then here's some more details about the statute here on the retro support. Gosh, got a lot of screens on that, don't I? Okay, debt compromise. Gosh, I can't believe it's already been 2015. Doesn't seem like it's been that long. So in debt compromise, it used to be against public policy to forgive child support arrears. You cannot forgive any arrears owed to the state, but you can forgive arrears owed to the custodial parent. Only if the custodial parent agrees to it. The judge can't order it. Judge can't say you're going to do it regardless without the consent of the custodial parent. Now the judge has to ultimately approve it and approve the order, absolutely. The judge could say, no, I'm not going to approve it, but the judge can't order it to happen. The other parent, not custodial parent, can't just make it happen. If the child support office is involved at all, if there's ever been a child support case, they need to be part of those negotiations. Don't leave them out. There could be some state money owed, or they just need to be involved in those negotiations because they've got a case. So what needs to happen is, because we have some forms on this state too that we or through our policy, we require our child support attorneys to do. And that is you have to do a explanation of rights for the custodial parent. He or she needs to know exactly what they're giving up. Is it, if there's any interest in the past, I know we don't do interest much now. That's changed since 2017, but they need to know exactly what is the total amount they're giving up. Now they don't have to give up monthly arrears. It could be that they're going to forgive $20,000 because the person's going to pay them $10,000 for $1,000 or whatever. Sometimes I'll see the situation where maybe the other parent bought the child a car or did some other, things outside of the child support. So that is the reason maybe they decide to forgive the arrears. But it does need to be that the non-custodial parent or payor needs to pay consistently pursuant to the order a minimum of 12 months prior to the agreement being entered. Also, they need to, well, when I say entered, I mean all the way through. They don't need to reach an agreement and then, okay, we're done. and it sits on somebody's desk for 3 months, or it doesn't get approved by the judge, or what have you, then they stop paying, well, they've got to start all over again. It's gotta be 12 consistent months leading up to. It can't be a lump sum, it can't say, okay, well, let's add up 12 months and pay that in a lump sum. No, that's not gonna work. It can only be done one time per case. So if they do a forgiveness one time, get behind again 2 or 3 years, they can't do another one. It's just a one-time thing. If there is domestic violence involved, we really suggest you've got to talk to the parties individually. You need to probably have that in front of the court. So the court may be very familiar with these parties because of domestic violence, and you don't want a situation where the person is trying to twist your arm. And one of the reasons we have the 12 months is because we don't want someone to go without any support for several months, and then they feel like they're in between rock and hard place. So, well, I've got to give it up because that way he'll at least pay, or she'll at least pay $5,000, and then I can get something. So that's why there's that 12-month period. That's one of the hurdles that we have found, that's hard to overcome, because so often we don't have cases that take consistently for 12 months. We actually tried to do 6 months in the beginning, and that didn't fly with the legislature. They wanted at least 12 months. That's where we landed with that. Okay, there's more on debt compromise there. A couple of pieces of legislation that changed. This top piece, this became effective in March of this year. This bill requires the court to take into consideration whether a parent has failed to pay court-ordered child support for a period of 3 years or more in any proceeding requiring a court to make a determination regarding minor child. Do you all know this law existed now?
As of this morning,
Okay. Did somebody speak on that earlier? Okay. So make sure you keep that in mind. There's a statute there. Here's another piece that changed in this. With a voluntary acknowledgement of paternity, the parties, for whatever reason, doesn't matter what reason, can rescind it within 60 days. However, if it used to be 5 years for fraud, duress, that sort of thing. Now that no longer is in the law. This amendment eliminates the 5-year statute of limitations for challenging a voluntary acknowledgement of paternity of VAOP on the basis of fraud, duress, or mistaken fact. Now, quite frankly, there's a statute. Quite frankly, I have seen judges, depending on the circumstances, they'll sometimes change it. It just depends on the facts of the case. But that has been the law. Okay. Scenarios. Do we have time? Hope we have time. We've got like 5 minutes, 6 minutes. Oh, you know what? I'm gonna type too.
Yeah, I'm gonna get it pulled up for you.
All right.
No.
We're so quiet. I feel like we need some background music or something. I can do my phone. Yeah.
Client now whose father is filing a motion for increased parenting time. He is years behind on his child support. When all the stimulus and everything came out, he filed the child on his taxes, and he was awarded stimulus payments, which paid off his arrears. His wife then filed as a,
Spousal injured spouse claim.
yes, and also got payment. Well, now child support has came to our client and trying to get those payments back from her.
From the the spouse or from the custodial parent.
From the custodial parent.
Yeah, and when they apply for services, when that person applied for services, whether it was because they got benefits or because they actually did an application for services, if they ever received a payment that they should have, they are under a duty to pay that back. I know that sucks. Or being recorded. Are we being recorded? Okay, sorry. I know but unfortunately, that's, if they got something they shouldn't have gotten, so they received something they should not have received, they're gonna have to pay that back. The problem, and I don't know how long it had been before the money came through and the injured spouse filed a claim. Usually, if there is a spousal, if it's a joint return, child support office will hold that for at least 6 months in order to give time for the IRS to come back in and make adjustments if they need to, or for that spouse to file an injured spouse claim. Usually, that takes care of it. However, the IRS can come back much longer than that. That may be what happened here, and take that money back. And unfortunately, for the custodial parent, they're gonna end up having to pay that back. Now, doesn't mean that goes back to the arrears. I mean, then he's gonna, that's gonna bump back up his arrears. And I had that happen actually recently. And where that same type of situation in a JD far from here. And the tax intercept took care of the arrears, but that spouse wanted, they wanted to, they got their money. And then so now we've got a deficit here. Well, because it took care of his arrears, he was wanting to get that credit, or his spouse was. Well, we told him, okay, you can do that. However, you're gonna have, all these arrears are owed now. We're gonna do enforcement actions against you again. You're gonna possibly get your license revoked, possibly, all these other things. So it ended up, he didn't go that route.
I didn't know with that because the local health support office is telling us that it still shows as he's not in arrears.
Well, the adjustments still have to be made on that. If you want to email me, I can check the case itself. Okay. Remember what I said, I love Mickey and Minnie, so I have to use them. And anytime I do this, can I do this? Which one?
You can click the minimize on that.
This one?
Yeah. That
Oh,
will,
that right there. Okay.
or you can move it to the top.
Can I just scan that too? Ooh,
No,
no,
that's
that
as
didn't
big
do
as
it.
it's
Okay.
gonna get. Cause they cut it down for some reason.
Can I do
Yeah,
this?
yeah,
Maybe, okay,
absolutely.
there we go. All right. All right, so in this first scenario, what,
2 minutes.
Okay.
We've got lunch after this, so we've got a little.
oh, they're gonna be mad if I didn't do their lunch. Okay, so on this one, I just did a standard parenting time, 285.80, which is basically every other weekend, every other holiday, 2 to 4 weeks in the summer. $1,400 a month I use for income for both. So look down here on line 4, so that 561, that is the BCSO, basic child support obligation, that should be in the custodial parent's household. Because they have the same income, 50-50, equal, Mickey's portion is 280.50. Now you look on 4B, SSR does not apply, because what was his income? 1,400. Let's go to the instructions. I'm sorry, the schedule. See this in the blue, the shaded area? That is where the SSR comes into play. And because we're talking about one child, 1,400 does not fall within that shaded area. Now, if we had had 2 kids in there, it would have been 372. So then the SSR would have applied. All right, let me go, oh shoot. Oops, credit. There we go. Okay, so let's do one where we'll see an SSR applying. Let's say Mickey's income is just $1,000 a month. All right, did that change? No, that didn't change. Oh, there we go. Okay, 1,000 a month. Their combined adjusted gross income is 2,800. Why did that not? That's not right. There we go. There we go. Okay, 2,400. I thought that was. So Mickey's portion is 42%. So the BCSO for the household is 493. Mickey's 42% is 207.06. Now, remember his income is 1,000. So let's go over here. Oops, not there. There we go. Okay, 1,000. So where does that fall? $100 a month is his obligation, because it does fall. What will happen is the worksheet will compare these two numbers. It will compare 4A and 4B. What is the lesser of the two? And it will go with the lesser amount. So in this situation, it's $100. Now, remember I said that that is before any other expenses. So we also have, Minnie is covering some childcare, and she has some help with DHS, but she still has out of pocket $100 a month of childcare. And so now Mickey's portion, remember he's 42%. So his share of that 100 is $42. So now he owes that child support obligation of 100 plus his share of the child care. So he has 142. All right, let's do a Social Security case. I want to do that real quick. And I want to do a minimum order.
Yes or no flag on this? That's what I don't understand.
Not on that.
Okay.
Not on that.
Okay.
Not on that one. I will do this. We'll do a zero income. Mickey, and this hurts me to say this, but Mickey is incarcerated. He got in trouble and he's incarcerated, so he doesn't have any parenting days. Yeah. Minnie brings Pluto to the jail, the prison a little bit, but that doesn't count as his parenting days. So here we are at zero income. So on this, come on down here. If we didn't do anything else, his obligation would be zero. So see line 15, we want to change that in. It defaults automatically to an N. So we want to change that to a Y for minimum order. Now he's going to owe $100 a month. And that would be the same kind of scenario, say if he was in an inpatient facility and getting into rehab. And that also hurts me to say that about Mickey. To tell you. Okay, so let's talk about Social Security. Now, Mickey has some disabilities and he fell during the parade one time, and now he has some permanent disabilities. And let's say 365, I'm just putting some numbers here. He receives $1,500 in Social Security disability, not a lot, but he receives that. Now, if we didn't do anything else, his obligation would be $303. But Minnie is receiving a derivative payment directly from the SSA of $400 a month for Pluto's care. Oops, sorry. See, I did what I told y'all that you can't do. I did that. I was talking about Minnie. Okay, $400, even though Minnie's receiving it, it's under Mickey's disability. So that does change his income because that is assessed to him as income. But then flip on over here. So now his obligation based upon 1900 is $375 a month. However, Minnie's receiving $400, so that $375 is taken care of. So look at line 17. So now Mickey's obligation is zero additional because that $400 takes care of it. Let's do one where, let's say, Minnie, oops, not 2000. Minnie's receiving $200 a month derivative payment. Mickey's obligation is $338. So that $338 is applied. So now that $200 is applied to the $338. So now his balance is $138. Does that make sense? So you can look at that last line there. What else do we? Y'all have some scenarios you want me to do real quick? Whatever. It's 12:19. I am happy to give you scenarios unless y'all are going to want to your food right this second. Let me do one real quick about the means tested, and then I'll quit. Let's see. Mickey, and a lot of times I'll see parties or child support offices or private attorneys not do a worksheet if the only source of income is means tested or is SSI. But technically you're supposed to do a worksheet. So let's say, what did you say? It's Becky, right? Becky? Beth. I'm sorry. I knew it could be. Okay. 600. I'm sorry, what?
840.
841 is the SSI. So what that would turn out to be, and that's his only source. He is not working anywhere else. So you would have an obligation of 101. However, because it's means tested income, you want to make sure you change line 3A from an N to a Y. Means tested income, so that he will not have an obligation, because you cannot set support against means tested income. Even if there's arrears owed, you cannot set a payment on the arrears if their only source of income is SSI. Okay, any questions on that?
If anybody wants to ask her some specific questions, we can always keep this going while people grab their lunch. Can come up here and ask her questions so we can keep it moving, but we want everybody's questions to get asked. So we do that.
Well, anyone come ask me if you like, but thank you all for letting me speak to you today.
Thank you.
And thank you for, laughing at a couple of my jokes.
All right, everybody, our lunch orders are down here. Your name is on the box. If you don't see your name, that means that I didn't get your order, but we do have some extras in the back for people that we didn't get lunch orders for, but we will be back at 12:45. Yeah, they're in alphabetical order, first name, drinks, everything are in the box with you.
Yeah.
That helps a lot.
Oh, good.
That, I'm a visual learner and, when I saw you doing it, I'm like,
That makes sense, right? And that's true when you tell them.
Reason you played so well, nobody was darn.
Yes.
Beth, do you want to try the clicker?
Oh.
You want to try it?
Yeah, so,
I've got to click on it once. Okay, now you click and see if it'll work. Yeah, and then you.
and
could-
this goes the other.
Yep,
I
I was saying, and if something happens and you just have to do it, just let me know. I just find it easier that way.
It probably is because one minute, this one up, and then the next 2 or 3 will be like quickly. No, I've done too many leather clubs. I've done too many extracurricular stuff and I'm not gonna do that.
So, all right, it is going, and, let's see. All right, everybody, we're gonna go ahead and get started with our next presentation. We have Beth Bates up, and then, so if y'all have any questions for her, just let us know.
Thank you. I am going to need your questions, but I ask that you wait at least 10 minutes in because I think we'll get too far astray to be of any general use if we start before then, but then let them go. Please, I'm humbled to be here. I'm trying my best not to be caught. I'm suggesting you that you probably have daily or at least weekly potential new clients who call and say something like, I'm receiving Social Security disability income, or my husband's trying to get his SSI. We're needing a divorce, or I'm receiving Social Security. Now, 70% of the time, they're probably know exactly what they're receiving. But 30% of the time, they probably are mistaken. And I've recently had friends who are upper income, middle income, who had the same problem. But I can't blame anybody because SSA, the Social Security Administration, administers at least 3 similar sounding programs.
That point towards the king this way.
Beth, point it towards the projector.
Oh,
Yeah, it'll work
yes. I thought I couldn't screw it up in it.
better.
40, yes, instead of the screen. Okay. How are they different? This may not be so interesting initially, but I'll eventually get there to something that is relevant to your practice. How are they different? Well, Social Security, the retirement part, came about in 1935. SSDI, Social Security Disability Insurance, 1956. SSI, 1974. How are they different? They're funded. Even though they're established by law and they're technically not an insurance contract, that's how they act. Social Security retirement, some survivors and auxiliary or derivative benefits, they're paid for by FICA, by our payroll taxes, or by taxes paid on self-employment income. Those are the premiums. For retirement, you generally acquire 10 years worth of credits, or they used to be called quarters. That can be over a lifetime. So you may see someone like Betty or Bert Homemaker who are insured for retirement. They started working a part-time job in high school, they worked part-time in college, they worked full-time when they got out of college, they worked full-time
when they got married until the children came, and then they dropped out of the workforce for 15 years. They probably acquired 10 years worth of credits. You could only get 4 credits per year, but they're based on dollar amounts. You could get 4 credits in 2 or 3 months, even on less than high income. But they're not insured, or Betty or Bart are not insured for SSDI because you have to be currently insured. If you're over age 31, generally you have to work 5 of the last 10 years or the equivalent in credits. They're both funded the same: payroll taxes, self-employment income. SSI, general revenue, income taxes mainly. The name supplemental security income, I surmise, was, as our previous speaker described, you had Luann and Larry Laborer who had worked all their lives, low wage jobs. And when they came to retirement, they needed a supplement to supplement their Social Security. So supplemental security income. You have to be poor. If you're 65 or older and meet the financial guidelines, then it doesn't, that's all you have to do is meet the financial guidelines. But if you're younger than 65, you have to be found disabled to meet the SSI criteria. Now, the definition of disability for adults is the same for SSDI and for SSI. It's just the poverty issue that is different. There is a program for children who are severely disabled. That's kind of a confusing term because it's a term, severe is a term of art in Social Security. But the criteria are harder for children, but there is a children's SSI program as well. Now, I'll use a couple of illustrations. I'll already used Larry and Lorraine that get SSI and maybe Social Security retirement. For Social Security retirement, I'm not talking about disability, but retirement, you've reached your full retirement age, which varies, but now is about 66 and is gradually going up till the folks born in 1960, and then it'll be age 67. After that, your income doesn't matter. So Senator Grassley, President Biden, they are eligible. Their work doesn't matter. Their income and their work doesn't matter. They can get Social Security retirement income. And I looked up his age, and he hadn't been there too long, but Bill Gates is at his full retirement age. His wealth doesn't matter. It's far different with SSI. Now you're saying, okay, Beth, you've bored us enough. I'm going to overlap a bit of what we last discussed. I won't read this slide, but something relevant to your practice. Social Security retirement and Social Security disability, their income for the child support guidelines definition. So they are counted in the worksheet. And she showed, Dr. Davidson or Ms. Davidson showed you how you got credit for the derivative, or I call them auxiliary benefits paid to the children of most wage earners that receive Social Security disability or Social Security retirement. And that's very important. And I suggest that it'll be covered on another slide, that it's very good child support. You don't have to worry if you've got a wage assignment and the person changes jobs.
You don't have to keep dragging the person back into court. That, the custodial parent receives the money every month at the same time. Very, reliable. And as I've seen from her worksheet is, that you, a lot of times it takes care of the obligor's, requirement. He doesn't have to, or she doesn't have to keep going back into court either. It's taken care of. You might keep in mind, and I had a friend like this in high school. She didn't, it was an intact family, but both of her parents had retired. And while she was still in high school, and so she was able to get an auxiliary or derivative benefit as well. Minor children of a deceased parent are also able to get this type of benefit, which is very helpful. As well as that, so don't forget about the retirees with the teenagers or the dad that's much older and has younger children. That's there as well. SSI, as she indicated, is exempt. That's taken from the child support guidelines. It's excluded from gross income. There are no auxiliary or derivative benefits. That's a means tested payment just for the person that qualifies. Another good thing, well, I actually got this right, is that Social Security retirement and Social Security disability income can be garnished. That may not be the proper term, but it can be. Folks like Terica Smith or the child support collecting, excuse me, attorneys for the state can file a notice of administrative lien with the Social Security Administration. I checked the sub-regulatory authority for Tennessee for Social Security, and they accept that. A court order should also work, and it can SS and SSDI can be garnished for alimony as well as child support. I don't know if a particular form is needed because I don't collect child support, but I suggest you find a person at a local Social Security office. You ask for a Title II claims representative, befriend that person, treat her like your favorite clerk, or treat him like your favorite clerk, and say, this is what I want to do, this is what the judge has ordered, the law provides it, and you can have the authority for that. What kind of notice do I need to file? It can be filed even while someone's applying for Social Security disability. Don't ask for an SSI claims rep. You'll just get referred to somebody else, and you can't garnish that. I know from experience, I represent the people that either got into financial trouble and are losing their eligibility because of that, or their disabilities being reviewed, or sometimes people who are trying to get or obtain disability under some circumstances. And I know that I had one fella who had grown children, but the mom had received TANF or welfare in Missouri while they were minor children. She was fine, but of course the state of Missouri wanted to be paid, and he'd been borrowing money. I think he had remarried. She'd been paying. He had it down to like $2,000, let's say. We were able to get him approved. He had that lien. He'd been going back and forth to child support court. He said, take it all, knock it out before you start my monthly checks. and so they did, because he asked them to do so. They will not bat an eye, though, in taking half of the check. And sometimes 60%. If there are arrearages involved. So if you have some pitiful obligee, you go to, whoever's collecting child support, if it's the state agency attorney or the contract state agency attorney, and, or you go back to child support court, because Social Security won't touch it. They'll leave the order, they'll give credit to the domestic relations order or administrative order. But my client was glad to get it out of the way. That was his choice. He didn't have to pay it all the first couple of months, because in his case and in several cases, the monthly checks may start before he gets his retroactive benefits. And that was the case with him. He's like, no, get it done. I want to be finished with that. Let's see. So those are hopefully some useful things. And I'll try to do. Okay. Yeah, I've covered some of this. I look every time. Sometimes grandchildren, generally they're not, but sometimes children living with their grandparents, custodial parents, so to speak, may be eligible for auxiliary benefits. Most of the time they're not. Some exceptions would be if the child started living with the grandparents before the grandparents started receiving retirement or disability, or if the parents are deceased or disabled, then they might be able to obtain auxiliary benefits. But generally not, because most of the time we see grandparents obtain custody after they've already been receiving the benefits. In that case, you see a lot of grandparent, or maybe not a lot, but you see some grandparent adoptions. And with adoptions, that child becomes, a child of the grandparent who's receiving benefits, and they would be eligible for auxiliary benefits. I have the regulations, several of them cited below, and I look every time that I think there might be a possibility. I don't rely on my memory. I look every time to see if they're if they might qualify. The same type thing with step parents. If a step parent is paying more than half of the support for that child, and there's a length of time that they have been married, or they have particularly if they've been married and he or she's been caring for the child, providing income before the step parent becomes eligible for Social Security benefits, then there might be a possibility of auxiliary benefits. Now, caveat here, there is something called the family maximum. If you have 10 children, each of them, you're probably not going to have very much money per child. Generally, ballpark, if someone is receiving, say, the parent is receiving $1,000, then all the children together are probably, the family maximum is going to be probably 150 to 180% of that. So they're not, you might, if you have one child and then that child would probably receive a great deal more than if there were 7 children. I'm not any questions? I think I've gotten far enough along that I'm saying. Okay. Oh, I keep going back. Maybe this is also practical. I know from being friends with Mary Jo that discovery is very important in family law cases. You're going to need to know what your earnings record might be, or usually the adverse, what the adverse earnings record might be. It used to be that we would get earnings statements annually in the mail, and you could get that. Well, it's not quite as easy these days. You could, through discovery, make your opposing counsel have his client or her client go to the Social Security office and get a copy of the statement. That's one way. The second way is a My Social Security account that the client can set up through the Social Security website. I set mine up a few years ago, and I remember it was kind of cumbersome. I had to take a photo of my front and back of my driver's license, and then I think I had to take a selfie of me so they could make sure that I was the same person. And I got an ID and me identification. Then even anytime I want to check in to see, for retirement purposes or whatever, if I lost my Social Security card, I can request it through that. There's still two-factor identification. Social Security says it's illegal for us as attorneys to set up these accounts. So I suggest it has to be the client, and that's the two-factor identification. They're going to get it on their cell phone, the code to log in. You might want to bring the client into your office, and I would say practice and get your own set up first so you can help the client. It's kind of like when you're flying, you put the mask on yourself, and then you help the client, and then you can download your earnings statement, or you can save it to your computer, and they'll give you an idea. It gives an estimate of what your retirement would be or what your disability payment would be if you do that. And it's an estimate. It's not exact, but it's probably about as close as we can get. The third way, which I suggest might be the most the last resort, is a form that Andy handed out with the rest of the materials. It's an SSA form 3288 that you can use and have the adverse sign it. The only and then you can get the information. The only downside is that Social Security is going to charge you $35 to $40 if you use that, because if you're not, like, I have my client sign an appointment of representative form, and because I'm trying to represent them with some kind of issue with Social Security, but this, you're just trying to get information. So they use it as a money maker. But I can see there might be some desperate time that this could be the only thing that you could do. Now, I'm getting back to folks that just honestly don't know. They're honestly mistaken as to what they're receiving. And this is relevant. So you're going to probably need to help them, because you're going to need to know what can be garnished, and you're going to need to know if there's going to be any auxiliary benefit or not. One of the clues is the amount that they're receiving. In the materials that I submitted, there's something called COLA 2023, and it will give them, and it's about middle ways down, it will give the maximum amount of SSI for 2022, 841, and there's been a cost of living increase of 8.7%. So in 2023, in January, it's going to be 914. If you see that, that's probably SSI. Not always, but very more often than not. if you see someone with $261, you probably have someone with some SSDI or Social Security retirement and some SSI. The reason being is that for what Social Security considers unearned income, there's a $20 disregard. So that's why that's a clue. I don't know that you need to know this, but it's just kind of interesting for a couple and both are receiving SSI. Either they're 65 or older and very poor, or they're disabled, and both disabled, or one's older and one's disabled. The maximum for a couple is $1,261 for this year and $1,371 for next year. It's less than 2 times the individual. But beware, now this changes every year based on the consumer price index for the 3rd quarter. But the resource limits haven't been changed in 40 years. And that's something you may run afoul of when you're doing divorce work, or just trying to help your clients, advise them. Non-exempt, there are some exempt, important exemptions, but non-exempt is $2,000 for an individual and $3,000 for a couple. The most important exemptions are the home where you're living and one bed. Those are the most important, but there are a few others. Another clue that you can use to tell whether it's SSI or Social Security is when they're paid during the month. If it's the 1st or one day before or one day after, it's SSI. Almost everybody is going to get their benefits on either a debit type card, I believe Direct Express is what they call it, or direct deposit to their bank account. Very few paper checks. I think there are a few. And we once recently we had to ask someone to ask for a paper check because his debit card had been stolen and it was going to be longer to have it replaced than was necessary. Okay, and then for Social Security retirement and disability, it's either going to be the 3rd of the month for your older clients, or a different Wednesday set out through the month. I think the first 4 Wednesdays of the month that you get Social Security retirement or disability. Some of this is a little overlapped. I've used some of the slides for different presentations, so that's why. Beware of outright alimony if you've got someone on SSI. $20 will be disregarded, but they consider alimony unearned, so it's going to reduce it dollar for dollar. But we're going to discuss, with time permits, some things that might be done to help with that. On the other hand, if you have an SSI child, a child who's receiving disability, and I suggest to you, these are very needy people. They are very disabled if you have a child who's receiving SSI. 1/3 of that child support is disregarded for Social Security purposes. So that is important. I'm going to reference some examples from a publication from 2008. So called Disability, Divorce, SSI, and Medicaid, using creative alimony, child support, and property settlements to maximize SSI, ensure Medicaid eligibility, and create funding for assistive technology. The front page of that I've included in the materials. There are a couple of caveats. The SSI law is still solid, but it was published in 2008. Some examples at that time, it predated the income shares child support guidelines. So some things you can tell when they're talking about straight percentages, that was pre-2005 for us.
So that, that dog won't hunt anymore, but the rest of it is pretty good. There, gave one example, and the amounts of SSI are much smaller. One example of a family that had two children, one was disabled and one was not. We would expect the court to presume that half the child support was for the non-disabled child and half for the disabled child. You would reduce the half by a third, and then you would take out $20 for the general disregard. That reduces the SSI check, but not by as much as dollar for dollar, and which is very important here, and in this case, is the child can still receive Medicaid, what we call TennCare, which is worth a lot more than sometimes the cash. So that's an important thing to remember. If you even, and there'll be another slide, if you even get $1 in SSI, you're going to be categorically eligible for TennCare, and we all know how much, how valuable that could be. Other examples they have for children, if the court would permit, and I don't know if this is allowable under the guidelines, I don't know, but it's a good idea. If you have somewhat friendly parents, if you have some abusers, or you want to have some parents that don't want to see each other ever again, it's not going to work. But instead, what examples they use is that you can pay, the non-custodial parent can pay third-party vendors for things that are not food and shelter. So they gave examples as a pro rata share of cable TV, gift cards for some clothing, and it would have to be reasonable. Our local claims representatives for SSI wouldn't take just something they would consider to be extravagant. Something like music therapy or horse therapy that, music therapy they offer at the Star Center. I think they may offer art therapy. Some children go to what I call horse therapy. That's not the proper term, but they do that. I don't think all of those are covered by TennCare, and those are things that could enhance the child's quality of life, so that some of the dollars that would be allocated to child support could be used for things like that. Another example they give for a child who had a spinal cord injury that needed a specially equipped van would be to craft, as a part of the property settlement, a down payment on that van, car payments on the van, or car insurance payments, YMCA dues, which of course would probably help the disabled child, a portion of the internet and telephone bill, not for the whole family, but what might be pro rata for the child, or if there was any extra need because of the disability. Those are some examples that could be considered if the court and the guidelines permitted to be substituted for child support. Beth, what were the two things you said that the alternate residential parent could pay, except there were two things? Was it housing and something else? Yes, housing and food. Okay, but they could give a card for food? No, a card for clothing. Clothing, thank you. Sorry, there's a change in the regulation pending at the Office of Management and Budget that might take the food out, but it's mainly housing, and they consider housing mortgage or rent, of course, but also utilities, mortgage insurance, probably renter's insurance. That's kind of a gray area.
But what you would generally, consider related, to housing, house insurance. You're welcome. Probably you'd be okay with telephone. Because that's, not exactly housing.
Could child support go into a special needs trust?
Yes, it could. There's also something called an ABLE account, and those were established after this publication was, developed. If a child or young adult disability began, prior to age 26, people can set aside, I think, up to approximately 16,000 a year, up to $100,000, to make that disabled person's life better. Basically, and there is some, I think it's bipartisan, some kind of legislation pending to raise the age to like 46 or 45, which I think would be a good thing. But right now it's 26, and that leaves a lot of folks out. I think that helps a lot of people that are not extremely wealthy, but kind of middle class. They can help, and make their child or young adult's life better. Yeah, that's a good idea. I don't know if you've heard Judge Jim, but a special needs trust, that would be good. That would also be good if you had if the child had an inheritance. Yeah, a special needs trust would be good. Okay. And that's careful creativity is what we're talking about for the child. And I've cited the regulations there. Good to have the law or the. Yeah, here I go. I like to go backwards. Yeah, here I think I'd need a little bit of a social worker, but as I've mentioned before, even $1 of SSI means health insurance. Okay, and I am digressing a little bit here. Children in Tennessee ought to be able to obtain health insurance. That's what we're taught at legal aid, our statewide meetings. They're either eligible for TennCare. You can be on SSI, and that's one path to TennCare, but that's not the only way. The younger the children, you can. The higher the income limits, so you can have intact families or divorcing families who will work and have low income that qualify for TennCare, particularly if they've got children under 6. And then there's still some that could qualify until the child is turned to 18. It's certainly worth looking into. Cover Kids is a state program for families that have incomes a little higher than TennCare. They will pay a premium, but that's accessible coverage. Then if they can't qualify there, or y'all can't, and a lot of the chancellors can order that are coming after me, can order employment related insurance, or they can order private insurance policies. So that's a good way. And I think from what I've read, most children are probably covered by their parents' employment related insurance. But failing all of that, they can go to the marketplace, which is what we call Obamacare. The marketplace will send you to some of these other places if you fit, or if you have affordable insurance. But I think unlike the child support guidelines, the marketplace considers that about 8%, a little past 8% of the gross income. So it's a little bit higher there, but not all that far off. And I suggest, and hopefully you've got this material, the Tennessee Healthcare Campaign. Call them if you have a question about either your insurance, it could be your insurance, but about a child qualifying for insurance. They're free. Of course, they're what I would call do-gooders. They're trying to get health insurance for everybody, but they do really good one-on-one insurance counseling. I have a friend who it's her birthday today. I saw on Facebook. I'm not going to tell her name, but she is very good. And I thought she'd retired, but she's back with them for this year. So she's world-class good. And you might get her because she's in the West Tennessee area. I would suggest that you call them and see if there's some options. They found some options from some of my friends who, of course, were adults and needed affordable coverage. So that's kind of fun. And I don't get any benefit, or legal services doesn't get any benefit by promoting these folks. It is free. Okay. Oh, and another thing that I think would be really helpful, if you have a client, potential client, that is receiving retirement or Social Security disability, and their gross benefit beginning in January is less than 914, say, have you applied for SSI? That could help them get health insurance, which is going to be worth a lot more than maybe they only would get $20 in SSI. Then that's really going to help them. If with Social Security retirement and disability, you a lot of times get Medicare. Folks at 65, you can apply for Medicare anyway. So there's no waiting period. But for SSDI, there's a 5-month waiting period from, say, if some poor person was hit by a car leaving Jackson State and became disabled, there's a 5-month waiting period before benefits would start. Then on top of that, there are 2 years that person would need to obtain retirement, obtain Social Security disability benefits. So you're looking at 29 months before you're eligible for Medicare. But if your client's already passed that, then their premiums are going to be about $170, $160. If they could get even a dollar of SSI, then they wouldn't have to pay a premium. Even if they don't get SSI, and you could tell they're poor, they're under the federal poverty level, which changes every year in February. You can get those premiums paid by something called Qualified Medicare Beneficiary Program. You can call the Southwest or Northwest Area Agency on Aging and Disability and ask for the SHIP, SHIP program, and they can help your client determine if there's any help paying Medicare premiums. That will, just help the overall economic well-being. Okay. Maybe this ugly car, truck, and house will help us remember that SSI has very strict resource limits. And the same reference book has some examples for alimony situations. But first, are there any questions? Okay. One thing, well, we've already talked about it. Okay, if you have a poor disabled client that can stay in his or her home, then you're going to want, most cases, I would say, alimony in Toledo. You're going to want the equity in the home to go to her if it's paid for. or if she can afford the mortgage. You could do home repairs. Maybe she's allowed, he or she's allowed one vehicle. You might think toward driving the property settlement or the alimony toward that. Now, this book suggests, and I have not actually done this, but I do have a colleague in Tullahoma that did, the proceeds came from a special needs trust. This suggests that the much higher wage earner on a long-term marriage could pay the mortgage, which would actually be more than the SSI check, but there's something called the presumed maximum value, so that the mortgage payment would only count against the SSI check up to a third of that check, so a third of $914 plus $20. I've never actually used that, I think, but that appears to be the law. And and my friend in Tullahoma did do that. Some other things, my example, if we're usually deal with much poorer clients. That sometimes they're just single people that have gone over their resource limit. I suggest, well, do you need a cook stove? Reasonable appliances and furniture are exempt. So I mean, do you need a cook stove? Can you buy that? And so that it would be exempt and you could get back on SSI. If you find yourself in a situation, seems like several of my clients, probably not really that many, they have an insurance policy, a life insurance policy. Sometimes their mother bought it for them. They don't know whether it has any cash value or not. They know they've been told that it's for their burial and it has face value. And after a while, lo and behold, it gets enough cash value, acquires enough cash value that it knocks them out of SSI, and it takes SSI a while to find it, but they find it. And that's a situation in which they would need to spend it down for something that they needed. And unfortunately, we see a lot of that, or it just seems like a lot lately. Let me look here. Oh, it also suggests that, if you have retirement or stock, you might, and you have one of the folks on SSI who needs the SSI more for the health insurance than they do for the money, that you divide the property settlement accordingly. I'm trying to look for other examples here. Supplemental needs trust is one of the ones that they suggest for an adult. A lot of times, folks that don't have, their children are not minor children anymore, so they can't get in here that way. They can't afford the marketplace because they don't have any income. They can't get private insurance because they got pre-existing. Well, they can't afford private insurance either. So, then these are the people that really need SSI. So I would suggest that I only included the first page of this publication, but you can Google it, and I think it's well worth a read. It's about 25 pages. So it's not, it's the first part you can kind of skim. It's not extremely burdensome. Yeah.
You give us that name again?
I'm sorry,
The name of the article again?
the name of the what?
The article we're gonna Google.
Oh, I'm sorry. The title page, if you don't, if it's a long
front page. The title page is in the materials.
Okay, you don't look good. That's fine.
Disability, divorce, SSI, and Medicaid. And then it got a lot of subtitles. God. If I can summarize one of these, if you have a disabled parent and a disabled child, Mark and Beverly are about to get a divorce. Mark will retain custody of 9-year-old Cindy, who is autistic and attends a special class for children with similar disabilities. The couple has no other children. Although Cindy clearly meets the disability criteria for SSI, she was never eligible for SSI while her parents were together because their combined incomes were too high. Following negotiations, the parties agreed to the following. Mark will go from a full-time to a part-time work status to devote more time to Cindy. Mark's wife will pay $1,000 per month as child support. And neither party will receive alimony. He will receive about $1,000 a month. Now, this is years ago. Part-time status. Under this agreement, if approved by the court, Cindy will still not be eligible for SSI. The SSI program will disregard 1/3 of the child support payments, which would be $1,000 under their guidelines. It would so she would be down to $666.67, and then an additional $20. And that's just, at that time, that was just enough to make her ineligible. And it says that they can divert part of the payment as alimony to Mark. And that would make her eligible. And that would deviate from the guidelines, but to make her qualified for Medicaid, that would probably be a good reason to do it. And the other things they could do was special daycare, a portion of car insurance, maybe any special program that would help Cindy. It would still leave her with a fairly small, it would leave her with a fairly small SSI check, but she would be eligible for TennCare or Medicaid. In the materials, I'm not going to go into this in detail, but there's a separate section called deeming. And this, what I'd like for you to remember, just in general from this, is that the income of the primary residential parent, the custodial parent, counts as well. It's not dollar for dollar. There's a worksheet that shows if you take out an allocation for any other children in the home that might not be disabled, for earned income, say the custodial parent is working, you take out $20, then you take out $65, and then you take out half of whatever is left. The rules for earned income are much better for SSI because they want to encourage work in a very convoluted way. But you also do consider the parents' income. In that little section, there is a break-even chart that gives you an idea whether with one or two parents, you're in the ballpark for SSI. Because there's a sort of an upper limit chart for that. Doing fairly well, but I think I've got about 7 minutes left. Do y'all have any other questions?
Hey, Beth, I know that Jane Jarvis worked on this case right before she retired, and she represented this woman in a long running divorce, and he was ordered to pay some alimony and never paid the alimony. He was drawing SSDI. And so she was able to take him back to court and got a portion of his social security check, SSDI check every month sent to the wife to pay his back, alimony.
Yeah.
So I just didn't know, that was the first time I'd ever heard about it. I didn't know that you could do that, so.
It's subject to collection. It is for spousal support. That's a good point. Everybody probably heard it, but if not, one of our colleagues, took an ex-spouse who owed alimony back to court, got an order, and was able to attach or garnish or seize or whatever the proper term is, a portion of his, Social Security disability income.
And the way that the wife gets it is she gets a separate check from Social Security every month or payment every month, not a check for. It's just for that money that he owes in addition to what she gets.
That, and she doesn't have, and so she gets it directly from Social Security. She doesn't have to have anything to do with him.
Right.
And it's very reliable.
Right.
Yeah. Yeah, yes, sir.
That brings me to a question. What if you're unable, for whatever reason, to collect the alimony? Are you still disqualified to receive the benefits? I mean,
If you're unable to collect,
the alimony.
you may,
Always.
no, the way I understand it, if the person's on SSI that's supposed to be receiving it,
Right.
that it's what's actually received. That's my understanding.
Okay.
But Beth, if you have an order for alimony at the time that you apply for SSI, or shortly thereafter, are they gonna presume that you're gonna get the money? I mean, I don't know even how they keep up with that.
I think you can rebut it, even if they presume that you are going to get it. You could, when you applied, they asked for, we sometimes help folks with applications. It asks for your income, and you could put in remarks, he's been ordered to pay it, but I've never received it. I think you're okay. Good question.
In the context of special needs trust, sometimes there's not always a good choice for trustee, either there's no family or not anybody that the beneficiary could trust to administer the trust in an adequate manner. Although, I guess I got two questions. What's a good practice tip for trying to figure out a trustee for that situation? And second, are there any public trustees or administrators that do that kind of thing?
I think I would ask some folks who do elder law, like Pam Wright or Nancy Show, but I think there's something, or there used to be, called the Tennessee Pooled Trust, that are not really public, but they're a group of trusts that are, it would be economically infeasible to manage it, each one on their own. You know, it'd be too expensive to do so. So there was something called a pool trust. And that would be what I would recommend. They're also in the Southwest and Northwest Area Agency on Aging. They have a public guardian that sometimes serves as like a conservator if there is no one to act. And I don't think they would act as a trustee, but they would probably know some people. You know, they probably have a good recommendation as to what to do in that situation. Does that help?
I think so.
I think I've got one more slide, but it was just kind of a footnote. I found this when I was looking. I don't think you'll see this very much. But some people receive benefits on their parents' record because they, the disabled person, became disabled prior to age 22. They used to call it disabled adult children. Social Security now calls it childhood disability benefits. And it's can be a little more than SSI, but it is funded by payroll taxes, that funding scheme and that type of, that area of the law. It's the child support guidelines say that the income for those folks is disregarded as well. I don't think you'll see very many of these because many of them become ineligible for the benefits if they marry someone who is not also a disabled adult child. But this is something I didn't know until I was preparing. So you may run into one tomorrow. I don't know. I don't know if I answered your question about the pooled trust, but that's the best I could do. Sorry. Any other questions? Thank you.
All right.
Thank
All right. We have our quick 15-minute break and then we'll come back after that.
Have people awake going back and forth.
I don't think I like the numbers enough.
Your next one. Obviously, is next one. Excellent.
I wasn't sure if I exactly, but I think it did.
You're like John Wayne. Every time I got out of this torch class, I thought I understood like the threshold of the door is in, it was like, no, I don't really. Like it's very simple. I think it's just, I'll be calling, you know that. That's what you do.
That's what the drive is for.
Explain this thing.
No, when they drive, driveways, I'll get my house. They'll go up there on Friday night and Saturday night, and you run apartments and all of them, what is on Friday night. You run as many times as you want, but because Saturday night is driving. A lot of it's hard.
Your story cases.
You should do it.
But, you know.
I've enjoyed it.
Not much fun. It's too much. You know, I mean, you might know that. Yes, based on what you sound like, really bad about the number around. It's supposed to work.
Yeah, when he's got staff.
Okay, that's it. That's what it is.
Hey, staff, because you're doing that job too.
Yeah. But I don't.
No, that's good.
And my son.
Oh. Now, so how much do we have? You would have just keep my bank account in there, I would not have said that. I got the house. And it just, I had no idea until I got a payment. Cause you don't realize that it's just got in that condition over a long, you know, don't turn out. Because, you know. It means a lot of property value, so I'm now officially poor. Cause the carpentry work with. I work with street and work.
At least you can get somebody.
I've got the
Get somebody, you have to wait in line. Yes. Oh, you know.
You get somebody out of Kansas.
Yeah.
You know. So I got people. If you don't go on, I mean, they come, they're not just gonna take around and be beautiful.
Get what you want.
But way after that, so it was double track.
Oh, this is less. Yes.
Yeah.
They were always. You know, it looks like they never stick together long.
Yeah.
I want to turn the screen off.
Where's the camera?
Right here,
Oh, this is it. Okay.
and the microphones and that.
Cool. That's pretty cool.
It's not very.
Well. Have to improvise.
Yeah. Well, the original plan was I was setting a laptop up in the middle.
Yeah.
I do.
There's no plugins. The only, the only plugins are up here and it
Yeah.
looks for something.
That's a lot of cords.
So I just, we went,
They don't work good on extension cords.
no, no. All right, everybody. We're- All right, we're gonna go ahead and get back started. I'll give you a 15 minute. I'll give you a 15 minute, about 15 minutes.
Yeah,
Just
10,
say
15
something.
minutes. I'm just going to.
All right. All right, everybody. We're gonna go get back
We did.
All right, everybody, we're gonna get started with Chancellor Butler.
I bet.
All right, floor is yours. You're good to go? I am.
All right, everybody, if we weren't on camera, I'd be standing over here, so I'm gonna try to talk loud enough where everybody got as far away as they could and actually hear. We're gonna talk about today something that applies to every court in every case in every state. But I'm not sure everybody knows about it. So how many people have ever looked at the Soldiers and Sailors Civil Relief Act of 1946? 1, 2, 3, 4. All right, do you now know that it's no longer that act? It's called the Service Members Civil Relief Act. Because they it had something to do with gender. And they said soldiers were men and women weren't soldiers for some reason. So anyway, they changed the name of it to the Service Members Civil Relief Act. And if you'll notice, in every divorce complaint, there's a section right after the statistical information that refers to that. Some of them still say Soldiers and Sailors Civil Relief Act, but that's not right. It's Service Members Civil Relief Act. It's not possible for me to cover all of the act, I'm gonna call it the act, in an hour. But I would generally say that if you ever have a client who is a service member or a spouse of a client or a child of a client, or maybe even a parent, disabled parent of a service member, this act might apply to them financially. So just remember that it applies not only to the service member, but to their family and like a parent, like if they are a dependent parent on that service member. Also, I would remind you that most judges are not familiar with the SCRA, the act. So you may have to educate the judge if you're seeking relief for a member or their dependent under the act. I have taught this act for 20 years because I was in the service. And I'm a veteran. And today, I have 3 indications of my veteranness on my body or in my clothing. So if you can guess what they are, you might win a prize. But I have 3 on me today. So pay attention, try to figure it out. The very nature of military service often compromises the ability of a member of the service to fulfill their financial obligations and to assert many of their legal rights. If they are in a job like I was in the National Guard, I was also a lawyer and a judge at some point in time. And if I got called up, I would have to leave that and go to the military. And so I might be off 1,000 miles away, or I might be off in East Tennessee. So that would affect my ability to protect my rights and also maybe pay my bills if my salary with my job stopped and I had to take up military salary. So during the Civil War, the United States Congress enacted an absolute moratorium on civil actions brought against federal soldiers and sailors. And various southern states also did the same thing. During World War I, Congress then passed the Soldiers and Sailors Civil Relief Act of 1918. The 1918 Act did not create a moratorium against actions against members, but it did direct trial courts such as Chancellor Mansfield, Chancellor Maroney, circuit judges, whatever, people who hear those cases, directed them to take whatever action they felt was equitable to take care of the service members' rights if they were in some type of controversy. In 1940, the Soldiers and Sailors Civil Relief Act was enacted, essentially a reenactment of the 1918 statute. But the experiences that people had during World War I were incorporated into that act, and they updated that act and made changes that are necessary because of the passage of time and society evolved. Some courts tried to override court decisions did try to override some of those restrictions, but they were not very successful. And then the Congress then started passing amendments to the act. And the first of these was enacted in 42, right after Pearl Harbor. And so they expanded and made available additional relief to the service members. So in 2003, President Bush enacted what we now have as the Service Members Civil Relief Act. And it was written to clarify the languages of the old act and to update the act to reflect new developments in American life since 1940. It also went a step further and enacted protections for reservists and National Guard members who weren't protected under the original act. So now, if you are a reservist or a National Guard member and you get called to active duty, then you come under this act. Active duty is enacted pursuant to Title 10 of the United States Code. Most National Guard and reservists are on their weekend duty and summer duty. They're under Title 32. So they're not entitled to the act under Title 32, but under Title 10, they are. the most common forms of relief that you will be involved with, if you are called upon to represent somebody under the act, are number one, mortgage relief, termination of leases, cars, housing, protection from eviction, can't pay your rent, or if you are called out and you're sent to Oklahoma and your salary is reduced and your wife is at home with the children, you can protect her from eviction. Interest rates on all loans automatically go to no more than 6%. So that's an important thing. I did a lot of reducing interest rates when I was called up in Desert Storm and Desert Sheep. We went all over the state, and I designed a letter for the soldiers to give to their lenders to make sure that they knew what their duties were, and the lenders all cooperated. Everybody cooperated, but they needed that information because they didn't have it. And so the letter was designed to help the soldier, and so they automatically reduced all their 20% interest rates on cars and loans and whatever to 6%. And so you might ask, well, where does that interest go? How do they recover that lost interest? They don't recover. It's just gone. So 6% interest rate on loans. Stay of proceedings in court, federal court, chancery court, circuit court, city court, general sessions court, any kind of court, competent jurisdiction that you might have a client in, or a client's wife in, or a dependent child, such as juvenile court. All of those proceedings can be stayed under the act. How long? It depends. You might need but a 3-month stay, might need a year stay. So it depends on the situation. And the judge has almost unlimited power to grant that stay. And, you know, they can, that's why the judges need to be educated about what their rights and duties are and what their powers are, which they may not know if they've had no connection with the military. Reopening default judgments. We all know how hard that is to do in just regular cases, but under the act, default judges can be reopened up to maybe a year after the judgment, or a year after the service member returns from active duty back home. They may not even know that they have a default judgment. A judge may have granted a default judgment on a case where they were served before they left, and then they got called up on active duty and went to Japan or wherever and just forgot about the judgment, forgot about the case. And so, having been served, the judge might not know that they were in the military, nobody tells him. And so he grants a default judgment and a $50,000 judgment. That can be set aside very easily. And I will say this, that he doesn't even have to apply for it, for a stay if he knows about it. The judge on his own, if he hears about it, and even if the defendant does not ask for it, the judge can issue a stay saying, I heard from Bill Smith that Billy Jones got called up and I've got a case that is in my court. So I'm issuing a stay. If the judge finds out about that also, or upon request from the defendant, he must appoint a lawyer to represent the defendant under this act. There's no discretion about it. So The judge appoints a lawyer. I've appointed lawyers before. Most recent, I remember I appointed Dusty King in a case where I had a soldier in a divorce case. And he'd been called up to active duty, and he was in Oklahoma. And he had already been served, and the case was going on. But it was 2 or 3 months old. And so he didn't have a lawyer, and I appointed Dusty King to represent him. So what were Dusty's duties? His duties were to first contact the defendant. Let him know who he was, what his duties were, and find out more about how long he's gonna be gone, when's he coming back, can he defend the case, what's his income, so forth and so on. And then the lawyer reports to the court. He doesn't necessarily enter an appearance. So if he enters an appearance, then you open the door for default judgment. So he doesn't enter an appearance simply by asking for this information and making a report to the judge. So remember, there are lots of things that can be done under the act to protect a service member or their dependents. What I'm going to tell you today is about 20% of it, because we don't have time. We don't have an hour. The Supreme Court of the United States says that this is not an equal opportunity law. This is an unequal opportunity, and it's in favor of the service member. And the court says that the Service Members Act must be read, and I quote, with an eye friendly to those who drop their affairs to answer their country's call. Who can resist that? What judge is going to say, well, the heck with that? So never get reelected. I don't have to worry about it. You do. All right. Who does the Service Member Civil Relief Act apply to? 1, active duty members of the Army, Air Force, Navy, Marines, Coast Guard.
What about Space Force? Space Force.
Space Force is out. They don't apply. Doesn't apply to them. Now, they may make an amendment to that, or if the Space Force is an auxiliary under the Air Force, maybe, but it's not in the act. I'm not even sure the Space Force exists.
They don't have a lobby yet.
Yeah, I'm not sure they exist yet. Number 2, it applies to reservists, Army reservists, when they are on active duty. Title 10, as opposed to Title 32 duty, which is weekend drill. Members of the National Guard, if they are mobilized under federal orders, Title 10, again, for more than 30 consecutive days. Active duty commissioned officers of the Public Health Service or the National Oceanic and Atmospheric Administration, NOAA. They're covered under the Service Member Civil Relief Act. And as I said, the act has rights and they may be exercised by anyone with a valid power of attorney for the service member. Service member might be in Japan, or might be in Oklahoma or Canada or wherever, Alaska. So they can be exercised by a power of attorney. Some of these protections also apply to their dependents, not all of them, but some of them. 2 words that I'm going to say that are covered throughout this act, and they are very material and very important to remember. The 2 words are material effect, EFFECT, material effect. You will find those two words all through the act. It is a central, equitable component and concept. Trial courts are required to determine or form an opinion of the extent to which a service member is materially affected by his or her call to active duty or being on active duty. Materially affect. If they're not materially affected, then they're not going to get any relief. But if they can show material effect, then they are entitled to a whole panoply of relief. So you just have to show that you have been materially affected. If you were in a job and you make $50,000 a year and you're a National Guard member and you get called to active duty, then you may be sent to another state making $20,000 a year or 30. You have been materially affected because your income is reduced, and therefore you are entitled to all the rights and privileges of the act. Active duty is defined as active training. It also is going to war, being in combat. It also applies when you are wounded or your spouse is wounded if you are a dependent and are sick or on leave for any other cause. So you've got lots of room there. The period of your military service, which is a component of the act, because it only applies during certain periods, begins when you enter on active duty and it ends when you come off active duty, plus could be 30 days, could be 60 days, could be 6 months. In one case, it could be a year. So even after you finish your term, you have rights that apply up to a year. Persons, when it refers to persons in the act, it's referring to the when it's referring to the holder of a right, such as a creditor. It includes individuals, partnerships, corporations, and other forms of business organizations that might come after you, such as a bank, suing you for a debt. The term court, all through the act, says you take this to court, apply to the court. What court are we talking about? Well, the court means any court of competent jurisdiction in the United States of America. State court, federal court, general sessions court, chancery circuit, city, juvenile court. So it just applies very broadly. Don't forget that, most of your cases are going to come probably in the chancery court because they're more familiar with equitable relief and has the ability to formulate remedies. Chancery court, unlike circuit court, can formulate remedies to take care of situations. Circuit courts are law courts, so they don't have that ability. Chancery courts have that ability to do that. Mortgage relief. Let's talk about your house mortgage. Say you have a client who's a soldier who gets activated, and they have a house and they have a mortgage. If they took out this mortgage before entering active duty, then number one, it can't be foreclosed on. It's pretty good, right, isn't it? The only way they can be foreclosed on if they go on active duty and miss payments is if the mortgage holder goes to court and gets a court order and gets a judge to allow the foreclosure. So they can't, there's no more self-help foreclosure. Where if you miss a payment, they send you a letter and say, we're gonna foreclose next month. They can't do that. Have to get a court order. The court order has to come from a judge. One generally elected by the people, who is going to be very mindful of your rights as opposed to their rights. And with an eye friendly to the service member. This applies in every state. It doesn't matter whether the states require a court order or not. Some states do require a court order. Tennessee, I don't think does. But it does in this case. It also applies whether or not you told your lender that you had a mortgage. I mean, that you were subject to this act. They may say, well, you didn't tell me you were subject to the Service Member Civil Relief Act when I gave you this loan, and that you would be able to stop me from foreclosing and collecting. But you can just say, well, I'm sorry, forgot it. Because it doesn't matter whether you told them or not. Also, a court on its own can stop the foreclosure or issue a stay if it is requested to do so. Provided that the member has been materially affected by his or her active duty service. And as we said, it also applies to their dependents. So say you have a client who is a service member who has his mother living with him in the house. And she's older, disabled, doesn't have much income, and he can't make the house payments. And they want to foreclose on the house or want to evict somebody for a lease payment that hadn't been paid. Just because she is his dependent, then a court can stop that eviction or can stop that foreclosure until they can get it straightened out. So that's a pretty good right, pretty strong right to have. Interest rates, we talked about this a while ago. It applies on just about every loan that you can think of that a service member would have. It does not apply on loans that the service member makes while they're in active duty or after they go on active duty. In other words, you can't go into active duty, go buy you a Cadillac, get you a loan, and then say, I want to reduce my interest to 6%. It doesn't work that way. But to get this 6%, you don't have to have material effect. That's one place it does not apply. It automatically goes to 6%. All you have to do is let them know about it, that you're on active duty. And what we did when I was doing this, we sent a letter. I designed a letter to go to the creditor. I said, take this to your creditor. If they have any questions, tell them to call me. And so they did, and not one of them ever called. I think everybody got all their interest rates reduced automatically to 6% all the time they were gone in Desert Storm and Desert Shield. Applies to car loans, student loans, house loans, credit card loans, credit card debts, these 30% loans that you get at the, when you really don't have any money and then credit, they automatically go to 6%. But you have to notify the lender in writing and include a copy of your orders, your military orders. And with that, you're in good shape. The 6% lasts all the time that a member is on active duty, and for most loans, for an additional year after the end of active duty, if you make a proper request. What do you do if the lender says, screw you, I'm not going to do that? I've never heard of that. They won't reduce your loan. You borrowed this money from me. I'm one of these payday lenders and they charge 30% interest. So, I might reduce it down to 20. How about that? Well, you don't need to argue with them. You need to get you a lawyer, or if you don't have the time to get a lawyer, get your power of attorney to get a lawyer for you. They can act for you. Take it down to General Sessions Court, Chancery Court, or Circuit Court, and you will immediately get relief. If, number one, if the judge knows what the relief that you're entitled to. What if you go into active duty and you forget about this 6% stuff and you learn about it 9 months later? Can you go back and get that relief retroactive to the date that you entered? Yes, the answer is yes. So if you forget about it or you don't know about it until you learn about it, you can retroactively send your lender a letter saying, I want to reduce my loan retroactively to, here are my orders, by the way, the date I entered, 6% back to them, and they have to do that. So that's just an important thing to know. That applies also for 180 days after you're released from active duty. So don't forget that. Under this act, the lender may say, well, you know, I may have to do this, but I'm not going, I'm going to send a letter to the credit reporting agency, how you screwed me on this loan. But that is against the law. That's a federal offense, number one. The lender cannot revoke your loan. They can't change your credit terms. They can't refuse to grant you credit just because you exercised your rights under this act. In addition, they can't furnish negative information to a credit reporting service just for invoking your rights under the act. I think we've already covered foreclosure. What about this? You got a house payment of $1,000 a month and you're making $50,000 and you got no problem paying it. You got a wife and 2 children and you get activated and your rank is like enlisted 6, which you might make $25,000 a month, a year, maybe 30. And you've been materially affected. And you want to keep your house, you want to keep your family in there, but you can't afford that $1,000 a month. So what can you do? Under the act, a judge like Chancellor Mansfield or myself or Roy Morgan or any General Sessions judge in Missouri can have a hearing, give the lender the right to come into court, and your attorney, in fact, could be your wife, could be your mama, whatever, and have a hearing. And if he or she, the judge, finds material effect, might cut your payments to $600. So well, you can afford $600, so I'm gonna cut your payments to $600. And the lender's over there having a stroke, saying, well, what am I gonna do? I set this loan up at $1,000 a month. Well, they don't have to eat that. What they have to do is they do have to reduce it to $600 a month while you're on active duty, while your client is. Well, what happens to the other $400 a month for a year? All they can do is add that on to the back of the loan. So what it does, it might extend the loan for a period of time after it would normally mature. So if it's a 20-year loan, what the heck? You know, you go add 6 months on the back of the loan in the 21st year. So you're going to recover from that. And it's not going to hurt the lender, they'll still be in business. So that's one of the remedies that the judge can do. Can't cut it out, but he can add it back. Default judgments. A service member who is sued while on active duty has some protections against default judgments. Some of these rights I will go through. Before the defendant, before the court can enter a default judgment against a service member, party suing must file an affidavit with the court stating whether or not the defendant is in active duty service and provide facts to support that statement. If the party suing is not able to find that out, then he has to set that out in an affidavit that I asked around, I checked, I can't find anything about active duty service. This applies not only in divorce cases, and we've all seen that in our divorce complaints. We might have wondered, why do we have to put that in there? Well, this is why. It's required. And it's not only required in divorce cases, but any case, in circuit, chancery, federal court, whatever, before a default judgment can be entered. So if you file a lawsuit, you don't put it in the complaint and swear to it or have it acknowledged or whatever, before you can get a default judgment, the judge is supposed to make you file that affidavit. Now, granted, we've all been through that. The judge may not know about this, may not know about the Service Members Civil Relief Act, and may let you slide through. But what if you slide through and then the service member comes back after they get out of service and say, default judgment, what do you think? Then they file a motion to set aside the default judgment. And pretty well, it's going to get set aside. And then they start over, and you have to start over. So, word to the wise. The court can delay the case for at least 90 days on request, and longer if the court finds that it's necessary. What would be an example of that? Well, if you've got a soldier who was served and then got called to active duty, sent to a permanent change of duty station in Japan, how is he going to defend this case? And you might say, well, I'll give him 90 days. Well, he can't get back in 90 days. He can't leave unless the company commander will let him. And if the commander won't let him, then he can't leave. So you may have to extend it to longer than that. And whose ox is getting gored? The defendant, the plaintiff. But that's just the price that plaintiffs have to pay when they're dealing with active duty service members. Remember, an eye friendly for the one defending your country and you. So that's why it's not an equal opportunity act. If you have any questions that will go along, how much time I got, Andy?
It's 3:08, so you've got 22 minutes. 3:08, so you've got 22 minutes.
22 minutes. Well, I'll try to avoid you 22 more minutes. Then I got some fun stuff. Protections against repossessions. In some instances, this act will prohibit creditors from repossessing a service member's personal property, including their car, vehicle, without a court order. You know, normally they just go pick it up in your driveway. But to get a service member's vehicle, they have to have a court order. They have to go through a judge and prove to the judge that there has been no material effect So even if the wife can't make the payments and misses the payment while he's on active duty, creditors still have to file a lawsuit and get a court order from a judge before they can get that car away from her. And she can come in and say, I need that car. I've got to get my child to the babysitter so I can go to work at Wendy's. I'm not making but $7.50 an hour. And so the judge has the power to stay that repossession while the active duty guy is on active duty. He also can cut the payments to where they can afford it until the service member is released and add those payments back on to the end of the loan. So the creditor is somewhat protected, they're just delayed. And this is because they're also being protected by this guy that they're suing. So that's the concept under the act. You also not only have protections under the act, the federal act, but you have state laws in Tennessee that protect service members in cases like this. I'm not going to try to get into all that, but they're there. Look in the Tennessee Code of Annotated. There are several protections in that code. Termination of leases. You may have a client who has a lease on a house or a lease on a car. And they get called into active duty, all of a sudden, their job, they don't get that pay anymore. Their wife is not working or their husband is not working, got 2 children. The Service Members Act provides them with the right to terminate the car lease, terminate the house lease without penalty, regardless of what the lease says about termination. They can terminate it and move. They might want to move with their spouse to Oklahoma, where they're going to be stationed for a year. And so they've got a house lease over here for another year. So it's important to be able to terminate that lease. So if the creditor won't do it, then of course, the Chancellor, Circuit Judge, General Sessions Judge can terminate it for them upon application. And even if they're gone already, their attorney, in fact, acting under a power of attorney, can do it for them. So that's one of the nice things about this act. To terminate a housing lease, here's what you got to do. Written notice to the creditor. A copy of your client's orders to active duty. If you can't get that, a letter from the commanding officer of the company where your client is, just a letter from the CO will do it. You can do it by hand delivery. You can do it by private carrier, not pigeons. Return receipt of the mail or by email. Be sure and cover yourself if you use an email or something where you're going to need to prove you gave that notice. Okay, let's see. Talked about housing leases, vehicle leases, pretty well the same thing. We won't go into that too far. But if you've got a car that you leased and your family is being transferred to Alaska, you need to maybe terminate that lease. So you can do that pretty well the same way. Notice to the lessor, copy of your orders, and pretty well you've terminated that lease without penalty. Generally, it takes about 30 days notice to do that, to be somewhat fair to the creditor.
Got about 15 minutes.
I mean,
15.
15 minutes. I got 15 total. I mean, I gotta start my comedy act now.
So just tell me to do.
Well, I cut in Chancellor Manfield's time. Okay, so pretty well, what I would end up saying, by the way, statutes of limitations. If you get into a car wreck, say, and you get sued for something, or you want to sue somebody, and then you get called to active duty and you can't get it filed, the statute of limitations in all cases is extended for the time that you were on active duty or your client is. So if you're into the statute 6 months and your client gets activated before you can get the suit filed, be aware that the statute is extended until he comes back, and then it starts to run again. So you're in good shape there. We've covered defaults, we've covered statutes, material effect. There's a lot more to cover, but I can't do it. Summing up, though, if you, as a lawyer, represent someone who gets called into active duty or is already on active duty, but remember that they have more rights than a civilian does. And so if you don't know what those are and they have a problem, or if their dependent has a problem, try to find out, call a judge advocate officer. Chancellor Malone, myself, Chancellor Malone knows all this backwards and forwards. He's a judge advocate. I was a judge advocate. And several of us. Michael Banks over in Brownsville is a judge advocate. He's a full colonel. He knows what we're talking about here. So call somebody that can give you some advice. And that's pretty well it. Any question? Have you figured out what? Okay, question.
I do have a question. Assume if someone were to get a default judgment against a service member, and someone were to get a default judgment against a service member, and you didn't know they were a service member at the time, it doesn't matter. They come back, they discover they have a default judgment against them 4 or 5 years later, and for whatever reason, steps haven't been taken to collect on that judgment. The service member could then return and set aside that default judgment. What about the statute of limitations for the initial cause of action that got set aside?
You got an uncomplicated question? Let me give you a short answer. Number one, setting aside the default judgment under the act 1 year from the date that you're out off active duty. Number two, under state law, you may be able to set it aside 5 years. I did this in a case over in Haywood County, I believe, Jim, where we had a default judgment in a divorce, and there was something fooling around with the service, and somebody got the divorce, and I set that aside. And it went to the Supreme Court and they upheld it. I set it aside like 4 or 5 years after it was over. So there's some case law, I can't remember the name of the case now, but so setting aside a default judgment under this act is 1 year from the date of return, but you may have other cases where it might be longer than that.
I think part of the question though was, if you have a statute of limitations problem as the service member, and it's been told while you were in the service, does it start over again?
No.
No, it
Picks up.
picks up.
Yeah, it picks up from the time, there.
So if you had 2 months when it was told, you got 2 months when you get off.
Yeah, the orders that's told the statute have a date on them. And the date on those orders is when they went into active duty. And from that date until they get out and they'll have orders releasing them that date, that statute is told during that time. So you just add that to the end of the statute. If it's a year, might add another year to it. Okay, let's walk back in time. I made some notes while I was thinking a while ago how dull this kind of stuff is. But back when I started practicing law, and maybe Lloyd, I'm not gonna talk about Mary Jo. Never talk about a woman's age, but, and.
71 and proud of it.
I was born at night, but I wasn't born last night. So, but anyway, when I started practicing law, I remember Jim Diamond, who mentioned this morning, somebody mentioned him this morning. I remember Jim Diamond trying a criminal case and I was watching, and he was smoking. Had a cigarette and an ashtray on the council table. I don't know if the DA was smoking or not, but Jim was. And I've seen lawyers for years after that, 2 or 3 years, smoke in the courtroom. So how many in here have ever seen that? Jim, you ever seen it? I don't really recall. They probably stopped it at the start. Yeah. Your daddy would have seen it.
Oh, yeah, he probably.
Engaged. They had,
Oh,
Yeah, he's got it.
but when I started, instead of having water on the council table, they had ashtrays. And the little aluminum ashtrays, you know, you blow it hard and it fly off the thing.
Dad smoked a pipe in the Supreme Court building. I wonder if he sat
that's when he,
in
when,
here.
no, he didn't. When he quit smoking, he started smoking that pipe.
Yeah,
And I told
And you
him
could
he
smell
should kill the
whole
rest
building.
of us and himself, but he did not smoke in the court.
and Judge Tommy, hey,
You know he did. You know he did.
Don't forget the spittoon.
Well, I'm getting to that.
Okay.
Now, Judge Taylor, who was the circuit judge when I started, he smoked cigars. And, you know, you couldn't smoke a cigar in the courtroom, that's just terrible. But he did chew. And so he had a spittoon right there by his feet, behind the bench, and then there's tobacco all over the floor, but he never hit it. And, but so and I can't remember if the lawyers had them or not. I can't remember for sure. I think they had them in chest care. But Judge Taylor had a spittoon under the bench and he spit in it. He'd reach over like he's scratching his leg. We all knew what he was doing. But so I don't remember when it was that they stopped people from smoking in the courtroom. Now, they didn't let the audience members smoke, but they did let the lawyers and the judge smoke. I don't know about the clients. I don't remember seeing any defendants lighting up, but the lawyers could smoke. You remember that? You know, you too young.
They stopped that just before we started practicing.
Probably so, but I remember it for several years.
Yeah.
Remember on air? I remember those little aluminum.
Right.
What else am I gonna talk about? Typewriters. Anybody here got a typewriter? You got one?
Mhm.
Is it a real typewriter?
We got 3
Yeah.
in our office. They
Well,
all work.
Back a long time ago, when some of us started, that's all they had. Typewriter. So they didn't plug in. You didn't have to reboot them. You just stuck your paper in there and started typing. Didn't have copy machines. So you had what they called what? Onion skin.
Oh, onion skin.
Onion skin
Onion skin.
and carbon paper.
Not used to-
And so you or your secretary would have one letterhead, and then onion skin and carbon paper, onion skin and paper.
And you had to be sure to put the carbon paper face right there.
Oh, wait, wouldn't do that. So you screwed up.
The whole letter.
Type the whole damn thing. But, so we had carbon paper and onion skin. The onion skin went in your file
Right.
and the real paper went to whoever.
Right.
And the onion skin, I don't know what to deal with that. I mean, the carbon paper, you find it through little.
Yeah.
So back a long time ago, your files, you might have a big divorce file, might be that thick. Instead of that thick. That was around the time before, that was when they didn't have any discovery. Didn't have any rules of civil procedure. And as a result, there was no discovery. So if you ask your opposing lawyer for a copy of your client's wages, you say, F you. I ain't getting that. And you couldn't do much about it except go to the judge. And he might issue the order, but there was no discovery. So you didn't have interrogatories, requests for admissions and all that stuff. If you want to get somebody to admit something, you'd have to take the deposition and put them under oath. Copy machines. Does anybody remember our first copy machines
Xerox.
that were wet?
Oh, no, not zero. No, they were wet.
They were wet.
Yeah.
And so when the copy came out, it rolled up. You had it out and then, pat it down and put a brick on each end until it dried. And then you'd have a page.
Right.
So our old copy machines, when we first started out, were wet. Then you had your page, but 4 months later, you look at it, it was blank. It faded out. So there wasn't anything on it. So it was hard to preserve records back then. When I started practicing in 1966, all of the courts in Jackson were in one spot, except City Court, which was in the fire station, the old fire station, which is now the Carl Perkins Museum. That's where City Court was. But all the other courts were in the Madison County Courthouse. So you could go from the General Sessions Court to the Tennessee Supreme Court and never leave the building. General Sessions was in the basement, as was the entire Sheriff's Department, who has 2 new buildings and one out east of town. But they had the whole Sheriff's Department and the jail and all the prisoners in the basement and on top of the courthouse. And if you went up there to visit a prisoner, you really had to just sometimes hold your nose, because I don't know what they cooked with, but it was awful. But they cooked up there. And I have eaten up there. Sometimes, every once in a while, they let lawyers and judges eat. And we go up there and there'd be Lysol, it smell awful. And the prisoners, don't talk to you. So anyway, all the prisoners were up there, they had a deputy up there, and all the women were on this end, on the east end. Every once in a while, somebody get mad, they throw all the women throw their clothes out the window through the bar. So they'd have to go get some clothes for the women before they could bring them down to court. Because they were mad about something, so they throw all the clothes out the window. There was no air conditioning in the courthouse. That came along later. I don't remember exactly when, but when we would hold circuit court or Chancellor court, you'd have to compete with the horns blowing up and down the highway, loud mufflers, people fighting out on the lawn, and wind and rain. Because they'd have the windows open and the fans going. Now the fans are still in there. I don't think the windows have been open for a while. But it was hot. It was hot. And so they would let you take your coat off and loosen your tie if you were a lawyer. Unlike now, you can't take your coat off. I guess, can you, Chancellor?
Not in my court.
No, sir. Anyway, you could go from general sessions to the Supreme Court, up and down the elevator. Well, let's talk about that elevator. If you go in the courthouse today and you turn right to go to the elevator, there's a portrait of a guy on the wall. You know who that is?
Hugh Anderson.
Hmm?
Hugh Anderson.
Is that who it is?
Yeah,
I don't, you sure?
yeah.
I thought it was another guy. I thought it was the guy that fell down the elevator. Who was that?
That was Hugh Anderson.
That was Hugh Anderson.
Judge Hugh Anderson.
He's the one that died?
Yes,
Okay, I thought that was him.
yeah,
I thought that was his picture.
it is.
Judge Anderson was on the Supreme Court, I think, wasn't he? Court of Appeals.
Court of Appeal.
And he was getting on the third floor. They had the Court of Appeals, Court of Criminal Appeals, and Tennessee Supreme Court. And the clerk's office, all upstairs there with the library. Had a big library on the other end of the hall. Judge Anderson got through with court that day and pushed the button to get on the elevator. And the story I heard was that he would turn around to say something to Whit LaFawn. And the door opened and he was talking to Whit and he stepped in there and there wasn't no elevator. They would come up and he fell all the way to the basement and killed him. And so that's whose picture is there by the elevator around the corner on the first floor of the courthouse.
When you know who it would be involved.
I'm not sure, but I'm not sure. In 1966, when I started, all the lawyers were within maybe 1,000 feet of the courthouse. All around the courthouse, level 1, then you got level 2 around. And after that, you didn't have any lawyers anywhere else. They were all around the courthouse. Because all the courts were there. And people didn't go out on Howard and south of town or whatever. They were all around the courthouse. Which made it really good for Christmas parties. Because we would all have Christmas parties around the courthouse. It was a big drunk, it was. But you'd go from office to office and you'd have alcohol. And if you got home, you were lucky. A lot of times you had to call a cab. But those were fun days. What else? No air conditioning, we talked about that. How did you get to be a judge? Well, I remember that when I was president of the Bar Association and Brooks McLemore resigned and went somewhere else, his slot was open. And I don't remember now, but the Bar Association had to give a recommendation to the governor. And so I called the Bar Association into session. And the association was going to recommend, I knew, Bobby Holt to be the new chancellor. Chancellor Morris heard about that, and Ray Blanton was the governor. Chancellor Morris was Ray Blanton's field representative when Mr. Blanton was in Congress. So he knew Governor Blanton pretty well. So he calls up Governor Blanton and says, Bar Association is going to make you a recommendation that you're supposed to follow it, and it ain't going to be me. You need to appoint me before 2 o'clock. I had called the meeting at 2 o'clock. Well, at noon, Governor Blanton appointed Chancellor Morris as chancellor. I just called off the meeting because there wasn't no need to have it. He wasn't required to go by the Bar Association, but it was a tradition. But anyway, he appointed Chancellor Morris, and so that's how he got to be appointed. There wasn't any election, anything like that. There wasn't any vetting. Nobody had to file this thick application with all your qualifications, to be chancellor and all of that. All you have to do is know one thing, that is the governor. That's all it took. Does anybody remember the Cold Alley tap room? Randy? You remember, Mary Jo, not that you were there a lot.
Right.
I never did see you there more than 20 times. But across from the courthouse, where now at City Hall, used to be First National Bank, which was an 8-9 story building. The only skyscraper in Jackson. And then a row of shoe stores and Woolworths. And so right down the middle of them, right across from the front door of the courthouse, Court Alley. And that's where the Court Alley tap room was. And that's where the lawyers could get a cold brew, lunch, whatever. So it's gone now. I forget who ran that. Who ran that? Everybody remember? All that crazy guy.
Yeah, and they had the big white house.
Yeah,
Oh, we should remember his name.
I can't think of it. I know who you're talking about.
Yeah.
Anyway, after a while, when they got ready to build a new city hall across from the courthouse, they imploded First National Bank. The only implosion that I've ever heard of in this area. I was there. I was there then.
Wow.
When? I was there that day. I was too. Were you there? Did you run after the dust started coming? Anyway, they imploded the First National Bank, and it was a sight to see. Everybody was all around gathering, watching it, and when the fireworks went off, but we forgot about the dust. When that sucker came down, we saw the light and we took off running west. And it was too bad about our cars because they were covered. Had to take something to get the dust off. But anyway, that was a fun day watching them implode the bank. How many people have ever heard of Buford Puster? Everybody. You lying. I know you've heard of it. Raise your hand. Met him. I met him too. He used to be, when he was sheriff down in Selma, he had his office in the basement, the courthouse. And so I had occasion every once in a while to run into him, and he was a big old guy. When he got to be famous, his lawyer was Lloyd Taylor, Lloyd's dad. And so I'm sure he's been in your office more than once.
Oh, yeah.
Oh, yeah.
He's been to the house. I mean,
Yeah.
Buford would come over. He was, I, for a time, when I was a kid, I thought he was related to me.
Thank you, uncle.
Yeah.
Oh, Buford. Anyway, some of us knew Buford before he got in that wreck, he got killed, but he was a big guy too. I mean, he was like 6'7", 6'5", 6'7". Built pretty good. Anyway, his movie was filmed partially in Chester County at the courthouse. They built that 3rd floor courtroom, and that's where some of the scenes were filmed in the movie. What was the name of the movie? I remember.
Walk and Talk.
Walk and Talk. And so, and Lloyd's daddy was in the movie. And I remember seeing him.
My legal bookcases are in the movie.
Really?
I was clerking for him and they liked them and they moved them from my office to his office. So they look good.
Yeah. So
Yeah,
when we,
too.
so we got connections.
Yep.
But I remember seeing that courtroom, and I've held court in that courtroom a lot. And I was also a defendant in that courtroom. One time when, you remember when that guy took a deposition at your office, and I forget what happened, but he got beat up.
Oh.
Then we all got arrested.
Part of the movie was filmed in Jackson.
Yeah, it sure was.
On the 45
Yeah, and one of my old girlfriends was in it.
Oh, really?
Can't remember her name. Joe Ridley, made fun, much time.
You're,
I'm good.
Yeah.
Well, I'm sorry. I'm sorry. I don't. Okay. All right. Thank you very much, everybody. We had a good time. You gonna give them a break?
now then we get a break this time.
Give 'em a break.
No. We got one more speaker. I'm gonna get the. Oh, yeah, I'm gonna get the PowerPoint back on. Okay, there's a clicker right there.
Is there any way to put this computer up on the screen?
No, I'm trying to find mine.
There's no way to unplug this.
I
one
couldn't
from-
find one because I tried to earlier.
Okay, that's fine.
Well,
Here. So.
You're good to go.
Thank you, Andy. Thank you, Mary Jo, for inviting me to be here today. If anybody needs to take a break, feel free to walk in and out anytime. I know that there's not one in the schedule, but I understand we've been sitting here a while, so take off. I wish that I had a little more time to prepare for this and get my PowerPoint like it needs to be. I stole this PowerPoint you'll see on the next page. I stole this from the judicial conference. So this is from lawyers in Nashville, fine lawyers who put together a great presentation, a great summary of the recent case law that I know nothing about. So I stole it and all that, but I do have one thing that I tried to get Andy to put my computer up on the stand. You guys can't read this, but I'll show you this picture. All right, this should have been the first page. Chancellor Butler, who all of you know is the godfather of just about everything. Especially family law and forms and orders. He gave me, thankfully, the Bible. And the Bible consists of, after you put the thumb drive in your computer, about 28,000 documents of everything he has acquired since he started, I guess, practicing law. I don't know, there's all kinds of stuff in there. But this picture that I just showed you is what should be up on the screen. I wish I could do it, but I'll read it to you. It's a sign outside of a building that said Psalm 628. Pray for those who mistreat you. Now we ask you to pray for Chancellor James Butler. On January 20th, Chancellor James Butler placed Mr. Denton in Henderson County Jail for contempt of court. And Mr. Denton's family went and bought him a sign, put it on the courthouse wall and said, pray for those who mistreat you, and Chancellor Butler just did that for me. I wish y'all could see it. So that was it.
Randall Denton.
There you go. That's in the archives. I didn't see it. I couldn't read his name because of the phone, but Mr. Randall Denton asked for prayers for Chancellor Butler's day, for him and all those others who've been administrated by him.
Well, Bastard wasn't in jail. We put him there, and he was good friends with the sheriff, and the sheriff immediately made him a trustee and let him go home.
Oh, my goodness. That's
I
it.
didn't have any sympathy for Randall.
and that's not the first time he's had a public sign up against
Okay, that's on it.
him. Two more like, just like that.
That's on the picture I've got in the archive. It's saved on my desktop right now. I've got something to strive for. First sign, and I'm gonna send a picture of it and set it up.
When you get one, that'll be a sign that you have arrived.
There's nothing. As long as you know I am in here. So, all the things I'm about to tell you, I honestly don't have any clue about right now. I'm learning. I've been here 90 days. And Michelle knows that at Rainy Kaiser, I never so much as read a family law case for the past 25 years. So anyway, it's been a real education. It's been an eye opener, and bless y'all's heart. Okay. I mean, you guys that have been doing this for as long as I was handling car wrecks, I mean, bless your heart. There is a lot of pain and agony in this world. It just really is. And y'all are right in the middle of it now. But not all of it's pain and agony. I thought about this the first few days I was chancellor. I thought, well, I'm just making people mad all the time. My job is just to dish out pain and misery. But then I signed an uncontested divorce that just came in and I signed, I thought, you know what, when these folks get this document, they're probably gonna be pretty happy. So about half my time is spent making people happy, because they're so glad to get away from one another. But, anyway, well, thank you for asking me to be here. I'll go through this, and I do expect this group to help teach me and answer all the questions that get asked. All this is the case law update. Thank you for giving me the easy part that I could just go and steal other lawyers' work. So, let me see if I can get this clicker to work. Which button is it that makes it?
The arrow going this way. Try it now. There we go.
Okay, there we go. So these good folks, Gregory Smith, Brent Blackford, and Ann Brown, they are the ones that did this presentation. Brent's actually from Ripley. He's a good guy, so I appreciate them doing that. All right, so we'll start off. And I'm gonna try to keep up with all this because this is a different way. All right, all the fun cases, most of the important ones. That's probably true. You guys know all about this. All right, Himes case, alimony modification. So this was a case in which the husband sought to terminate his alimony because he had retired. His income had obviously gone down. The original amount was $5,000 per month. The trial court said ongoing support at $1,500 per month. So even though the guy had retired, he had some benefits. He had some ability to pay. The wife had, she acknowledged that she had some earning capacity, but she hadn't worked in years. She was 62 years old, had few transferable job skills, so the court didn't even impute any income to her, but decided the husband had the ability to continue to pay $1,500. And there was proof that both parties were about to be in line for an inheritance. Actually, the wife in this case was going to get $1,500 per month alimony. 62 years old. There was a $3.2 million case in probate from her aunt that she was going to get at least $400,000 from within the next year. But the court still found that she had a need despite that because she didn't have any income. So the court kind of disregarded the inheritance that the wife was going to get. But that also was offset somewhat that the husband was in line for about a $300,000 inheritance as well within the next several years. The person had not died yet, but he was still in the will. So Court of Appeals went back, made some minor changes to the trial court's ruling, but ultimately affirmed that modification of $1,500 per month after retirement. All right, go exploring. Oh, and that's the one I just did. Okay. Now we got the Smith case. Smith involved a case in which the wife was awarded an interest in assets built by the husband during a lengthy separation. So the court divided the estate equally, even though the husband said, "Hey, we've been separated for years. I've been the one putting all of the effort into building these separate assets, and I deserve a bigger share of it." The court said, "No, you were still married while you were doing this, and so we're going to assume that it's marital property." The court divided it equally. But the court did not award the wife her attorney's fees because they did give him some credit. They said he's got a substantial debt burden. He put all this effort into building the assets while the separation was going on. So the court at least didn't make him pay the wife's attorney's fees. The Court of Appeals upheld that, said that it was fair and equitable. And that's the thing, you know, obviously, all of you already know this, and I did too, but you know, the Chancery Court's a court of equity, you know. I told people when I've encouraged folks, or if they come with their lawyers to get a trial date for the divorce case, they'll be sitting there in court. I'll say, okay, we'll set your case for trial in 120 days or whatever, but I'm gonna order you to mediation. And so the parties are sitting there looking at me, and I said, you guys need to take mediation seriously. So all you mediators in the room, I'm trying to help you out. I look at the parties and I say, you need to take this seriously because that's gonna be your last chance for you to have any control whatsoever over what happens. After that, you're about to give me your house, your kids, your dog, your china cabinet, or whatever, and I'm gonna decide where to go. So please take mediation seriously, and you guys go participate in that before you come to trial. So that's what all these cases generally are about. Obviously, there's never a one size fits all on any of them. All right, let's go to child support. All right, in this case, this is, let me see. Yeah, joint decision making. I thought this was interesting, and Chancellor Butler, you may have something to weigh in on this as far as what your opinion of this is. The mother made $16,000 a year, the husband made $115,000 a year. The mother, even though they had joint decision-making under the MDA, decides to enroll the child in a private school in Chattanooga and asks the husband to pay for it. The husband says, no, we've got joint decision-making authority. I don't want to fund our child going to private school. They can go to public school. But the court said, well, if that's more of a child support issue, so we'll modify it, and husband, you're going to pay for it. That doesn't sound very joint to me, but ultimately, the reality is that somebody's got to break the tie, and that's going to be the court. But as far as I've not run across obviously yet a case in which we've got parents fighting over sending the kids to private school versus public school. But this was kind of interesting to me as a new judge and new family law participant, that parties with joint decision making, one can effectively force the other spouse to pay for a private school education if the paying spouse objects to it. And anybody have any thoughts on that? Have y'all had any cases involving private school? I mean, we've got USJ and JCS, Trinity, Sacred Heart around here, so we do have private school come up some. Anybody ever run across a case like this and have any insight? Any thoughts? I haven't read this opinion in detail, but I have a hard time seeing the equity in this. You have a public school system that's available, and
$115,000 a year is not very much for Baylor's tuition. I don't know what their tuition is, but it's high.
well, that's what I'm saying.
Well, the problem is that we don't know why the court found it was in the child's best interest. This might be a child who needs medical or,
I did skim the opinion, there was none of that proof for that.
Okay.
It was just a straight mother decided to enroll them. The kid was already enrolled, and she petitioned for the court to have the husband pay for it, and the court went along with it.
Well, was he enrolled there for 10 years? He only had 2 years left.
Yeah, this is brand new.
The county's a big county, so there's lots of education
opportunities. I don't know, there's gonna have to be something, I think, I would think that a judge would need something, Mary Jo, like you point out, that there's gotta be either the kid's been there the whole time and they previously agreed to it and all that kind of thing, or something, but I don't remember that being in the summary of this opinion, that I read, and actually, give me just a second, I may be able to find some more of those facts, because, I have the handy dandy outline that you guys may or may not have. Now this was a new enrollment. This was just a new enrollment. It just said that it was in the child's best interest. And then they tagged the father with 50% of the tuition. So, that it wasn't prohibited by the parenting plan, they tagged him with 50% of the tuition on a new enrollment by finding it was in the child's best interest, but there's no analysis about the unread and how it got it.
well, and even the Court of Appeals may not have put in, everything that the lower court found.
That's
But I imagine that there was a good reason for it, because I agree, I think we probably all agree with you that financially, they should be able to. And, so there needs to be more than just, I want my child to be in private school.
Yeah, I agree. I was wondering if anybody had seen that. All right, and then this is another case on the private school limitations. The parties divorced and had agreed that children would attend private school until a certain school was no longer an option, at which time the private school obligation would cease. I suppose that's kind of like Trinity used to be. Trinity used to be through, I think, 6th grade, and then they would have to go somewhere else. Now, obviously, they built and got to high school. But then later on, even after that particular school ceased, then the court ended up ordering the father to pay for continued private school education at another school that he objected to. But that's just one of those things. So again, I haven't read the opinion in detail, but there must have been something there that convinced the court of that, but I'm not sure what that. All right, let's see. Insurance to secure support. This issue obviously comes up. But this one was interesting because at the time of the divorce, each party was ordered to maintain a $300,000 policy on each other for the payment of child support to the children. The father did so for a while. Mother never even got the policy. So the father had the policy payable to the children for some period of time. Mother never even got her policy at all. The child support for the father was reduced twice, but then he left his entire $500,000 policy to his new wife. Okay, so his wife had never bought a policy at all. He was ordered for $300,000, but he left it to the new wife. Well, he passed away. And upon the father's death, the two ladies started litigating. And so the court found that even though the wife did not fulfill her end of the bargain, that the mother was actually entitled to the payment of the life insurance as opposed to the new wife. I'm not sure whether she got the 300,000 or the full 500,000, but she got the.
It'll have to be 300,000.
Probably so. But the mother, the court did enforce the contractual agreement in the MDA for the father to maintain insurance despite the mother's initial breach. But the mother, the ex-wife, petitioned for payment of attorney's fees for litigating against the new wife, but there was nothing in the contract that provided for that, not against the new wife. So they didn't get their fee. It was just a standard contract case at that point. Let's see. All right, this one's kind of interesting. This is a case involving an NBA basketball player. I'm assuming that this is out of Memphis. So the NBA basketball player was no longer in the NBA. And so the wife said that the NBA player was willfully underemployed. But the wife never provided any evidence to the trial court as to whether the guy could continue playing, what his prospects were, whether he could go to Europe or anything like that. The wife just said, my husband's been an NBA player. I've been making all this money. Now he's out of the NBA. Say that he should be tagged with the NBA salary. The court said, no, you got to come up with something showing why. Maybe he was injured or whatever, but there's nothing in the opinion that relates to that. So the mother spent $14,000 in legal fees trying to litigate this issue and came away with nothing. She asked the court to award her fees for trying to prove that. Since she didn't prove anything, she didn't get anything. So I think that's pretty standard. There's nothing new particularly in that case. It's just interesting because it involved a professional basketball player. All right, we got military pension and child support. All right, according to the summary, there's a lot to unpack in the case. Most of it is fairly easy. The division of the pension and the property division not considered in the calculation of child support. Assets distributed as marital property will not be considered as income for child support or alimony purposes, except to the extent that asset will create additional income after the divorce. So that was an issue in this case that wasn't too hard for the Court of Appeals to take care of. In this case, I don't know what the Hague lawsuit that the father finance involved, but he spent $130,000 of the marital assets on legal fees to prosecute a Hague lawsuit. Don't know what that was. Now, what's interesting is the wife said that the husband had dissipated those assets, dissipated $130,000, spent it for a non-marital purpose, willfully in order to decrease the marital estate. But the trial court found it wasn't dissipated. We're just gonna tag him in my equitable distribution and equitably divide and give the wife a bigger percentage of the estate, which ultimately was affirmed by the Court of Appeals. So, the trial court did the wife a favor by not accepting her argument on dissipation, because you don't have that issue as to whether it was willful, wasteful, all that kind of thing. They put on the proof about all that, but the court just said, we're going to set all that aside. I'm just going to make a 75-25 distribution of the marital estate, and that'll take care of it all. So that's one of those things that the lawyer doesn't protest too much, but the trial court and the Court of Appeals found right. You ever done that, Judge?
Well, it seems to me like it's the same thing. Dissipation or adding it back, it's the same thing. It still got back into the list of assets.
That's right. They didn't create an appealable issue though with all the dissipation part that made the case plan.
That's what they said.
Yeah.
I think it should be a appealable issue.
Yeah. All right.
Money he doesn't have.
Yeah. Right. All right, this case, Tigard, the modification of a deviation, this case was from, 2021. Wife filed a petition for contempt against the father. The Court of Appeals reversed and remanded for a new hearing. But fees were still awarded to the wife. So the trial court found the father in contempt, awarded attorney's fees to the wife. The Court of Appeals overturned that filing or that finding, but still affirmed the award of attorney's fees to the wife because of the particular language of the verbal dissolution agreement. Because that agreement didn't require that the party seeking enforcement to be the prevailing party, just that it was reasonably necessary to institute legal proceedings to secure enforcement of the MDA. Now, they didn't find him in contempt, so I don't know if any money changed hands or what happened, but the court said, okay, even though you weren't the prevailing party, the MDA doesn't require that. It just, if it was reasonably necessary for you to take him to court to enforce your obligation, you're still entitled to the fees. It was kind of interesting in this one. This is talking about deviation. The initial award of child support had contained a deviation already, so the initial support wasn't done pursuant to the guidelines. And so the fathers thought to modify the support and eliminate the deviation. I guess it's been deviated up to begin with above the guidelines. The trial court initially agreed with the dad and said, okay, we're going to change the deviation, I guess go to the guideline amount. But then on Rule 59, motion to alter or amend, the court reversed itself and said, no, we're going to leave the deviation in place. The Court of Appeals said that once the trial court has deviated from the guidelines, the father would have to prove that the circumstances have changed from that deviation. It's not an original just default to the guidelines and then go from there. You got to start from the deviated facts and see if those have changed. And apparently that's what the trial court found on the motion to alter or amend. That yeah, you're right. We don't start out on this motion for deviation from an initially deviated child support guideline. We don't default to the guideline amount. We default to, okay, what were the circumstances that caused the deviation? Did those change? The court found they had not, and that finding was affirmed. All right, if anybody has any questions about any of this, and I'm here to be educated even more than y'all are, please speak up and let me know, and somebody in the room will answer it for you. So I can give you a decision, but I can't give you a summary of what the law is right now. All right, this case, Stanley dealt with attorney's fees and winning. The father filed an action to modify custody. The mother filed a counter petition to modify child support. So we got two separate issues filed by two separate parties. At the end of the day, the trial court said, okay, we will modify custody as the father asked. We will modify child support as the mother asked, and I'm going to award you each your attorney's fees. So the mother appealed. She apparently didn't like that arrangement, even though that's exactly what she asked for. But the Court of Appeals affirmed that. Those cross actions. So I don't know. I don't know which is which. The father may have spent more money than the mother and had a higher price lawyer. I don't know, but the mother didn't like the outcome of that. But that certainly is a possible outcome. All right, our favorite topic: civil procedure and evidence. When my friend Bradley Owens got elected general sessions judge in Gibson County, he said, "I thank God I've thrown away my civil procedure book." But I still have to use it. He still got his evidence book, but he threw away civil procedure. All right, this is where I get in trouble. All right, I may get in trouble at some point. It's fair to resolve issues and facts. So this is what this judge did, and I know better than this, and I hope you never catch me doing it. Instead of the judge creating one ruling, coming up with a ruling or putting something together, he got proposed findings of fact and conclusion of law from each of the parties, went through with a black marker and redacted out the parts he didn't like, put both up, stapled them together, and sent it up. Yeah. So the Court of Appeals said, no, you can't do that. So they sent it back and said, you judge have to come up with one cohesive ruling instead of just marking out what you don't like about these other parties' findings and sending it up here. And the Court of Appeals asked for a true summation of the trial court's proceedings. Now, whether my notes will ever provide a true summation of what happens, if you haven't got a court reporter and I write it down, I'm right. So, whether it's true or not, I don't know, but, I will do my best. I will try to never do what this judge did, however.
Well, isn't this a statement of the evidence because there was no court report? I think that's what this is about. They didn't have a court
Yeah,
report.
this is the statement of that. That's right.
And
Yeah.
so both of the lawyers wrote a statement of the evidence, and then the judge was supposed to approve something. And
Either,
then did this instead.
that's right.
So there was no court reporter. If there's no court reporter,
That's
this is
right.
what happens.
The judge would have been better off if they could have somehow
Cut and paste.
gotten both of them in Word or something, and they put in a few transitions and some paragraph breaks and something like that. And, you know, I can imagine that it was a pretty big transition. Plaintiff's lawyer on this side, defense lawyer on this side, you marked it all out and they played them together. The Court of Appeals didn't do that. Even I know that. So. All right. Rule 10B, this is when you're wanting to kick the judge off. I don't know if you guys can read this or not in your materials or read that on the screen. It says at the top, I've been informed by my bailiff and my wife and a few of my colleagues on the bench and a number of lawyers who don't fill me with deep despair every time they speak, that I probably shouldn't decide the outcome of this case based on a simple coin toss. Second one says, as I am to be denied that one small mercy, I must find a way to resolve this problem in a way that preserves the integrity of this court. To that end, I'm going to call a recess, drink the 2 bottles of scotch I have hidden in my desk, and God willing, get myself disbarred by noon. I haven't gotten that grizzled yet, but I can see it coming. So if I get to that point, you know, maybe somebody will take a vacation. All right, so this was the case, this Atkins case from 2021 was a case in which the one of the parties tried to get set aside and mediated and negotiated settlement order. And so during that, one of the parties asked the court to recuse itself, and the judge recused himself. After 3 years of litigation, and this issue has been around for 3 years, and then they filed a Rule 10B motion. And then after they argued, I guess, another motion right before filing the 10B recusal motion, the parties argued a pending motion. Well, the court orally ruled from the bench, told the parties what the court was going to do. The next day, they filed a 10B motion. And then the court reduced its ruling to writing. So they tried to say that the judge should not have reduced that to writing because he entered an order after the 10B recusal motion was filed. Court of Appeal said, no, he'd already listened to the judge had already given you what he was going to do. You knew what the order was going to be. The written order was just a memorialization of what the court had already ordered, so the court could do that. In other words, it looks like that these folks found out that it wasn't going their way, went to the office and filed this recusal motion as soon as they could to try to prevent that order from going down. Didn't work.
I bet it was fun that we went to court that judge court that time.
Yeah, you know, that's some sharp lawyering. Yeah. Say, no, Judge, you can't write that order down, even though I know what you're gonna do, and you told us you can't write that order down, and we're gonna get you out of here. So I'm sure that it didn't go all that well. But you know, some of these family law cases, I do give them an A for creativity, no doubt. All right, Pagliara case in 2022, Rule 12.026 fees. Now, I'm assuming you guys probably do this in family law some, I don't know, but this was a big deal when it came out in my world, in the personal injury world. The 12.026, you get to recover your fees if you get a case kicked out on a motion to dismiss. So you have a case filed and you file against your client. You file a Rule 12.026 motion to dismiss. If you win that and you ask for your fees, that's the point of this case. The lawyers did not ask for the fees, but if you win that and you put in your motion that you want your attorney's fees reimbursed, the other party has to pay you up to $10,000 in attorney's fees, because essentially it's kind of a frivolous action sort of thing the legislature came up with. if you can't get past a motion to dismiss, you can't even state a prima facie case, then the General Assembly a few years ago said, you know, we're gonna let the defendants recover their fees, but you've got to ask for it. So I don't know if this comes up very often in the domestic world, but you know, you may run across a personal injury case or a breach of contract case, something like that. Can be a pretty potent weapon if you've got a case that doesn't have any meat to it at all, and you know that you can win it. But 12.026, you can recover your fees, but put in your motion that you ask for attorney's fees incurred in defending the action. All right. Next, Rule 59, motions alter or amend. This was a Rule 59 motion that the wife filed based on the court's failure to divide up the husband's military retirement account. And what was interesting about this case is that the court said, you know what, you're right. I completely forgot, as the judge, I forgot to do that. And so even though the wife did not prove any fraud, duress, misrepresentation of fact, anything like that, the court said, you know what, you're right. You caught me. I didn't do my job. Now I'm going to alter or amend my judgment. The Court of Appeals said that's fine. Even though she didn't prove fraud, duress, misrepresentation, anything like that, the trial court realized that it failed to do what its responsibility under the statute, and so the trial court appropriately corrected that. I assume the trial court would probably do this sua sponte as well, and the Court of Appeals would say it's fine. When a judge catches and acknowledges their own error, then that's going to be fine. So this case made me think about me and getting into my new job and doing into my new world. All right. Some of you are litigating cases in front of me now. You will start getting the orders in. If I forget to do something, if I just missed it, file a motion to alter or amend before you file an appeal, and I'll see if I can fix it. You know, now, if you just don't like how I rule, you don't like the money you got or whatever, don't worry about it. Go ahead and file your appeal. All right. But if I have completely forgotten to do something, overlooked something, you know, really misapplied a law or done something unconstitutional, whatever I've done to you, if it's a legal issue, file a motion to alter or amend in my court. I'll take a look at it and try to fix it. Because I don't mind getting overturned on appeal. I just don't want them to come back. You know, I want to get as close as I can to where the Court of Appeals, if they find I did something wrong, they can write their own opinion, because I don't want to see it. I've already said what I think about it. You know what I mean, Judge?
I agree.
Yeah. I figured. I've already given you what I thought.
I like remand.
Yeah, I don't need it back again. So, you know, I'm not going to be offended at all at any Rule 59 motion, regardless if you don't like what I did. If you feel like you want to give me another shot, I'll do it. But unless there's some legal thing that I've missed, you're probably not going to get anywhere with that. You might as well just file your appeal. I'm not going to say that in every case. That's not a bright line rule. Just that's this case reminded me of that. All right, the Couch case, Rule 60, and this is the Rule 60 motion to set it aside based upon numerous different factors. So 4 years after the divorce, they filed a Rule 60 motion. That's certainly one problem. So to begin with, the trial court originally granted this motion. A Rule 60 motion filed 4 years after the divorce was granted. But then there was a after hearing proof, the trial court ultimately reversed itself, declined to modify the previous agreement. So the Court of Appeals affirmed that denial of relief under Rule 60 and affirmed an attorney's fee award to the wife. And what had happened was the wife filed a petition under Rule 60 asking that this agreement be set aside. And the court said, originally said, okay, I'm going to, then the court reversed itself and said, I'm not going to. And wife, you know what, I'm going to have the husband, I'm going to order the husband to pay your attorney's fees for going through all this trouble. Does that sound right to anybody? It doesn't to me, but that's what the trial court did. And the Court of Appeals ultimately affirmed everything, including the attorney fee award, because the attorney for the husband didn't raise it or argue it in their brief. They just put in their closing paragraph, they didn't cite any law or say anything about why that was inequitable or because she lost, she shouldn't be awarded her attorney's fees. So neither party raised the issue in the statement of issues in their brief, but just argued it in the conclusion. And so this is the drafters of the PowerPoint that I borrowed this from said practice step. The Court of Appeals is not there to construct issues. The party or his or her attorney is responsible for that. I think that's more and more true. I was talking to Judge Peoples, Claiborne Peoples at a judicial conference not long ago. He said, you know, when I first started, when I was first elected to be a trial judge, the Court of Appeals judges told me they felt like it was their job to affirm a trial court, to try to find ways to affirm the trial court. I don't think the Court of Appeals looks at it that way anymore. Based on the opinions that I see, I think that the Court of Appeals has their own thing. You know, they are, I think they sometimes look for errors to not help out a trial judge. And so that's certainly, this is a reminder of that, and it made me think of that when I was looking at it. I do not think the Court of Appeals bends over backwards for trial judges these days. And I don't think the Court of Appeals bends over backwards for attorneys at all, for sure. So keep that in mind. All right, here's one that I really, I'm not experienced enough to know how this would even work, and I did not read this opinion, but one day I'm going to, because this is somewhat fascinating for me, given what I know about termination cases. This is a parental termination of rights case that was decided on summary judgment. Have y'all ever had that happen? Ever heard of it happen?
There's a case somewhere that says that kind of case should never be resolved on summary judgment. Maybe I guess it's overruled.
Well, you know, it's kind of like workers' comp, you know, for a long time, courts thought that you couldn't resolve a workers' comp case on summary judgment, and then the court said, we don't see any reason why, and that's essentially what this court said. This is almost the direct quote from that old workers' comp case. We're unaware of any authority that precludes the use of summary judgment in termination of parental rights. So that's interesting, and that's why I'm gonna read this case, Judge, because I would have thought that there would have been a case out there somewhere that actually said you cannot use summary judgment in these cases, but apparently it was not.
This Court of Appeals.
Yes. Court of Appeals. It's on page 20. I don't know, Andy, did you send the handout? If you look at the top, up here it says proceedings page 20. The page 20 correlates to the written outline. Now, it doesn't correlate to the number at the top of your PDF, your Adobe. This is page 20. Let me see, can determination. And in your materials, you'll say it says the Court of Appeals said, we begin by noting that summary judgments are proper in virtually any civil case that can be resolved on the basis of legal issues alone. We are unaware of any authority that precludes the use of summary judgment in termination of parental rights proceedings. To the contrary, this court affirmed the use of summary judgment process in a termination proceeding in a 02 case. There's a 2002 unreported opinion that they cite, Judge, that they allowed that, because the undisputed material facts establish the ground for determination of the rights. So there you go. I had not expected that would be something that I would ever say would be a summary judgment termination case, but I suppose they're out there. Maybe it's like a unicorn.
They raise a question, if you can do it in parental termination cases, why can't you do it in child custody cases?
That's exactly what the court said.
I'm sure you'd love to get a stack of those motions.
Yeah. Hey, they hired me to make a decision, though, Lord. I mean, that's what I do. I get it. I'm gonna make a decision, and then it's up to you guys to figure out if you want to keep litigating. So, next case, Attorney C. Lane. the wife had been awarded attorney's fees during a divorce. The husband subsequently died. After the husband's death, the wife's attorneys filed, creditors' liens against the real property for enforcement of the wife's attorney fee award, and the Court of Appeals upheld that. There was no problem with it.
Well, she murdered him. That was my case. She really shouldn't have got attorney's fees.
That was your
She
case.
murdered.
She murdered her husband.
Yeah.
Got attorney's fees, and they filed a lien on his property, and
I believe that's the same case, yeah.
Bronco 2021.
Yeah, very job.
Yeah.
We don't have the last two.
And
Wow.
she had been in our office. She tried to hire me and she was nuts. Yeah, the lady with the dog. Yeah. Yeah,
How about that?
She's still in prison, I think.
yeah, well, hopefully. He really is
She
nuts.
was crazy.
Crazy, crazy.
I can't remember, I know Andrew was involved in that.
Everybody was involved.
We had some involvement in some way.
Yeah.
I think that was me.
Like I said, bless y'all's heart. It's the kind of stuff I'm talking.
You don't see that current case.
That's right. All right, next one, still on, attorney's fees. Trial court refused to award fees to wife in a post, divorce proceeding, because the court found that the husband's actions were not willful. But the Court of Appeals said there was no willfulness component in the party's MDA, because it said the defaulting party should be required to pay fees to the non-defaulting party. You incur fees and expenses to divorce compliance. So the willfulness wasn't a standard. Watch out for that in your MDAs, I suppose, or in whatever agreements you come to, because the attorney's fee shifting can be a little bit lower standard than what your clients may be expecting. Next was the juvenile court issue. This one was sent back because there was a juvenile magistrate that made a decision. The losing party demanded a hearing from the juvenile court judge. The juvenile court judge said, okay, you demanded a hearing, but we'll just hear this on briefs and affidavits. I don't need for us to come in. And the Court of Appeals said, no, once the party has demanded a hearing, judge, you've got to give it to them. Defamation. All right, this one was just kind of interesting just because it's fun. A guy and his wife got divorced. Several years later, the wife decided to remarry, and so at that point, the husband filed a declaration or filed a complaint against the wife, saying that our divorce was never final and you're now a bigamist. And so then the wife filed a defamation action against her ex-husband for calling her a bigamist, but the ex-husband called her a bigamist in the course of a legal proceeding, which is privileged. So it was his allegation that she was a bigamist was relevant to his allegation that they were still married, and so the court let him off the hook. That was an absolute defense. All right, interest rates. In federal court, the interest rates float on judgments, but not in Tennessee state court. The interest rate that's in effect on the date of your judgment governs that, regardless of what the interest rates do going forward. And you have to look on the website to find what the most recent Federal Reserve rate was. I think it's changed every 6 months. Is that right? So you got to find what Federal Reserve rate applies to your judgment, and then it sticks. It doesn't float up and down.
And it's on the AOC's website.
There you go. I knew it was. I forgot which
That's
website.
really easy to find.
Yeah, I forgot which website it was on, but I knew that it wasn't too difficult.
Yeah.
So. All right, Rule 59 again. This case started in 2003 as a petition for legal separation, became a divorce action in 2015, was tried in 2020. Had all kinds of issues in it, but the Court of Appeals pointed out you cannot argue the intentions of the parties without proof of those intentions. If you want to retain the appreciation on separate retirement benefits, you have to prove that appreciation. And transmutation from separate property to marital property does happen, especially in a long marriage and substantial contributions by the other party and much more. I have not read this opinion, but the authors of our PowerPoint today said that the award for patience goes to Judges Melissa Blevins Willis and Kenny Armstrong for dealing with these people. All right, statute of limitations and MDAs, the parties divorced in 05 and 05. The wife obtained knowledge that the husband had not gotten a life insurance policy that was required by the MDA. So the wife sued the husband in 2019, seeking to enforce that in a breach of contract. The trial court found that the breach occurred in 2016 because it was a continuing operation or a continuing obligation. But the Court of Appeals said that the cause of action actually occurred in 2005 because the contract was to be read as a whole and was not severable. The life insurance provision is not severable from the divorce decree dividing the parties' property. Now, the guy did have some excuses why he hadn't done that. He had open heart surgery soon after the divorce. He was actually uninsurable from a life insurance standpoint, but he got out of it on Court of Appeals or on statute of limitations grounds regardless. And I am going faster through this. I'm never going to get through all this, and I knew I wouldn't, but I've got 5 more minutes, so we'll go through them as they come. Fees on appeal. The appellee in this case was granted $123,295 in fees on appeal, but it got reversed for the payment of $458 in costs. Because the Court of Appeals had remanded the case to the trial court to determine the fees that should be awarded to the wife. The trial court apparently found $123,295. And as part of that, the court also assessed the cost of $458 to the appellee, and the appellee did not like that, so took it back to the Court of Appeals to get it reversed on that, because the initial remand only said deal with the issue of fees and not costs. So I know you guys have never seen anybody that does things for spite. That would be this guy. All right, expert testimony. I do kind of know something about this. This was also in my world. The appellant, in this case, complained that the court relied upon an expert that had relied upon other experts' opinions to form their own opinion. The court said that's fine. If you have an economist that relies upon the opinions of 2 other economists in order to come up with their opinion, they are not simply generally parroting what the other economists are doing. They are using that to form their opinion. All of that information is admissible. That is perfectly reasonable, but apparently the mother's lawyer did not know any of that. Because this was a physician that looked at the records of other physicians and rendered their opinion based upon, or rendered their opinion as to the health condition based upon all the information, including other opinions, which is perfectly valid, but apparently people still live here. Let's see, sexually transmitted disease. This one, the funny, I guess not the funny part, but the interesting part about this case is the last bullet point. The wife sued the husband for transmitting a sexually transmitted disease to her because she was positive, tested the husband, he's negative. All right. She sued him, and so she's anonymous at the Court of Appeals, but they named the guy. Well, I guess at least he's negative, but still. I don't have an answer to that question, but I guess that's the way that the case was styled when it was filed in the trial court. The trial court entered an order and left the guy's name out there, and he didn't do anything. But now he's in a Court of Appeals being accused of having HIV and HSV. All right. Let's see. Culberson, Lucas H. I'm sorry. This is a psychological records case. The court said that psychological records are essentially on par with attorney-client privilege records and would not let them out. There are some ways to get to psychological records under that statute 37-1-411. It's been a long time since I've used it. I did use that some in my former life. And you just have to meet certain requirements and you can get to those records. But apparently in this case, they did not follow the statutory requirements. All right. We got about 2 minutes left. I'll end on this one because this one's pretty good. You guys may have read about this in TVA Today or some newsletter. This is the one where the lawyer, and I can't remember what part of Tennessee he was in, but a lady was complaining about her ex-husband on Facebook. And an attorney posted comments in response, advising her on how to escalate the use of force, and then ultimately told her how she could murder him and get away with it. Oh, now this is not in Messenger, this is on Facebook, all right? And actually told her that, but at the end of it said, please delete this entire thread because premeditation could be used against you at trial if you follow my advice. Did y'all hear about that?
Yep.
Yeah. Okay, so the BPR suspended the guy for 60 days, but then the Supreme Court got hold of it and suspended it for a year. They said, BPR, you didn't go far enough because this is a lawyer, a member of the bar of the state of Tennessee, counseling someone on public social media forum on how to murder somebody, get away with it, and then hide the evidence of it. So they suspended it for a year. So I don't expect anyone in this room will ever get even close to that, but do not give anybody, your clients or whoever, advice as to how to murder somebody, get away with it on a public, on a private written form. All right. Well, thank you all for being kind to me today. These materials are much better than I could have ever put together. They, I certainly, commend you to them, and, I'm going to be using them going forward. The materials are much better than the presenter that you ended up with at 4:30 on a Friday afternoon. But thank you all. Look forward to y'all having me.
All right, everybody, thank you all for coming. Make sure you get the forms for your CLE credit to Katrina on your way out so you can get your CLE credit. You're participating remotely. You either got a form. If you didn't get a form through your email, let me know. But see y'all next year.